Good morning, everybody. Welcome back. Hope you all had a fantastic weekend. I had big aspirations for this weekend, and boy, really didn't happen. I had told you guys at the end of the week, I got these ideas for Substack. Keep an eye on it. I never had a chance to get to it. I'm going to show you why. I had to do actual legal work this weekend, which is a rare thing these days. But no, 2 years almost out of contract. With the state, you still gotta do things on your criminal cases. So this year, I had to wrap up this weekend. So that took up a big chunk of my time. But then the other thing that happened was actually a wonderful thing. The irrigation water finally came on, so got to go get my my whole sprinkler system going, which kind of like with the lawnmower, it's just things sit all winter and then you go turn them on. There's always a billion things you got to fix, but got that taken care of. So a lot of things running a little bit more smoothly on the home front, but meant this weekend was a little bit hectic, but hey, here we are. This trial waits for no person. Judge Cannone was determined to get it done when she said it was going to get done. And so here we are. Half a day of testimony. Don't know who we're going to get. I have a theory. Okay, here's my theory. I don't think that Hank is completely unfamiliar with the doctrine of primacy and recency, right? This is a kind of standard wisdom for how you structure a trial and an argument and so forth. People remember the first thing they heard and the last thing they heard. So that's where you put the stuff you want them to pay attention to. The things you don't want them to pay attention to so much, you bury that in the middle. So my suspicion here, my theory is that since Hank's case is really, it's just, I hit him 2.0, right? Reprise. But he did that head fake in his opening to make it sound like it's fact, science, and data. It's not actually fact, science, and data. He's going to bury the fact, science, and data in the middle. So that's my suspicion. We might be starting to head in the direction of the facts, science, and data portion of Mr. Brennan's case. Guess we'll have to see. I don't know where we're going to get, but half a day of testimony, and then we get the Crash Daddies. Then we get this voir dire that isn't really a voir dire, but seemingly just going to be accusing the Crash Daddies of, communicating behind the scenes with the defense counsel about their opinions and then lying about it, saying what they think about that and about that accusation. Of course, they were compelled by the judge to produce massive volume of stuff all related to their work in the case of Commonwealth versus Karen Reed. They are almost certainly going to interpret that as just since I was hired by the defense in this particular case, not all the stuff we did for the FBI, because that wasn't for the Commonwealth's case, and because the court already knows we're under a non-disclosure requirement. We can't disclose the work and the communications and so forth that we had with the FBI. So probably going to be interpreted narrowly what they produce. We'll see if that satisfies the judge. But I've been saying, guys, she really seems to be looking for a reason to have a problem with ARCCA. So I'm very excited. That's definitely the portion of the hearing today that I am most excited about, is getting them on the record. See what they think. What do they make of these accusations of wrongdoing and shenanigans and so forth? Well, it was a very busy weekend as well in the case. Not the case. The case, of course, the trial is recessed, waiting to come back Monday. But information out, new things out. So we'll take the opportunity to share a couple of those, starting with The Rock. The Rock. So this came out. This came out. Some photos that were taken at 34 Fairview during the jury view. Apparently, this rock is just there outside by the front curb, the Albert rock. So somebody snapped this photograph. Now, of course, doesn't look like the jurors are here yet, but what do we think of this? Do people think this is sus? Do people think this is suggestive? Are we going to have a whole hearing about this? I'm not sure what to make of it. So first off, is there an innocent explanation? Absolutely. I mean, first off, I don't see the jury here in this picture, so I'm not sure that the jury even saw this rock. If it was just kind of there to guide people. They know a lot of people are going to be showing up for this view. There's going to be press there. There's going to be YouTubers there, all that type of thing. And so certainly possible. We just put this rock out there so people know, here's the right place. And then, somebody removes it before the jury gets there. It's possible. It's just, I don't know that this is what happened. I'm just saying there's a possible, non-nefarious explanation for it. But there is a possible nefarious explanation for it too, isn't it? That we just want to have this out there. Nobody's called the jury's attention to it. Nobody's trying to say, oh, jury, look here, this rock is what caused John's head injuries. Nobody did that, but it's planting a little seed, isn't it? They might just happen to see that there and think, oh, there could have been a rock. Or it's just one of those things that gets in your memory and then, it gets distorted. Wires get crossed. You pull it out the wrong time. Maybe you misremember what it was. Example of that last week when I was talking about the retrograde extrapolation and I'm talking about Cornelius Harris. I had somebody text me afterwards going, the guy who testified about retrograde extrapolation in the first trial was Nicholas Roberts. And I went, oh you're right. You're right. So where on earth, where did Cornelius Harris come from? And I'm just kind of baffled for a minute, like of all things to come up with, where did that come from? And it finally came to me. That was a witness from Det Be Heard. He was a guy who, he had to babysit Amber Heard at Coachella, and he also had to go and bribe a homeless man to get Johnny Depp's phone back after Amber had thrown it out of the window. So that was his Cornelius Harrell. And somehow, that got crossed in my mind. Those kinds of things can happen. So the jury can be sitting there in the deliberations trying to figure out what happened here. Somebody's wire gets crossed. Well, remember there's that big rock out there in the front yard, or there's lots of rocks around. I remember seeing rocks around there. It's just a little subtle thing that can potentially distort their recollection. So what's going to happen with this? I think it just depends on what the circumstances are. I would expect the defense is aware of this. They probably ask questions. What's with that rock? Who put it there? What was it for? If it was there because they were there for the jury view, if it was there when the jury was present, they're going to be more concerned about it than if it had already, of course, been removed by then. So if this is an issue, I would expect the defense to raise it. And if they haven't gotten satisfactory answers to those types of questions, I would expect they'll ask for an evidentiary hearing. Why? Because this could be construed as potentially improperly influencing the jury, depending on the circumstances. Who did it? What permission did they have to do it? What was their purpose in doing it? So it will be a we'll see. We'll see. We'll see what happens. Of course, the other big thing that happened this weekend, the affidavit. The affidavit in Turtle Boy's case. So I'm not going to go through this line by line, but there's a lot of overlap, as you know, between Aidan Carney's case and Karen Read's case, because it's alleged that he's intimidated witnesses arising out of his coverage of Karen Read's case and the activities he's engaged in and stuff, the protest types of activities. So a lot of like common personnel, still dealing with the Norfolk County District Attorney's Office, dealing with Lieutenant Touhy, the Massachusetts State Police, some of the overlapping characters here. I have not really covered Turtle Boy's case on my channel at all, but the reason why this one came up is because he now has a witness who claims that this person, Kate Peter, she's the Masshole Mafia user on X, for those of you who are like me, regrettably, on X. She has apparently claimed to this person to have all kinds of communications inside lines into the prosecution and the prosecutors. Most important in this particular case, we have some statements that she's allegedly made involving Jennifer McCabe. So Jennifer McCabe, according to this witness, has paid off Kate Peter for help, putting information out and so forth. So it's alleged that Kate Peter told this witness that Jennifer McCabe had bought her a brand new sectional as compensation for her cooperation. And then this one right here. Kate Peter was told by Jennifer McCabe that Jennifer McCabe informed Michael Morrissey that she is, quote, not testifying unless Turtle Boy is in jail, unquote. Michael Morrissey informed Jennifer McCabe he would then have to subpoena her, and Jennifer McCabe then told Michael Morrissey, then we won't say what you want us to say. Well, that's interesting, isn't it? Because it does harken back to that discovery request, that discovery demand that Karen Read's team had made just before trial got started again the second time, where they asked for any indication about witnesses being hesitant to testify, witnesses tailoring their testimony, witnesses, not wanting to, just inducements, all that type of thing. And so everyone wants to know, what do I make of this affidavit? Well, on its face, this affidavit, it sounds like crazy town, doesn't it? It sounds like crazy town. This sounds like something that if somebody came to me and they told me this story, I might think this person is, honestly, like maybe psychotic, like dreaming stuff up. You get a lot of conspiratorial and paranoid types of delusions that can translate into wild stories when you're dealing with folks with certain mental health conditions. I mean, gotta be blunt. That's like the first thing that comes to my mind. Having said that, there has been so much crazy stuff, like unbelievable things that have already come out in the context of this litigation, that in context, this is far from the craziest thing that I've heard. Okay. The district attorney having ex parte conversations about his cases with a judge on a burner phone using a burner email account. That's pretty crazy. That's pretty crazy. Somebody comes to me and tells me that story, I'm going to be like, you better be able to back that up, because that's a pretty serious allegation. And yet, what happened? Lo and behold, yeah, that was going on. That was actually going on. They actually did substantiate that. And that's the whole issue now with defense in Karen Read's case wants to know, is Judge Cannone also having communications behind the scene with District Attorney Michael Morrissey on his burner account? And so requested any of those, and there's been a taint team that's been going through all of Mr. Morrissey's emails. But Hank Brennan decided, no, I don't want the taint team going through those. I'm going to go through them myself. And as we sit here right now, I don't think we know what, if anything, has been disclosed as a result of that review. So this affidavit sounds a little crazy, but it's far from the craziest thing that I've already heard in the context of this entire case. Another thing that gives me some pause about how serious should we take any of this. Well, okay, so the very fact that this is filed in an affidavit in court tells me, yeah, we need to take this seriously. We need to take this seriously. This isn't something that just got put out into the public sphere. Try it in the court of public opinion. This is being brought into court. So I got kind of some thoughts about the context and what that means, because, you know, so far, Mr. Carney's defense team has built quite a bit of credibility with this court. They have made allegations that they have been able to back up, even when these allegations seem a little bit nuts. There have been a pending motion to dismiss in Mr. Carney's case. It got argued, I don't know, quite some time ago, and we're still waiting for a ruling on it. So if you are in good standing with the court, you're waiting for a dispositive motion, are you going to risk kind of blowing all that up, setting yourself back with your credibility before you even have that decision, by just willy-nilly filing random, crazy sounding accusations? That would be quite a gamble. That would be quite a gamble, because you file an affidavit like this, just like if you accuse a district attorney of using a burner email account to communicate with judges, you better be able to back that up, because otherwise nobody's going to buy it. So the expectation here is going to be they will be able to back this up. Now, we don't know who the witness is. The witness's name is impounded, has not been disclosed. And we don't know how, if at all, they've been able to corroborate any of this stuff. We don't know what corroboration they may have. How did these conversations take place? Where did they take place? Are there other witnesses to them? Are they in text form? Has there been any verification of these things that Kate Peter has allegedly said? Are there records of the communications that she relates in here having with Mr. Lally, with Mr. Brennan, with Mr. Morrissey, with Ms. McCabe? I don't know. But I do notice something intriguing about up here in paragraph 15, where they have quotes, quotation marks. She is not testifying unless Turtle Boy is in jail, unquote. When you quote something, that means you're saying this is exactly what was said. So how did you know that? How did you know that? Well, that takes us back to that discovery motion the defense filed here, doesn't it? Disclose any communications where witnesses were hesitant to come in and testify. I would say this fits the bill. Not testifying unless Turtle Boy's in jail. I'd say that fits the bill. Quote, then we won't say what you want us to say. Do they have this in writing? Were these people dumb enough to actually put that kind of thing in writing? I have to wonder. It's in quotes. It's in quotes. There's no, this affidavit, it stands alone. There's no supporting exhibits. There's no documentation. As far as I see, I mean, the affidavit doesn't refer to anything that's attached or any specific evidence that supports it. So Mr. Carney's team is playing their cards carefully. They're holding their cards close when it comes to this particular set of allegations. They're not disclosing everything right up front. And why do you do that? Well, you do that so that you see how people respond. You just put the accusation out there, and what's your response to it? Do you deny it? Do you have an explanation for it? And then you see if that comports with your corroborating evidence, assuming, which we don't know here, assuming you have some. They deny it and you got it on text. That's a little bit of a different situation than, well, we admit it, but we're gonna try to explain it away or something like that. This is a warning shot. It's a warning shot. Signals, you don't know what we have. You don't know what we have. So be very careful. Be very careful about how you proceed. Last page here. There's not really anything super significant with respect to Karen's case here, except that very first paragraph here. Didn't come out at the trial, but that was around the social media, made the circles. Some news media ultimately picked it up. Was it News Nation? I would expect it to be News Nation. The quality issues. This little photograph went around that supposedly showed, Alan Jackson getting very handsy, back hug from the back of Karen Read. And clearly, implying there's more than an attorney-client relationship there. So this made the circles on the rounds on social media. People are like, that's a fake. A lot of people suspected it was a fake. News media didn't pick it up. It kind of corroborates, they can't validate this photo or establish its provenance or anything like that. But somebody eventually did, and really inclined to think it was probably News Nation, just because it's the kind of thing they would do. Sorry if it wasn't them and I'm smearing them, but they've earned it. So that's why I would make that assumption. But nothing ever really went forward with it. I think most people, left with the conclusion that this is probably fake. The whole situation was very sus in terms of how did this come about? Where did it come from? And all that. So according to this affidavit, Kate Peter admitted to this witness that she created the image of Karen Read and Alan Jackson embracing that was then given to the Daily Mail. Oh, was it Daily Mail who published it? Yeah, they're right up there with News Nation. I kind of put those guys on about even even journalistic playing field. As a little aside, speaking of the Daily Mail, for those of you following the divorce that will never end, the Ioan Gruffudd divorce from Alice Evans. I've talked about it on my channel before, but it's been some time because we are just languishing in nothing is happening mode. Divorce isn't getting finalized. Still have all the financial issues hanging out there. Anyway, Ioan Gruffudd remarried this weekend. Well, we don't know if it was this weekend that they got married. It was just announced this weekend that Ioan and Bianca Wallace, his fiance of the last couple of years, they're married, guys. They're married. It looked like a beautiful ceremony, very emotional, and very, very happy for them. It's a wonderful thing when you go through something, so demanding as exiting an abusive relationship, abusive marriage, obviously still having to fight it, still dealing with all the shenanigans in court, the litigation abuse, the financial abuse, and all of that. To have somebody to stand with you and to comfort you and support you is just very much a blessing for him. And I have no doubt that that's given him a lot of strength to be able to get through this part of his life and move forward into the future. So very happy for them. Anyway, brought it up because, Daily Mail is pretty much the only person the only outlet that cares about Alice Evans at all. And of course, we had a bunch of shenanigans with Alice and her dear friend Allison Bischoff, who was coming up with stories before information was really public, before people were supposed to know. Kind of some questions about how close that relationship was between them. So anyway, that's kind of what happened this weekend, guys. The Turtle Boy affidavit, and The Rock. A lot of conversation about that. So yeah, my bottom line, if The Rock is sus and hasn't been adequately explained, the defense will do something about it. They'll request a hearing, they'll file a motion, they'll do something. Maybe they'll put it on the record this morning, I don't know. But they'll do something to make sure that they have a request to address it at the very least. That is there in the record, because there's the potential that this is jury tampering. There's the potential that somebody's trying to distort the jurors' perceptions at the view. Somebody was trying to mislead them about the conditions at the scene. And that would be a problem if that's the case. So if they have reason to suspect that, I think we'll hear about it, and they'll make that record that they're making that request. As far as Turtle Boy's affidavit, is that going to come up here? Well, I mean, it might, because there's overlap, and Jen McCabe, she's going to be a witness here. So it looks like court is getting started. Let's go ahead. Bring them on, taking us away from the fan there.
Hey. All persons have any business before the Honorable Beverly Cannone.
Before the Honorable Beverly Cannone.
So Andrea, give your attendance and shall be heard. Let's say the Commonwealth of Massachusetts. This court is now open. You may be seated.
Oh, the closed captioning is the gift that keeps on giving.
All right. Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Good morning.
I do have to ask you those same three questions. Were you four, actually, I guess. Were you all able to follow the instructions and refrain from discussing this case with anyone since we were last here on Friday?
Yes.
Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left on Friday?
No.
Can't disagree with this.
Everyone said no or shook their heads. Were you all careful with your social media?
It does happen.
Yes.
Thank you very much. All right, Mr. Brennan.
Good morning, Your Honor.
Good morning.
Commonwealth will call Ian Whiffen.
Okay.
Ian Whiffen.
All
So
right, just
here we
hold on.
are indeed starting to get into facts, science, and data here in the middle of the case. But first, a sidebar. Maybe we're talking about The Rock. I don't know. So if Ian Whiffen is testifying, this is such a bizarre order sequence of events that we're getting from the Commonwealth. We don't really yet even have a timeline for Friday night. The jury doesn't even really know that Haas long to die in cold is an issue. That it was searched, when it was searched, the circumstances, the explanations that were given. Yet here we are, we're getting Ian Whiffen, and he's going to debunk Haas long to die in cold at 2:27 a.m. You know, according to the Commonwealth, that's what he's there for. That the jury hasn't even heard anything about yet. They don't even know. It's not in evidence. All we've had so far is they went out with Mike Camerano. You know, they fought that day, Karen and John. They argued that day over text. They went out with Michael Camerano, and then the next morning he's found, and you know, we've seen that process. He's taken to the hospital. He's died. That's all we really know about so far. And yet now we're going to jump to, and by the way, let's debunk Haas long to die in cold. It's just bizarre. I wonder if the jury is going to have a hard time following this. You don't have to always present your case in a chronological order. You don't have to. There's no rule that says you have to do that. It's just that does tend to be the easiest way to follow a story, is when it's told to you in order. When you get this part and then wait, hang on, I'm going to jump ahead, but let me backpedal and tell you something. It gets very confusing. Is that
Ian Whiffen.
Does the Commonwealth want us confused and not able to make sense out of this? Do they think that's helpful for some reason? I don't know. I just find this sequence very odd.
Please face our clerk and raise your right hand. You swear to affirm that the evidence you give to the court and jury in the case now here should be the truth, the whole truth, and nothing but the truth.
I do.
Good morning, sir.
Good morning.
May I, Your Honor?
Yes, please.
Good morning, sir.
Good morning.
Would you kindly introduce yourself to the jury?
Yes, my name is Ian Whiffen. I'm a digital forensics examiner and decoding product manager for Celebrite.
You just mentioned Celebrite. Is that where you work?
It is, yes.
And you're a forensic examiner.
I am.
Can you tell us a little bit about Celebrite, where you work?
Yes, Celebrite provides digital forensic solutions to customers globally for access and decoding of digital artifacts from devices.
Where would you find a digital system? Is that resigned to a phone, or is it all systems?
Typically, Celebrite focuses on phones or iPads, but we do have some additional devices that we can also integrate: computers, vehicles, things like that.
So simply, what is Celebrite?
Celebrite is a digital intelligence company.
Do they use a certain type of software? Do they brand a certain type of software?
Yeah, we create our own software to access devices and to decode the data that we pull from devices.
So essentially, does that software help you look into the data on a phone and analyze it?
It does, yes.
What is the role of a digital forensic analyst?
Typically, the analyst would take the data that's been extracted from a device, such as a cell phone, process that in software such as a physical analyzer that Celebrite create, and use that information to filter, to search, and to create a report for the investigator that would allow them to see what happened on the device at the time being investigated.
How long have you been involved in analyzing data, sir?
I started my career in digital forensics in 2013.
Can you take us back to the beginning of your career and tell us a little bit about how you became involved in learning about analyzing data?
Certainly. I spent 5 years as a frontline police officer in the UK during the 2000s. In 2009, emigrated to Canada and continued policing frontline officer in Calgary before joining the digital forensics team in 2013. Pursued several qualifications related to digital forensics and just continued in that role until 2019, 2020, when I left the police agency and began working for Celebrite.
While you were working at the police agency and began your career analyzing data, were there special classes that you took?
There were. In order to be a forensics examiner in Canada, you have to take a 3-week foundational course in Ottawa, basically covering the basics of digital forensics. And then from there, other courses are available that would focus on things like cell phones, would focus on how to get data from different types of devices. And then there's industry qualifications that can be sought as well, where you can focus on particular types of device or particular types of data.
Does software in this field continually change?
It does. Every time an update is released to an application or to an operating system, there's the opportunity for the foundation of that software to change. And from a forensics point of view, you have to re-understand what has changed, make sure you understand what is now happening on that device, and provide that information to the users.
As you've progressed through the field, do you continue to take classes?
I've not taken a class now since I actually joined Celebrite and did the basic foundational courses that Celebrite offer. But prior to that, I was doing courses across the industry.
Do you teach courses?
I do teach webinars. I don't teach any actual courses, although some of my research and some of my tools are taught to examiners in many of the industry standard qualifications which users seek.
Do you ever write papers about the subject that are published?
I do. So I have a blog where I publish my research. Sometimes some of those become papers which get peer reviewed and distributed in more academic channels.
So when one of your papers is peer reviewed, can you tell us what that means?
Yeah, essentially, other forensics examiners would read over the paper that I've written, do their own testing, compare their testing and research to what I've conducted, and make sure that what I've said is consistent with their findings. And presuming that what they find is the same as what I found, then they would agree that it's a valid document and it gets shared.
Take us now to Celebrite. When you began working at Celebrite, what did you do?
When I started there, I was considered the senior digital intelligence analyst. My role was to help the developers of the software understand the role of a digital forensics examiner, what an examiner needs from the tool, what an examiner wants to do with the tool, and how they want to use it. And then since then, I've progressed to the decoding product manager, where I can manage the backlog of software applications that we support, decide how we should support those applications, and how that information should look to the users.
Do you do research?
I do still do research, yes. It's not my primary function within Celebrite, but it's something that I've continued to do throughout my career.
Have you ever done any programming?
Yes, again, I'm not an official programmer with Celebrite, but I do program as well. And I have several tools which I've written myself for the last few years, since around 2015. Tools that I wrote to do the things that the vendor tools didn't do, and to offer examiners things that the vendor tools didn't offer. And I continue to maintain those tools as a learning opportunity for myself, and also because other examiners can make use of these same features.
Mr. Whiffen, have you ever testified in courts regarding forensic examination of data?
I have, yes.
And can you share a little bit about that?
I've been qualified as an expert in Canada, Australia, the UK, in total around 20 times.
I want you to take us now to the Celebrite software. We talked a little bit about it. I don't want to go into too much detail, but can you help us explain how software works like Celebrite software?
Yes, so fundamentally, when we've got data from a device, it's a series of files, a series of databases, property lists, all manner of different structured data. The software that we create knows where these files exist, knows how to read these files and what the data inside them means, and provides a clear view for the user to view that data. As an example, if you were to look at the SMS database on a device, all you would see is a long list of messages that don't really have an easy way to interpret or to read them. Our software takes that information, converts it into a conversational view so that as a user, you can read the data. You can see who sent what message, what time it was sent. We can do decoding and decryption of various different types of security to give the user as much information as possible.
Is there other software available in addition to Celebrite?
There's multiple vendor supplied tools and multiple tools available that are maintained by users in the community like myself.
Does a forensic examiner, should they rely simply on the software program, or is there more to do other than the program itself?
The software program is great at finding the data and displaying the data, but I always maintain it's the role of the examiner to actually understand what that data means and provide context and validation for what that data means, making sure that the end user of the report, whether that's the investigator, a judge or a jury, can understand what that data actually means rather than just taking it at face value from the software.
Does the software create a report that you can look at that manages or arranges some of the data that you can see?
It does. It just creates a list of all of the results that the examiner wants to include in the report.
So the software can produce a report, but the examiner goes beyond the report and looks into the data itself?
The examiner can and should go beyond what the program provides.
And how often do they do that, you think?
Your involvement in this case. Can you share with us when you first became aware of the data in this case and how that came about?
You think Guarino's
yes, it was
even
actually
capable?
one of the public relations managers at Celebrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp and requested if we could look into it and find out what the confusion was and how we could respond to it. At that point, I contacted the investigators to get more details.
Did you learn that a consumer had called about a question relative to a report produced by the software?
Yes, there was both the troopers who had requested information about this particular artifact and also a private forensics examiner, Richard Green.
And when Richard Green reached out to your company, what specifically was the question or issue?
He reached out to the tech support team, asking basically if there's a timestamp that doesn't make sense. I need to understand what this timestamp means.
What is a timestamp?
Essentially, it is the time which is attributed to an artifact. So it should intentionally be when something happened on that device, we would show a timestamp associated to it.
Can you tell us what an artifact is?
An artifact would be any piece of data that we pull from that device. So it could be a text message, it could be a location point, it could be a photograph.
So if I had photographs on my phone, would each photograph be considered an artifact?
It would, yes.
Would the date and time I took the photograph be considered an artifact?
I'd consider that a property of the artifact.
And if I had a phone call or a text message, those would be considered artifacts?
Yes.
When I look at my phone and I see a call log or a name, does that tell me all the information about that call?
When you look on the phone itself?
Yes.
No, there's usually a lot more information in the background of the phone that's available to the forensics examiner, which the user wouldn't necessarily see on the device.
And so when you're looking at an artifact, a phone call, a text message, whatever it may be, and you see it on a report, if you want to know more detail, where it came from, when it was developed, when it started, is that what a forensic examiner would do to look into the data to try to identify that other information?
Yes, you can see what other information is available. You can see if there's any information that's been deleted that can be recovered. And you can validate the information that's there and make sure that the timestamps are being interpreted correctly and that they mean what you think they mean.
You told us you got a call from a consumer or a forensic examiner, Richard Green, about a timestamp. What type of timestamp? For what type of artifact was this timestamp?
It was related to an internet query.
And so there was an internet query on a phone that had a timestamp, and this gentleman, Mr. Green, had a question about it.
He did. He wanted to know how accurate the timestamp was in relation to when the internet query was made.
Did you look into the query that was made?
In response to Richard Green at that time, I didn't. I wasn't aware that Richard Green had made this request until several months later, but it was an almost identical question that had been asked by the troopers here.
Oh, so to the
and
troopers,
that's the question that I was able to look into and to
responded.
answer.
And can you share with us what was the issue? What was the question that you were actually looking into?
The question was related to a timestamp of 2:27:40 a.m. And an internet query that appeared to have occurred at that time. There was no other information on the device that suggested that that internet query had occurred at that time. So we wanted to know how relevant is that timestamp to when the query happened. So I was able to take test devices, recreate test data to find out exactly what this timestamp meant, and discovered that it was actually the timestamp that the tab within the browser was brought into focus and had no relevance to when the actual web query had been made.
So after you looked into the issue and came to a determination or opinion, did you reach back out to Mr. Green?
Eventually, yes, I did. After I provided information to the troopers, I wrote a blog that covered this information because there was another examiner in Europe who had a very similar question, and I realized that this is a relatively common point of confusion. And then eventually I reached out to Richard Green, offering to speak to him about this issue and clear up any confusion, but never received a response.
So to summarize, there was an inquiry about a phone that made a Google or a internet search. And the question is, what time was that search made?
Correct.
And relative to that inquiry, there was a timestamp on some of the data that said 2:27 a.m.
Correct.
Sustained.
So at some point, did you have an opportunity to forensically examine a telephone that was attributed to a person by the name of Jennifer McCabe?
I did have the opportunity to look at the data that was extracted from that device. I never saw the device itself.
And putting that aside for a second, secondly, were you asked to look at any other phone to examine data in this case, aside from the phone attributed to Jennifer McCabe?
Yes, I was also sent the extraction of data from John O'Keefe's phone.
Did you look through the data and analyze some of the data in John O'Keefe's phone?
I did, yes.
So I want to walk through both your analysis of Jennifer McCabe's phone, but also of John O'Keefe's phone. So if we can first start with Ms. McCabe's phone.
Yes.
Did you actually receive her phone?
I didn't know. It was just a download of the extraction.
So how does that work?
The examiners here had done the extraction of the device, resulted in a large zip file, which is a container containing all of the files extracted from the phone. They uploaded it to Celebrite's secure portal, where I was able to download it and verify what the data was in the extraction.
When you received the download of the extraction for Jennifer McCabe's phone, was it similar process for John O'Keefe's phone?
With John O'Keefe's phone, I actually received the data on a USB thumb drive through the mail.
And before we begin, can you summarize briefly the issue, what you were looking for, and what the scope was as far as Jennifer McCabe's phone?
For Jennifer McCabe's phone, it was related to the internet search that occurred, or that allegedly occurred at 2:27:40.
Okay. And as part of your effort and analysis, did you put together a PowerPoint that would help educate us on how a timestamp works and what happened in this case regarding a search?
I did, yes.
And have you seen that PowerPoint recently?
I did, yes.
May I approach, Your Honor?
Yes.
Yay, a PowerPoint.
Thank you.
I'm handing you a binder that should take a look in. Do you know or do you recognize what's in that binder?
Yes,
the
this is the
slides.
PowerPoint presentation I created related to Jen's phone.
And with that presentation, do you have it downloaded on your computer?
I do, yes.
I'd like to introduce this as the next exhibit, please.
No objection, Your Honor.
All right, thank you.
Mr. Alessi, we finally get an Alessi
You know, with the
Cross.
court's permission, I'd ask Mr. Whiffen to be able to use his computer to walk us through the PowerPoint and explain it to the jury.
No objection, Your Honor.
Yes, thank you, Mr. Whiffen.
Okay.
May we begin, Your Honor?
Yes.
Mr. Whiffen, if you would walk us through and explain the PowerPoint and explain this issue to the jury, what the question was and how you resolved it.
Of course. Okay. The query revolved around a database called browserstate.db. Browserstate stores information about Safari internet browser and about the tabs that the user has either had open or has open. Fundamentally, in this presentation, I wanted to include information from iOS 14 and earlier. iOS 14 is not the version of iOS that was on Jen McCabe's phone, but iOS 14 has an easier way to understand how this database works. And then I can move on to iOS 15, which was the device or was the version installed on Jen McCabe's phone. And hopefully by that point, it will be clearer how this information is being populated on the device.
Could you tell us what iOS means?
iOS is Apple's proprietary operating system available on iPhones.
Thank you.
Fundamentally, the
Still?
browserstate.db tabs table is shown, hopefully I can show this on here, in the top here. The real database has many more fields, but these are the fields which are important for the demonstration to just see the row ID, the timestamp that's recorded, the URL or the web address, and the title of the page. And the example at the side there, you can see there's the browser is open, but there is no tab actually in focus at this time.
Can I take us just a little bit back so we can put this in context?
Yes.
When you are doing internet searches on your phone and you hit Safari or Google or whatever search engine you're going to use, does it create a tab?
It doesn't create a tab just by opening the application, but there may be tabs already open in the background when you start the application, and then you can tell it to create further tabs.
So if I have a phone, can I have a number of different tabs on my phone at the same time if I search for different things throughout the day?
Correct. You can have hundreds of tabs open.
Do tabs stay open forever or can you close them?
They stay open until you close them.
So if you look at your phone and you have a number of different tabs, and say, for example, I start with one tab, I'm looking for the local football score. Can I reuse that same tab for some other search, or do I have to use a new tab to start a new search?
You could use that tab for as long as you wanted, or create a new tab to do additional searches while maintaining the original tab in its current state.
And so what you're trying to demonstrate to the jury is identifying a time on one of these tabs
Objection. This
where a
is leading.
particular search was made.
Objection, Your Honor.
Sustained as to full.
Could you explain this demonstration as it relates to tabs on these internet searches? What are we actually trying to learn?
So as I showed, there's a field in this table called timestamp. It's actually called last viewed timestamp. And I wanted to prove or to demonstrate what that timestamp means, how that timestamp gets populated, and how it's relevant or irrelevant to a case.
So if I have one of many tabs open on my phone, each tab will have its own timestamp?
Correct.
And the URL, that's whatever I look up, what I search on the search engine?
Objection, Your Honor.
I'll allow that. Is that what's looked at?
That's great. The URL is the address of the page that's being viewed.
So if I have a tab open and I use it continuously, 3, 4, 5, 10 times, will the time stamp change?
No, it will not.
And is that what you're explaining to us now?
Correct. That's part of the demonstration and presentation.
I'm sorry to interrupt.
Okay. So in this instance, at 10 a.m., which is shown in the top of the device there, we can see I visit firstpage.com as an example website. At that time, A row is created in the database that shows row ID 1 with the timestamp 10 a.m. when the page was opened. The URL and the title are relevant to the page that was visited, so firstpage.com. A minute later, excuse me, I now use the same tab to visit secondpage.com. What actually happens in the database at this point in time is the first record is updated with new information. So we continue to see row ID 1. We continue to see the timestamp that the tab was opened at 10 a.m. And we now see the URL and the title that are related to the secondpage.com website. So I've shown it here. The first one is red to show that's no longer a live record. It's been replaced by the new record that's underneath it in black. A minute later again, I can visit thirdpage.com. And at that point, the record's updated a further time. So we still see that it's row ID 1 because no new rows are being created. We're just simply updating the existing rows. So we still have row ID 1. We still have 10 a.m. as the timestamp, and we have the URL and the title that show thirdpage.com instead.
Mr. Whiffen, so in the URL column, there are 3 different searches?
Yes, this is 3 different pages that have been visited within the same tab.
And in the data, it has 3 timestamps, but they're all the same.
Correct.
Okay, thank you.
This database is not monitoring web navigation events. It's purely monitoring the tab events. So when the tab's brought into focus or when the tab's created is the only timestamp that's relevant here.
Thank you.
From a non-forensic point of view, if I was looking at this database in a regular database viewing tool, all I would see is the black record at the bottom. I wouldn't see the other 2 records because they've been essentially overwritten by the third record. If I was to use a forensic tool, though, then I would see all of these records because the forensic tool is designed to find the older versions of these records that have been replaced. So again, from a forensic point of view, I would see all of these records, I would see all the different URLs, and I would see the same timestamp and the same row ID for all of them.
Is that
This
what we see on
fundamentally
Jen's
changed
phone?
in iOS 15. And I've tested this on multiple versions of iOS 15, 16, 17, and 18, including iOS 15.2.1, which is the same version of iOS installed on Jen McCabe's phone. In this case, the data is not written to the database immediately. So I've tried to show here that we have some in-memory variables, so essentially a short-term memory that the device knows exist, but aren't written to the database yet, so they're not written long-term. So in this case, if at 10 a.m. I go to firstpage.com, we see that the in-memory variable for timestamp URL and title are updated to show a 10 a.m. timestamp and the firstpage.com information. But you can see at the bottom, I still have the browser state tabs table, and nothing has been written to that database at this time.
So can I ask you a question about this browser state DB? What does that mean? What does that tell us?
The browser state.db is just the name of the database that Apple are using to monitor the tab activity on the device.
Will a cell phone have a number of different databases it will send information to, or is it all one database?
There are hundreds or thousands of databases, depending on what applications are installed on the device. Each database typically targets a different application or a different feature.
Can information from a URL or a Google search or a Safari search, can it leave data on different databases, or does it always go to one database?
It can leave on different databases, for sure.
Thank you.
So again, to continue this example, if I now go to secondpage.com a minute later, we can see that now the in-memory variable is updated. So the timestamp still remains 10 a.m., the same as it did previously on iOS 14, but the URL and the title are updated to reflect the current web page that's being viewed. Again, nothing has been written to the browser state database. I can go to thirdpage.com. Again, we see the in-memory variables for the URL and the title are updated, but the timestamp still remains the time that this tab was brought into focus or created, not the time that the navigational event occurred. Still, nothing's been written to the browser state database. And it's not until you actually close the tab that the information gets removed from the in-memory variables and written into the database. And at that point, the information written to the database is whatever was in the in-memory variable. So right now, all we have is a single record in the database that shows the 10 a.m. timestamp. That's when the tab was opened. And we have the thirdpage.com URL and title information, which is the most recent web page visited in that tab. It wouldn't matter whether I was looking at this data using a regular database tool or a forensic database tool. The only record that I will see is this particular record. There may be multiple versions of this record, but still would only show me this timestamp and this URL information because this is the only information that was ever committed to the database. Okay. Moving on from that, there was multiple databases or multiple data sources on Jen McCabe's phone that could be used to see what actually happened on the device at this time of day that was of interest. So the analysis I did looked at the browser state database that we've just described, the history database, which is what is tracking the navigational events. So every time you visit a website and the website fully loads, it gets written to the history database to say this URL was visited at this time. And that's the information that as a user you can see. When you look at the internet history in your device, it will list all of the web pages that have been visited. com.apple mobile safari.plist is a property list file, so essentially a list of values and information, keys and values that would describe various settings on the device typically, but it also stores information such as the last searches that were conducted using the Safari search feature. And then finally here we've got knowledgec.db, which is a massive database at the heart of iOS that stores lots of types of information. It can tell you what web page was actually on the screen at any given time. It can tell you when the backlight came on, when the backlight went off, when the device was locked or unlocked, the battery level, lots of different types of information, but useful here for the web pages that were being viewed. So using the combination of all those sources, I could see that at 2:27:29 a.m., Safari was opened from the application library on the device. At 2:27:29 a.m., when Safari opened, there was already numerous tabs open in the background. The browser would show in the foreground whatever browser tab was opened when Safari was previously minimized. In this case, we can see, looking at knowledgec.db, that the web page that was being viewed was related to Hockomock Sports, Friday's schedule scoreboard. At around 2:27:30, that tab would have been closed. Now, we don't actually have a time that the tab was closed, but based on other activity, this timestamp can be inferred.
Can be inferred.
Essentially, when this tab was closed, a record is created in the browser state database that shows the timestamp 1:59:44 a.m. That would have been the tab at the time that the tab took focus, and then the Hockomock Sports Friday schedule scoreboard URL. At 2:27:31, there was a browser switch occurred, and the last visited timestamp that's held in memory would have taken the time that this occurred, so 2:27:31. This URL was PayPal. There was no navigational event listed in history, so this wasn't a page that was visited from a bookmark or from typing in a URL. It was whatever was currently shown in that tab when the tab was brought into focus. And we know that this exact URL was last visited at 7:40 a.m. on the 28th of January. This is evidenced in browser state and in knowledgec. Around a second later, that tab gets closed, and that record gets written to the database with a time of 2:27:31. because that's the time the tab was brought back into focus. It gets written with the URL and the title information related to PayPal. At 2:27:33, another tab is brought into focus from the background. This one related to Eastern Bank. Again, the last visited timestamp would be updated because this tab has now been brought into focus, causing the timestamp to change. We know that this particular website was visited at 8:02 on the 27th of January, and there's no new navigational events at this time. So we know it's just brought into focus and visible on screen according to Knowledge C and browser state databases. That tab gets closed and it gets written to the database. This again is going to show, and I've just noticed there's a typo on here and the timestamp at the top is showing incorrectly. But essentially it's closed at around this time and the Eastern Bank URL is written to the browser state database with the 2:27:33 timestamp. At 2:27:35, we see that there's a YouTube video shown on screen related to It's Raining Men. This shows in Knowledge C. There's no new navigational event for it, but there's also no timestamp in the browser state database at this point. This is because this page is actually, or this tab is brought back into focus a second time. And when it gets brought into focus the second time, the timestamp that's attributed to it overwrites the timestamp that would have been written at this point. Sounds convoluted, but essentially, if you imagine that the in-memory timestamp here would have said 2:27:35, but then there's another tab that's brought into focus related to Hockomock Sports at 2:27:36.
Mr. Whiffen, can I ask you a couple questions?
Yes.
This timestamp 2:27:36, does that indicate the time when this tab was actually opened?
Yes. The time that the tab was brought into focus or opened.
What does it mean brought into focus?
If you imagine you could have 5 or 6 or however many tabs in the background, you select one of those tabs to view, it makes it full screen, that would be considered in focus, and that would cause the timestamp to be updated.
So if someone had an open tab that had a timestamp, and then they put it in the background to look at a different tab, but then went back to an earlier tab and opened it, would it create a new timestamp?
It would update the timestamp.
If somebody had an open tab and they didn't put it in the background, but they used other functions or shut off the phone, and when they came back, that tab was still open, would that create a new timestamp?
As long as Safari doesn't close, then the timestamp will remain the same. So if I just minimize Safari, put it into the background and start to do other things on my phone, the timestamp won't get updated. If I completely close Safari or turn the phone off, when Safari reloads, then that tab does get a new timestamp when it opens up again.
Thank you.
Okay. So at 2:27:36, we've got Hockomock Sports, Gallery Shoots, Canton Girls, Basketball to important win at Mansfield is the page that is visible on screen. Again, we know that there's no navigational event at this time, so the page is not being loaded as a result of a bookmark or typing the URL in. It's just showing what was on screen previously, and we know that this page was previously viewed at 22:55 on the 27th of January. This tab gets closed and gets written to the database as well, and we see it's written with the timestamp 2:27:36 when the tab was brought into focus. And then we go back to the YouTube video tab. So at this point, the timestamp that had been written there gets overwritten again with 2:27:38, and it shows the YouTube video is the active page that's on the screen. At around 2:27:39, that tab gets closed and the record is written to the database showing a timestamp of 2:27:38 when the tab took focus and the YouTube video URL. Then we move to 2:27:40, which was the time of interest. And we see that a browser switch occurs, causing the last visited timestamp to take on the time of 2:27:40. This is the tab that was ultimately used to search.
What happened to our sound,
At
guys?
this point in time, there is no navigational events recorded anywhere. All we see is that the web page that was brought into view is ozonebasketball.com/teams. This web page was last visited at 14 minutes after midnight on the 26th of January. We know that this is on screen because it tells us that in Knowledge C, and we know that the time is 2:27:40 based on Knowledge C timestamps and based on the browser state database timestamp. At 2:27:42, there is a web navigation event. Whether this is loaded from a bookmark or whether it's typed in, I can't say, but a web navigation event occurs using the same tab that's just been loaded. And now the user is loading the web page hockermocksports.com/standings. This is logged in the history database that shows what web page is visited when, and it also shows in the Knowledge C database to show what web page is on screen at this time.
Mr. Whiffen, in the slide before 22740, you mentioned that was the tab in question.
Yes.
Do the following pages that you show us in the PowerPoint follow that one specific tab?
Yes.
Thank you.
So at 2:27:47, there's another web navigation event as the web page hockermocksports.com/schedules is loaded. Again, this is evidenced in the history database to show that a navigation event occurred and completed, and in Knowledge C to show that this is the web page that was viewable on screen. At 2:27:53, there's a further web navigation event where we're now now loading the page hockermocksports.com/schedules/girls hockey. Again, this is evidenced in the history database and the Knowledge C database to show what page loaded and what page was visible on screen. At 2:27:58, there's a further navigational event for girls hockey Franklin 21-22. Again, this is logged as a navigational event in the history database and shown on screen according to the Knowledge C database.
So I understand these are all subsequent searches on the same open tab.
Correct.
Your Honor.
Are these
Sustained as to form.
Leading.
all subsequent searches on the same single open tab?
There is no tab switch event listed. We see the tab switch event occur at 2:27:40, and then we see lots of navigational events occur.
Thank you.
At 2:28:06, Safari is minimized, so it's removed from focus so that something else could be viewed, or the phone is locked.
Is removed from focus different than closing?
Correct. If you remove it from focus, it's essentially going into the background, but it's still open. It's in its current state, just in the background, versus if you close it completely and have to reload it later on. So in this particular state, the timestamp doesn't get changed. The timestamp remains 2:27:40 as it was earlier.
Didn't Jen say she
Safari
turned her
is then
phone
not
off
used
before she
again
went to bed?
until 6:23:37, when it's opened from the background using the icon in the app library. At this point, when it loads up, the same page that was open when Safari was minimized is shown. So we still see hockermocksports.com/schedules/girls hockey/Franklin/2021-2022. There's no navigational event at this point, so we know that it wasn't completely reloaded. It's just showing what was on screen previously, and it's evidenced in the Knowledge C database. At 6:23:49, there's a cache file created. The cache file is related to how long to digest food. Now, these particular cache files show up as suggestions in Safari. So as you're typing in a query or a word or a URL, for example, Safari tries to take that information and make suggestions based on what it thinks you might be searching for. So if, for example, you were to type in how long to die with the word spelled just DI, Safari can mistake that for how long to digest food, and it could present this information. And up until about 12 months ago, this is the information that was provided by Safari if you were to do this search. If you were to type in how long to DI, you would get the result that's shown at the top of the screen with an image of somebody eating a plate of food. And this is the image that was cached onto Jen McCabe's phone at 6:23:49.
What does cache mean?
Essentially, downloaded now for use later. It will download it, it will save it in case it's required again. If it is, it doesn't need to download it, it's already there. If it's not required again, eventually it will be deleted.
So is it stored information from prior events that's available in case the device thinks you're looking for it?
Yes, so at this point in time, at 6:23:49, when it downloaded it, that's the first time that it's downloaded this image, and it stores it. If an hour later, for example, I did the same search a second time, it wouldn't need to re-download the image because it's already got it in cache. So this, the creation time of this image shows that this is the first time that this cache file was downloaded. A few seconds later, at 6:23:51, the blue button at the bottom of the keyboard is used to submit a search for the term "how long tid I in CIKD," CIKD. This creates a specific URL in Safari, which is shown on screen here. So google.com/search how long tid I in CIKD, IE UTF-8, OE UTF-8. Client Safari is the important part of this string that tells us that it's a query that's made using Safari.
Camera, show us.
This is
the
different
PowerPoint.
to if I visited Google, for example, and just typed in the search text box in Google. It wouldn't necessarily have this same structure of the URL. So we know that this is the query created by submitting a search using the search bar here and pressing the blue button at the bottom. We know that that search was conducted at 6:23:51 according to the information in mobile-safari.plist. And Knowledge C also shows that this page was visible. Importantly, there is no history record made that shows that the navigation actually occurred to this website. Several reasons why that might happen. One could be if the device was in private browsing mode. However, it can't have been in private browsing mode because if it was, we wouldn't have the search recorded in the mobile Safari plist either. So we know it wasn't in private browsing. It could have been deleted at some point after the fact. That would leave a gap in the numbering. Every time a record is written, it would be consistent numbers 1, 2, 3, 4, 5, 6. And to delete a number would leave a gap there. So you would see 1, 2, 4, 5, and that number will pretty much never be reused. So if you don't see a gap, then you can be confident that nothing was deleted, and there are no gaps on this device. The third reason, and the one that I believe is the reason why it wasn't recorded in the database, is that the page never completely loaded. If I go to a web page and cancel the navigation prior to it completing the load, it will never get written to the history database. At 6:24:18, there's a second search submitted using the same method, so still using the Safari search bar, this time searching for host long to die in cold. This is evidenced in the mobile Safari.plist. Again, there is no record made in the history database that to me suggests that the page never successfully loaded. At 6:24:24, Safari is minimized again. It gets reopened at 10:33:33 a.m. Again, loaded from the app library and brought into focus. And at that point, the previous page is shown to the user. That previous page is related to the search host long dying cold. This is evidence in Knowledge C to show that this is the page that's visible on screen, but there is still no history event that shows that the page completely loaded. And at around that time, so around 10:33:34, that tab would have been closed, resulting in the record being written to the browser state database with the timestamp 2:27:40, when that tab was originally brought into focus several hours earlier, but it shows the most recent URL information, which is the Google search for host long to die in the cold. It doesn't have any of the other URL information that was visited during that time period. It doesn't have the previous Google search for how long to die in the Kikti, because all it records is the most recent URL that's visited alongside the original time that the
Did
tab
it
took
visit or
focus.
not then?
Importantly here, there is no title information. The title information is included within the page itself. So if you do a Google search, the title of the page that showed up would show Google search, and then it would show the query that you typed in to search for. The fact that this doesn't have a title also suggests that the page never loaded. So again, it kind of ties back to the fact that it's not written in the history database. We have no title. It's both indicative that the page never successfully loaded.
Mr. Whiffen, when a tab is ultimately closed, does the URL always have the last search, or could it show an earlier search?
It will always be whatever URL is visible in the tab at the time.
Thank you.
To overview again the data sources used here, com.apple mobile safari.plist is known to be a reliable location to get search timestamps from. We know that it's good to show the time that a search was conducted and what search was conducted. It doesn't record if the device is in private browsing mode. The only time it shows how long to die in the Kikti is at 6:23:51, and the only time it shows how long to die in the cold is at 6:24:18. There's no other mentions of either of these searches anywhere else in this file. The history database, again, is known to be a good source of data for visited web pages and timestamps for the pages that completely loaded. Again, in this case, neither of these searches or neither of these URLs was in the history database, but there are no missing records, which indicates that nothing was deleted. And again, the only reason that I can come up with for why that is the case is that the page didn't load. There must be an entry within this database to allow the user to delete it. Obviously, if the page doesn't load, it doesn't get written to the history. As a user, you can't see that item in your internet history list, so you can't delete it. And then knowledge C, which shows the page that's on the screen when the browser is in use. Again, we know that this is a good timestamp, and we see the only times that web pages related to these web searches were open is at 6:23 and at 10:33. There were multiple deleted records in the browser state database. It wasn't just the record for how long to die in the cold.
When you say there's multiple deleted records, can you go into a database and see what URL searches have been deleted from the actual item?
Yes, so from a forensic examiner point of view and using forensic software, I can look at the database and see the records that have been deleted and recovered. There does become a time when you're unable to recover any more records and they're now just purely deleted and unable to get back. But at this point, I was able to recover a good number of records. And these were the 5 that I thought it was important to focus on for here. You can see that 3 of them occur at 2:27. So at 2:27:36, 2:27:38, 2:27:40. And these are the web pages that we've just seen in the presentation. So Hockamock Sports, the YouTube video, How Long to Die in the Cold. And then 2 additional pages for cantonma.org and Ozone Basketball. The way that we're able to recover these records forensically is because of how databases work. What I've tried to display here is that when you first create a record, in this case, creating record 4025, a new page is created in the database. A page is simply a block of binary data that's organized in a way that can be understood by the database as a page of data, much like it would be a ledger with a list of records. So it creates frame 181 with page 2752 and the record 4025. What is a little bit different from if you were doing this manually is when you want to add a new record, or when you want to delete a record, or when you want to update a record, it has to create an entirely new page or an entirely new version of that page. So in this case, we see that frame 194 is also page 2752. It duplicates the record 4025 and adds the record 4026. From
This
the
is
database's
meaningless.
point of view at this time, frame 181 is now dead. Like, it won't be used for anything. And a regular database tool would only refer to the most recent version of that page, so frame 194.
Nobody knows what he's
Forensically,
talking about.
I can look back at all of these different versions of the page and I can start to see differences. Not so important in this case when all that's happening is that you're adding information, but when you start to delete or edit records, being able to go backwards and see these previous pages, you can see the records that have been changed or deleted. So as we're moving along all of these pages, each of these refer to a time when a new record was added. Every time a new record is added, a new frame is created, it duplicates the page from before, and it adds the new record. I've highlighted record 4028 in green across these three frames because this is the host long to dying cold record that is of interest. Moving forward again, we continue to see records being added, but particularly here at frame 430, record 4029 is deleted. 4029, if I go back a few slides, we can see 4029 is the cantonma.org Families Index webpage. As far as I know, no relevance to anything related to this case. It just so happens this is the first record deleted from the browser state database. We don't have information that tells us at what time the record's deleted, but we're able to infer what time that record was deleted based on other records in this frame. So for example, we know that at the time that record 4029 was deleted, record 4031 already existed. Record 4031 has a timestamp of 6:29 on the 31st of January. Therefore, we can summarize that record 4029 had to be deleted at some point after 6:29 on the 31st of January. We see again record 4030 is deleted on frame 468. Again, we can look at what record was the most recently created on that frame at the point that that record was deleted. And that gives us information that suggests record 4030 had to have been deleted at some point after 8:35 on the 31st of January. We can continue to go along and continue to see that records being added, edited, and deleted, but the record of interest, 4028, still exists, even on frame 650. And in fact, it doesn't get deleted until frame 732. By the time the record related to host long dying the cold is deleted, record 4037 already exists. Record 4037 was created after 2207 on the 31st of January. Therefore, we know that the host long to die in the cold record was deleted at some point after 10 p.m. on the 31st of January. Taking all of those deleted records, those 5 deleted records, and the earliest time that they could have possibly been deleted, we see a spread throughout the 31st of January. Like a few quite early on at 6:29 and 8:35, a couple at 9:20, 9:40, and then finally the one that we're interested in at 22:07.
But it was a deletion.
For the user to cause these to be deleted, if you wanted to do it selectively and delete one at a time, the record has to be available in the history database. As I said earlier, it wasn't ever in the history database because there'd be a gap. So this record could not have been deleted by the user selectively. That leaves options of deleting everything from the history. But if everything was deleted, we would have none of this information, and we do. And it also leaves the option of deleting everything from what's considered today and everything that's considered today and yesterday. And again, if either of those options were the case, we'd have much less information than what we have. And we wouldn't see this staggering of timestamps that we see here where the information was deleted. Ultimately, I wasn't able to say what caused these deletions at these particular times, but I'm confident that it wasn't as the result of user interaction. That's something that was brought on purpose.
Mr. Whiffen, I have a couple questions about your analysis and your opinions.
Yes.
You showed us a tab that was opened at 2:27:40, and it had something to do with Hawkmock Sports.
Yes.
In your opinion, to a reasonable degree of scientific certainty, was that the same tab, that 2:27:40 tab open for Hawkmock Sports, was that the same tab that later was used for searches or attempted searches at 6:23:51 and at 6:24 relative to how long or how's long to die in cold?
I believe it was, yes.
Does your opinion, is it based on your analysis of reports generated by software like Celebrite?
Objection, Your Honor.
Sustained as to form.
Was your opinion limited to analysis of reports generated by companies like Celebrite or Axiom?
It wasn't, no. I went into the data, looked at the various different databases, different files that were in use, tested it across many different devices to make sure that my understanding and analysis of it was correct.
In addition to your opinion that the two searches at 6:23 and 6:24 occurred at that time as opposed to 2:27:40, did you also, when analyzing the data, come to an opinion whether or not either of those searches actually connected and produced results?
If either of those searches had connected, the information would have been written into the history database. The fact that it wasn't in the history database, it strongly suggests it never completely loaded. And the fact that there is no title information on the browser state tab as well also suggests it never loaded.
And finally, those attempted searches at 6:23, 6:24, you mentioned that information at some point was deleted from the phone?
The only records that were deleted were the browser state database records. Yeah, they were deleted from the device.
Do you have an opinion to a reasonable degree of scientific certainty whether or not that information was removed as a natural application of the phone, or was it because somebody took the phone and actually deleted it by hand?
So again, I don't believe it's possible, given the situation and the information that's available, that it would have been possible for the user to delete it. I believe it was more than likely a system event that caused that, but I've not been able to replicate that system event.
I want to take you back to your first opinion, where you opine that the how's long to die in the search occurred at 6:23 and 6:24, not at 2:27:40.
Yes.
And so, in looking at the data, coming to that opinion, what caused the confusion with the software where it could be misunderstood the time those searches were actually made?
Objection, Your Honor.
I'm going to allow it.
The way that forensic software typically works, certainly the way that Physical Analyzer works, is we design models for the data. So we know that an SMS application, for example, will always have a message body. It will always have a sender, a receiver, a time, that kind of thing. We always know that a web visit will have a URL, a title, and a visited timestamp. In this particular case, in the database, the timestamp is called last visited timestamp, which is indicative, you would think, of the time that the web page was visited. So when that information was being modeled within the software, the timestamp that was within the database was used, and it was called last visited timestamp. Since the investigation that I did into this case, I requested that the forensic research team at Celebrite revisit this data and confirm if there's confusion around it. Were my findings correct ultimately? There are times that information can be correct. If, for example, you create a brand new tab, visit a website, and then close the tab immediately, then that timestamp would be indicative of the time that the URL was visited. But if you were to create a tab, use it for 3 hours, and then close it, the timestamp would not be indicative. Also, if you were to bring an old tab into focus that you'd used several days earlier and then close that tab, again, you're going to get bad timestamp information. So ultimately, from Celebrite's point of view, we removed the timestamp from that data to avoid confusion in the future.
You shared with us that the URL for the 623 and 624 attempted searches ultimately was removed from the device.
Yes.
Would it be fair or accurate to say there were over 4,000 deleted files from the phone, or there was 4,000 deletions from the phone?
There were many.
Sustained
Okay.
as to form.
Would it be accurate to say that the only
Leading
deletion from that
objection.
phone was that 623, 624 search?
No, there were thousands of records deleted ultimately for various reasons that I can follow.
That would be an inaccurate assertion?
To say that that's the only record that was deleted is inaccurate, yes.
Okay. Thank you. I'm now going to turn to a second phone that you looked at.
Okay.
You told us that you looked at two phones. The second one was a phone that was or is attributed to John O'Keefe.
Correct.
When you looked at the phone for John O'Keefe, were you looking at things different than we looked at on the phone attributed to Jen McCabe?
I wasn't as interested in internet data. I was more interested in location and health and anything else that could be useful.
Before we show any presentation, I want to get a little understanding of what you looked for and what you found. Were you looking for what's called location data?
I was, yes.
Was there a period of time that was important that you were looking for relative to location data?
Typically after midnight and before 6 a.m.
Is that on January 29, 2022?
It is, yes, sorry.
How does a phone, like an iPhone, store location data?
Multiple ways that it can be stored. Primarily, there's a database called cache.sqlite. And every time an application requests location data from the device, a feature called location services on iOS tries to calculate the device's location using a combination of technologies, GPS, Wi-Fi, cell tower, and Bluetooth. Calculates the device's location and stores that into the database as a latitude, longitude, altitude, timestamp, accuracy radius, information like that.
Are there different types of location data that are captured and stored on a device like an iPhone?
Can you define different types, please?
I'm sorry?
If you could define what you mean by different types.
The different sources of data that are generated that then captured on an iPhone.
Yes, so the application can specify how accurate it wants the data to be. So for example, if you're using a navigational application, you'd want high accuracy data. So the application would request high accuracy data from location services. Location services would then try to use GPS primarily to get location information. Versus if you were using a weather app, for example, where you don't really need to know precise information, you just need to know the approximate town maybe that the user's at. So a weather application would ask for low accuracy information, and the device may be able to calculate the location based on cell tower information, for example. Both can be stored in the database with the accuracy information that's available.
Would a application that is devoted to navigation in your programming experience typically have stronger data, location data information than a more general application like a weather app?
Yes, for sure. And Apple actually specify in their documentation, when they specify the various different accuracy levels, they have one for navigational purposes for map applications.
How do you define accuracy level from the different data that's being stored in the phone?
How do you mean, sorry?
Is there high level, middle, low?
Yes, the information is typically provided with a range of meters. So you'll have a latitude, longitude coordinate and a number of meters that you have to draw around that locational point. And the device is somewhere within that circle. It could be as accurate as 2 or 5 meters. It could be as inaccurate as several miles, depending on the technology that was used to get the data.
Are you familiar with an application called WAZE?
I am, yes.
Tell us what WAZE is.
WAZE is a navigational tool, so you can plot a route and it will try to direct you the best way, avoiding toll roads, avoiding accidents, that kind of thing.
What is the level of accuracy in location information that is generated by using WAZE?
That would be the highest level of accuracy. So it would aim to get GPS quality information of around 5 meter accurate.
So why doesn't a programmer in every application just use the highest level location data for every application?
Getting GPS data is not always possible. If you're in a building, in a basement, for example, you may not get that.
In a basement, for example?
It can be expensive to the device in terms of processing power, in terms of battery requirements. So if it can find location information cheaper by using the Wi-Fi networks, for example, then it would prefer to do that. So just a lot less resource intensive than using GPS all the time.
In order to capture the highest level of location data, the most accurate in an application such as WAZE, if somebody's using WAZE and then turns it off, does it still continue to capture that highest level of accuracy?
Typically not. It may do for a short time as it's still kind of working through a backlog. But fundamentally, if there's no application open that's trying to use location services, then the location information that's being requested and recorded is far more sporadic. It's typically background applications that may be requiring location data.
When you analyze John O'Keefe's phone, in addition to the location data, did you also look into data known as health care data?
Yes.
And could you tell the jury how that works?
Yeah, so pretty much all iPhones for the last 10 years or so have Apple Health included. It monitors activity on the device, such as steps taken using various sensors inside the device, looking for motion which appears to be walking. It monitors altitude, so it knows whether you've gone up a flight of stairs, for example. It uses that information in concert with the steps taken, so it knows the difference between going in an elevator versus walking a flight of stairs. And all that kind of information is available to you as a user to essentially see how far you walked each day and to monitor your own health.
When you look at healthcare data, you said it interprets it in different terms. One you used was steps. If I have an iPhone and I'm walking and it registers steps, can it tell what direction I went in?
No, it's purely just looking for motion of the gyroscopes, which appears to match the pattern that it expects of somebody who's walking. It doesn't know whether you're in a straight line, walking in zigzag circles, just number of steps.
What if I had my iPhone and I was moving the iPhone, but my feet weren't moving? Would it register?
It could register some, but typically it's relatively good at picking the difference between actually walking or throwing the phone around or shaking it.
The healthcare data, does it store with date and time?
So there's two locations that health data is stored. Primarily a database called healthdb_secure. And that aggregates the information into periods of time. So you may have a 10-minute period where it says 100 steps were taken. Now, it could be that the 100 steps were taken in the first 2 minutes and then virtually nothing was done for 8 minutes there. But there's another database called Cache Encrypted C, which is more granular. It's where the information is written originally prior to it being aggregated and moved into the bigger health database.
You also mentioned that the healthcare data has a term known as steps.
Yeah.
If the movement registers as steps, would that necessarily mean that a person was walking up or down steps?
Sorry, are we talking about steps taken or flights climbed?
I'm sorry, flights climbed.
A flight climbed, according to Apple, is essentially an incline of 3 meters over 16 steps taken. So it wouldn't really matter whether it was walking up a flight of stairs, walking up a steep inclined hill, on an escalator, something like that. If there is movement that appears to be walking and an incline of 3 meters, then that would be considered a flight climb event.
Is there any other ways that the phone could register flights climbed, but the person's not actually walking up or down stairs?
So I did test this a few months ago, driving in my vehicle. I was able to, if I just put a phone on my dock as I'm driving around, nothing was recorded. But I found that if I was actually holding the phone while driving at the same time, then the natural suspension of the vehicle plus the movement of my arm would be considered enough to be steps. And if that motion happened while I was driving up a hill, it would also result in a flight climb event. And the testing that I did consistently resulted in, I think it was 9 flights of stairs climbed while I was driving up the same hill multiple times.
In your studies, what elevation change would have to be present if you were in a car with a phone and it would register healthcare data as steps? Is there a certain level of elevation that would trigger that?
Again, it's just a 3 meter incline is required.
Did you say 3 meter?
3 meter.
The healthcare data, in addition to being able to give a range of time of movement and defining generally terms, whether it's steps or stairs, is there any other information about healthcare data that is important in your analysis of this case?
Sorry, can you just repeat that, please? I'm just
Sure.
trying to think.
The healthcare data you shared tells us there's movement,
Yes.
and it may come in the term steps. You also shared that the healthcare data can show elevation. That can come in the term flights.
Yes.
Is there any other information about the healthcare data you looked at? Did you look at it across a wide range in this case?
No, it was just the steps and the flight climb that I was interested in.
What is the time period you looked at the healthcare data for in this case?
Between midnight and 6 a.m. or 6:30 a.m.
That's midnight on January
On
29,
29.
2022 till about 6 a.m.?
Yes.
And before we get to any presentations, did you see movement on that phone relative to healthcare data at different points through the night?
I did, yes.
Did you identify those different times in your report?
I did.
You created a PowerPoint for Mr. O'Keefe's phone. Are those time points and movements, are they indicated in the PowerPoint as well?
They are, yes.
So you had, with Mr. O'Keefe's phone, you looked at location data, you looked at healthcare data. Is there any other data you found important in your analysis to try to track the movements or non-movements of the phone of John O'Keefe on January 29, 2022?
Yes, I've also looked at battery temperature information and at a feature called Doppler, which is monitoring for Face ID.
Tell us a little bit about the battery temperature. Is it the battery temperature of the phone or part of the phone?
There's a battery temperature sensor built inside the phone within the battery, and it's essentially always checking for battery overheats or battery cool downs to the point where performance will be affected and the device needs to power off to save itself being damaged. So that temperature information isn't recording ambient temperature. It's not interested in the temperature in the room, for example. It's purely interested in the battery temperature. But it is affected by ambient temperature. And I, again, did lots of testing by putting the phone into controlled temperature environments, so inside a freezer for a set amount of time, to monitor how the battery temperature would decrease over time, given the environment it was in, bringing it back into a warm environment and testing how long it takes to increase, putting the device outside. I live in Calgary, where it's pretty cold in winter, so putting it outside, it was like 40 Fahrenheit, I think it calculates to. And the temperature of the environment had a big impact on the battery temperature that was recorded by the device.
Were you able to track the changes in battery temperature for Mr. O'Keefe's cell phone over the course of the evening from after 12 on January 29, 2022 through after 7, 8 in the morning?
Yes, there wasn't a massive number of records, but there were records that I've included in my report.
In addition to those three areas, when a person uses an iPhone and presses the buttons, or they hold it and they try to open it by recognizing their face, what is that process called?
The Face ID would be the process for the unlocking, and then the locking, pressing the button on the side would lock the device.
When an iPhone is being used, does it act or operate differently when it's out in the open, or if it's in your pocket or under something?
Yes, so this is the Doppler function that I found within a feature called Unified Logs. Essentially, whenever the device receives a phone call, or when you pick up the device, an iPhone X or above is trying to find a face to use to unlock the device. If the camera is blocked, a record is made to say that it's within a pocket state. So if my phone's in my pocket, when somebody calls me, it tries to look for a face, it immediately recognizes that the camera's blocked, and it records pocket state. As soon as I take the phone out of my pocket or unblock the camera, it records a pocket state cleared event. So we know when the camera was covered up versus when it was uncovered, if at the time it was receiving a phone call or was being picked up.
Does an iPhone always record whether or not the camera was blocked or hidden or covered at the time a call comes in?
No. For example, if the device is already unlocked, then it won't make a recording to say that it was within a pocket state or a pocket state cleared. And if the device isn't blocked at all, so if I have the device on a desk in front of me, for example, and a call comes in, there'll be no record that says that it's in a pocket state or a pocket state cleared. It will only record a pocket state event if the camera's blocked, and it will only record a pocket state cleared event if the camera was blocked and now isn't.
So if I have my iPhone and I put it inside my jacket in the darkness and I get 30 calls, would all of those calls result in a reading of pocket state?
They'd all result in multiple readings of pocket state. The pocket state check is conducted more than once a second. I can't remember the exact number, but it's very frequent. And an average phone call from the start of the ring to when the device essentially hangs up, somewhere in the region of 500 checks. So if you had 10 phone calls, then you'll have 5,000 checks made that would all report pocket state.
Did you analyze John O'Keefe's phone
for each call
on the evening, early morning hours through the next morning on January 29, 2022, in an attempt to identify where he was, what he was doing, and whether his phone was inside or outside?
That was my goal, yes.
And did you engage in that analysis, sir?
I did.
And in your efforts, did you write a report?
I did.
Did you write multiple reports on these separate issues?
I did.
And those reports were provided to everybody?
Yes.
In addition to the reports that you generated from your study, did you present or did you prepare a PowerPoint?
I did.
Does the PowerPoint outline some of those points?
It does.
At the end of the PowerPoint, do you go through a timeline accumulating many of these pieces of evidence together that show them in a chronological sequence?
I do.
And does that help capture the movement or non-movement of John O'Keefe's phone through that
Excellent
night?
observation here.
Sir, may I approach?
Yes.
Very good observation.
I'm showing you a binder, sir. Could you look at it? Let me know if you recognize it.
Yes, this is the presentation that I created regarding John's phone.
And does it include some of the subject areas we just spoke about?
It does.
I move to introduce this as an exhibit, please.
No objection, Your Honor.
Thank you.
39. Go back and fill in the last one because I didn't hear them
Thank you.
say it.
With the court's permission, Mr. Whiffen, referring to exhibit 39, I'd like you to walk us through
Indeed,
John
it could
O'Keefe's
be.
phone on the evening of January 29th,
Okay,
2022.
Yes.
you.
Didn't look at
So
Jen's phone for
I
that, did
start
he?
the presentation with location data. As I mentioned earlier, this comes from the cache.sqlite database, which is considered the most reliable location or the most reliable file for location data on an iOS device. Stores information whenever location information is requested. That could be through user interaction with the device using something like WAZE. It could be background activity, just depending on what applications the user has open, what settings the user has chosen. It's constantly trying to find its location and recording it in this database, partly for the purposes of identifying frequent locations. At 12 minutes and 5 seconds after midnight, the device shows multiple location points at Washington Street around Forge Pond. What I've tried to show here, there's a kind of a gold dot in the middle, which would show the actual latitude, longitude information. And then the circle around it is what's considered the accuracy radius. The smaller the accuracy radius, obviously the more accurate the information is believed to be according to the device. But ultimately, if the device is anywhere within that circle, then iOS would consider it correct. It considers it an accurate record.
Mr. Whiffen, why are there multiple circles of location data for one point where Mr. O'Keefe's cell phone was?
So this wasn't a single point in time. This was multiple records at around 12 minutes and 5 seconds. No application was actually in use at this time requesting location information, but the device, for whatever reason, recorded multiple records with various degrees of accuracy. Typically, you would see accuracy start quite low and get better over time, which you may have seen on your own device when you open up the map application, and it may show your device close to where you are, but not perfectly where you are, and then wait a few seconds, and that information gets refined. Essentially, this is the same thing.
So low accuracy would be a wider circle and higher accuracy would be a smaller circle?
Correct.
At this point, Mr. O'Keefe is not utilizing WAZE on his phone,
Correct.
but location data is still being stored randomly on the phone from multiple different sources.
It is, yeah. Depends on the device itself.
In the top left-hand corner, it says 12:05. That's the time that this snapshot.
Yes.
Okay. And
In
then
this
below
case, approximate.
and below it's obviously the date.
Yes.
Okay, could you take us ahead, please?
There were multiple records between that last time and what's shown on screen now at 19 minutes and 33 seconds. But all of the records were sporadic and low accuracy with values of 1,000 meters or more. But around this time, around 19 minutes and 33 seconds after midnight, is when WAZE was actually brought on screen. WAZE starts to ask for high accuracy data, so we see the accuracy immediately start to improve. So again, we see relatively low accuracy data to begin, and then over the next few seconds, it begins to refine itself until it gets down to a 5-meter accuracy records as the device continues up here. We'll highlight that there's a cluster of records here as the device came to either a slow or a stop. Momentarily, multiple records were created, and then the device continued driving up Denham Street.
Mr. Whiffen, below the time, 12/19/33, in the date, talks about the average accuracy,
Yes,
and that's in meters?
that's in meters. So again, the records that are shown at the bottom here are around 55 meters. The records shown at the top are around 5 meters.
Is it typical in WAZE that once it locks in the range is around 5 meters?
Typically, yes. That would be the goal.
You also mentioned the average speed. Where do you learn the speed from? Where does that data come from?
The database, the cache SQLite database also calculates the average speed between two data points, and also the bearing or the direction of travel between those 2 points. So the average speed that's shown here on the left is approximately the average of all of the records that are shown on this map at the time. And each of these map points has a directional arrow that points in the direction that the database recorded the device was traveling in.
When you look at this information generated because of the usage of WAZE, and you can see both the accuracy and the speed, with the WAZE information at its most accurate, can you actually tell whether the vehicle is moving or whether it stops?
Yeah, based on the speed and the location and the timestamps, you can determine whether the device is moving or stopped.
Thank you.
Also important to, I think, point out here, in terms of knowing how reliable this location information is, I typically look at something along the lines of, does the location think it's accurate? In this case, 5 meters, so yes. Does it make sense? Like, it's on the road, it's on the correct side of the road. So again, it kind of makes sense. It fits the pattern of the road. The cadence and the speed are, what you would expect for this road, like traveling at 20 to 30 miles an hour up here seems quite reasonable. So all of these factors taken together increase my confidence that this would be reliable location data. Moving to the next slide, between 20 minutes and 19 seconds and 21 minutes and 58 seconds after midnight, the device starts on the left side, on the right side at Dedham Street, drives up and turns left onto Maplecroft Road. Again, we see that all of these location points match the pattern of the road layout. They all have a consistent cadence, a consistent speed, traveling at between 10 and 20 miles an hour. And we see a cluster of records here, which is around a stop sign. So again, it indicates how reliable the data is, because the location, or the location data that's recorded recognize the vehicle slow, come to a stop, and then continue after the stop sign.
Is Maplecroft Road in Canton?
Yes.
So Karen driving slowly, like she described.
At the end of Maplecroft Road,
in the interview,
the device turned left onto Oakdale Road and continued heading down there. Between the hours of 21 minutes and 59 seconds and 22 minutes and 53 seconds, the device continues down Oakdale Road. Again, all of these location points show with 5 meter accuracy. They show a consistent cadence, consistent pattern to the road. And again, we see a cluster where we see the device come to a slow or a stop for a stop sign. The device ultimately turns right onto Cedar Crest Avenue, I believe, and continue down there between 22 minutes and 54 seconds and 23 minutes and 57 seconds. Again, as I've said before, all of these points, 5 meter accurate, they all conform to the road. The cadence is good. And again, we see a cluster on approach to a stop sign. The device shows that it overshot Fairview Road and continued turning up Cedar Crest, but came to a stop somewhere between 50 and 51. And at 23 minutes and 58 seconds, the device appears to have turned around, so potentially a 3-point turn, in order to head back down Cedar Crest Road and turn right onto Fairview Road. Again, accuracy 5 meters, good cadence, good conformity to the road, all appears to be reliable and make sense, traveling at an average of 20 miles an hour.
And that road coming down at the bottom of the screen where John O'Keefe's phone travels, that's Fairview Road?
This is Fairview Road here, yes. The next few slides replay that same data, but instead of showing multiple points on one graph or on one map, it's going to show one location point per slide. So at 24 minutes and 20 seconds, we see the device is already on Fairview Road. Accuracy of 5 meters, traveling at 14.8 meters and heading south. 24 minutes and 21 seconds is now at 16.2 meters, but it's still highly accurate information. 24 minutes and 22 seconds, traveling at 18.3 miles an hour. 24 minutes and 23 seconds, traveling at 16.9. 24 minutes and 24 seconds after midnight, traveling at 16.9. 24 minutes and 25 seconds, traveling at 16.6. 24 minutes and 26 seconds, traveling at 17. 24 minutes, 27 seconds, traveling at 15.9 miles an hour. And at 24 minutes, 28 seconds, traveling at 14.5 miles an hour, at which point it's approximately outside number 34, around the driveway area. 24 minutes and 29 seconds, traveling at 12.1 miles an hour. 24 minutes and 30 seconds, traveling at 11.5. 24 minutes and 31 seconds, traveling at 10.4. 24 minutes and 32 seconds, traveling at 8.9. 24 minutes and 33 seconds, traveling at 7. 24 minutes, 34 seconds, traveling at 5.2. And 24 minutes and 35 seconds, traveling at 3.5. 24 minutes and 36 seconds, traveling at 3.2 miles an hour. And at 24 minutes and 37 seconds, traveling at 1.4 miles an hour. Finally, the device comes to a complete stop at 24 minutes and 38 seconds. I'll say
10
from the
seconds
testing that
at
I've
60
done related
miles
to
an
the
hour
speed,
after they hit the
it may
driveway.
not be 100% accurate, but it's a very good indicator of the speed in general.
Somebody do the math on
So
that.
if it says it was traveling at 10 miles an hour, it would have been traveling at somewhere between 9.5 and 10.5 on average.
Mr. Whiffen, you just showed us the travel of Mr. O'Keefe's cell phone
23 feet
around
per second.
12:24 to 12:24:38 on January 29, 2022. And you said at 12:24:38, it came to a complete stop.
Yes.
Before that complete stop, was the car continuously moving at some speed?
Yes, this is the first record that shows 0 miles per hour or 0 meters per second. Prior to this, there was always a record that showed some level of speed.
If you look at number 34 on that chalk, if you can highlight it, please. Okay. If the driveway were at the right side, the top side of the house,
Yes.
does your studies indicate that the vehicle, or at least the phone, traveled past the driveway before it stopped?
Objection, Your Honor.
Ask it non-leading, please.
Did this car or the phone that was in the car ever stop at the driveway of that address?
No, according to the location and the speed data from the device, by the time it was approximately the driveway, the phone reports it was still traveling at around 15.9 miles an hour.
Have you ever seen a photograph of that address?
I have.
You have or have not?
I have.
You have. And in that address, do you see on the far left corner of that address, the yard, there's a flagpole?
Yes.
Where this car stops, so this phone stops at 12:24:33, how close is the phone to that flagpole?
I believe very close.
And do you ever see the car or the phone stop anywhere near that driveway?
No.
Please continue.
Do you see the phone fly through the air?
Between
Few seconds
24
later?
minutes and 39 seconds and 25 minutes and 8 seconds, there were a cluster of more records, all showing 5 meter accuracy, but no movement. Although the center point does move around a little bit, you could interpret this as movement, but because all of the radiuses or radii overlap, there's also a good chance that there's no movement that actually occurred here. This is just the device as it's trying to refine its location. At 25 minutes and 30 seconds, we see a relatively significant change where the accuracy drops to 34 meters. We do see a course or a bearing that shows that the device reported it was heading west. But again, this accuracy radius includes the previous locations anyway. So it's difficult to differentiate between actual movement based on this location data or just on the fact that the accuracy reduced, the center point shifted because of the accuracy change, and therefore a bearing was attributed to it when it shouldn't have been.
If I could ask you some questions about the chalk on that indicates 25 minutes, 30 seconds, so 12, 25, 30. The circles become larger.
Correct.
Is WAZE still being used, or has WAZE been stopped?
No, WAZE has been closed at this point for about 40 or 50 seconds.
For how long, sir?
About 40 or 50 seconds.
This location data, or this circle, the perimeter, that's not coming from the WAZE application anymore?
No, the location data never came from the WAZE application. WAZE was requesting location data. iOS is responding to that request, and as part of that response would write the information to its database. WAZE itself records very little location data.
So when you look at that circle based on location data alone, could the phone be anywhere within that circle?
Correct.
There is a bullet pinpoint center of that circle.
Yes.
That center of the circle doesn't necessarily mean that the phone is at that exact location, does it?
It doesn't, no. The center point is purely an indication of where you need to draw the center in order to draw the radius. If we didn't have a center point, how would you know where to draw this circle?
And so the phone could be anywhere in that circle, close to 34, inside 34, 32.
Objection, Your Honor.
Ask it non-leading, please.
Could the phone be anywhere in that circle?
It could.
Could it be at the center point?
It could.
Could it be still in the car?
It could.
Continue, please.
Between 25 minutes and 31 seconds and 25 minutes and 36 seconds, there's an additional cluster of location data, ranging between 61 meter accuracy and 17 meter accuracy. All of them roughly centered on the same point, approximately, and all of the accuracy radius covers the same area. Like, there's so much overlap in these records that the device is essentially anywhere within the smaller circle. Between 27 minutes and 35 seconds and 38 minutes and 15 seconds, there was approximately 50 low accuracy records. Again, the device wasn't being used to ask for location data. This is completely passive and resulting in some pretty poor location data. I've highlighted with the red arrow where the 34 Fairview Road is. And we can see, although a lot of these location data do overlap with that point, there are location information here that doesn't. At 38 minutes and 16 seconds, the accuracy improves again. Is now 18 meters accurate, but continues to show approximately the same location that we saw 10 or 15 minutes earlier, around the flagpole area. 38 minutes and 17 seconds, same general area, slightly higher accuracy information down to 14 meters. 38 minutes and 18 seconds, accuracy increased to 12 meters, shifted slightly. Now the flagpole area is essentially at the lower side of this circle. Obviously the top side of the circle now includes a part of 34 Fairview.
If the location information is indicated by the circle and the circle has shifted, does that mean necessarily the phone has moved?
Not necessarily. Typically, you could assume it has, but when we're already talking about accuracies of 12, 13, 14 meters, it starts to become a little bit harder to determine how accurate this data is.
That's convenient.
at this point in time, it could be anywhere within this circle, and the movement of the center point could just be the result of refinement of the device or environmental conditions that suddenly change. If the weather changes, it could cause the device to slightly miscalculate or to calculate differently.
Would a snowstorm or a blizzard potentially impact
Yeah,
the
would it?
precision of location information that's not precise like WAZE?
It definitely has the potential to, yes.
How about a phone being covered? Could that affect it?
That could also affect it, yes.
If somebody was lying on a phone, could that affect it?
That could affect it.
Could being in a building affect it?
It could.
Thank you.
I don't think a person's going to block
So my
GPS,
one at
but
38 minutes and 20 seconds. Again, refining information more. We've got an 8-meter accurate radius, still focusing primarily on the front yard towards the left side. And then accuracy of 7 meters at 38 minutes and 21 seconds, again showing that same general area. Between 40 minutes and 22 seconds and 59 minutes and 29 seconds, accuracy fairly drops off again, and we see some fairly wild records that don't cover the area at all. But we also see some more accurate records showing, again, where the red arrow points at Fairview Road. Those records are highlighted here, just between 40 minutes and 22 seconds and 59 minutes, 29 seconds, only showing records of 25-meter accuracy or better. And again, it's kind of focusing on that flagpole area. Between 1 a.m. and 2 a.m., only looking at location information, which is 25 meters accurate or better. Again, it kind of focuses around the front yard area, although some of these accuracies are still rather large and could put the device inside 34 on the opposite side of the street, towards 32. Between 2 a.m. and 3 a.m., fairly similar story. Again, most of these points are centered around that same location at the front yard. Similarly, between 3 and 4 a.m., between 4 and 5, between 5 and 6. And in fact, if I take all of the location data between 25 minutes after midnight until 6 a.m., only looking at the records that report 10-meter accuracy or better, then typically they all focus around that same location at the front of the yard, nearish to where the flagpole can be found.
I'd like to ask you some questions about this photograph. There's a red circle with a bunch of red dots in the middle.
Yes.
Would those red dots indicate the center of some location that was captured at a particular point over that night?
Yes. So each of those center dots is the center of a 10-meter accurate or better location record. I chose to not show the accuracy radius circle on this image, just purely because it makes it hard to see when you've got all these intersecting lines. But ultimately, if you were to draw a 10-meter radius around all of these points, they would all fall within the large red circle that's shown.
So this photograph was meant to take readings from the most accurate of the data throughout the night?
Correct.
Objection, Your Honor.
Sustained. Ask it again differently, please.
Was this circle, did it include low frequency data?
No, this circle only includes 10-meter accuracy or better.
The fact that the
so the
center
precise
dots
stuff
are in different
puts
spots.
them in the street and all over the
Is that
lawn.
inconsistent with a phone being in the same place, not moving that entire night?
It could indicate movement. It could indicate refinement.
Is it impossible to tell?
It's impossible to tell at this level of detail anyway.
Are all of these dots, given the range, 10 meters or under, are all these dots and all these readings of the high frequency data that you compiled for that night, are
high
they all
frequency.
consistent with Mr. O'Keefe's phone being near the flagpole and not moving that night?
Objection, Your Honor.
I'm going to.
I think that's a reasonable assumption.
All right, this might be a good spot. Are you ready to move on to the next area, or you have any more questions about
Now would be
this?
a fine time, Your Honor.
All right.
Folks, why
Take
don't
enough
we
break.
take our morning break, 15, 20 minutes? We're going to see that there for 15.
Thank you.
Judge, please give me know what's going on this evening.
Isn't that
Rise
fun
for
how
jury.
the data means something when you want it to, but when you don't want it to, well, it could mean a lot of things. This high accuracy data showing him all over the front yard and out in the street doesn't necessarily mean that that's where he was. Doesn't necessarily mean that's where he was. Whereas the less precise information that includes inside the home at 34 Fairview, that doesn't mean that. Well, there is a lot to kind of go back and chew over with this guy, isn't there? He's a blogger that sometimes turns his stuff into peer-reviewed papers. If there's one thing we know about Mr. Alessi, it's that he's read every one of those papers and he knows exactly what this guy has researched and what type of opinions that he has come up with that have been substantiated or not. He's familiar with the guy's research background. He's from Celebrite, right? He's ultimately kind of a customer assistance guy. That's how he described his involvement in this. Customer had gotten the inquiry from Richard Green that they ignored, but then they get the inquiry from the state troopers and they follow up on that. Oh, and by the way, in the course of that, they go ahead and also answer to Mr. Green. How intriguing about those priorities. So whole issue came up with a 2/27/40 timestamp. And his explanation is, still pretty much the same as it was the last time, that data shows when the tab was originally brought forward. That's what the timestamp is, but it doesn't record until the tab is actually closed, at which point it records the website, the URL that is, being viewed. And so it records it later with the original timestamp from when it was brought into focus. That's his basic theory of this. I don't know how effectively he really communicated that this time. Like, I'm not quite sure if the jury gets that. He does acknowledge he did his testing on iOS 14, which is not the same iOS that was on Jen McCabe's phone. She had 15, but this just explains how it works. And then he did the presentation to show how 15 kind of changed the way it was working before. That seems to be kind of significant because you're making the assumption that these basic processes are doing the same thing in the later operating system as they were in the first operating system. But the second operating system, according to his theory, his explanation here, is that a whole bunch of the stuff that iOS 14 originally tracked, now iOS 15 is tracking in a temporary. It just temporarily stores this information. iOS 14 writes it into this browser state.db and updates it. iOS 15 does not. It keeps all these temporary files and then only records that final event. That seems to be an assumption. He has not given us much in the way of details about, well, how exactly did you test this? How exactly did you determine that these other operations are functioning exactly the same? One thing we know he didn't do, he didn't look at it from the programmer standpoint. Okay. He didn't go in and look at the code. Why not? He doesn't have it. Apple is proprietary. You don't get Apple's code. So you don't get to figure it out that way. It's one of the things I've always been, I love our chat. You know, we got so many good people in the chat, had so many people reach out to me. Andrea, I'm on the developer side of this, and maybe have a little bit of perspective that the forensic side of things, those folks don't necessarily have. The forensic people don't have the code. They don't know how this is set up to work. They don't know what sorts of problems have popped up over the course of development. Pretty much any software program is going to have, a programmer is going to have a story about, you know, code that they wrote and it's worked it out. It's supposed to do certain things, and, you know, you run it and it's got glitches. And then you're always having to go back, kind of figure out those glitches and you know, do your updates, do your patches, do all the things to like fix the unexpected stuff that isn't working the way that you thought it would. The forensic guys don't have the code. So they're working backwards. They're just looking at, well, what is the outcome? What is the outcome that we can see on this phone? And based on that, how can I manipulate this phone in a way that produces that same outcome? So they're reverse engineering is their process. They're trying to start at the end result and work back to figuring out how that end result is produced. Probably works a fair amount of the time for maybe even most things, but is this going to give you a complete and total picture of how the phone operates? No, it isn't. And Mr. Whiffen's own testimony tells us that. It tells us that because he says, yeah, these items were deleted. They were deleted from the browser state.db, and he has no idea how. He has no idea how or why that happened. It doesn't fit within his recreation and his reverse engineering of how all of this this stuff gets recorded in the phone. He's not able to recreate a deletion. So he doesn't actually have a complete theory of how this browser state.db database works, because he can't explain the deletions. All we know is he's just very confident it wasn't user. It wasn't user. Well, I don't think you do in fact know that, because if you can't explain the deletion, you don't know how or why things get deleted, then I don't think you do know that. I think you're just kind of guessing, because it doesn't make sense within how you think you understand this database, but you clearly don't have a total understanding of this database, or you'd be able to explain the deletion. So basically his explanation is that the iOS 14 would leave all of those original records as recoverable. You'd be able to do the forensic review, and you'd see them all. You'd see the course of the searches and the timeline stamps and so forth. But then in iOS 15, you don't do that, because it shifted the stuff that's going on in the tab, like in the meantime, over to this this short-term in-memory variable section, and none of that gets recorded. Only the final thing gets recorded. So she opened Safari. This is his theory. She opened Safari at 2:27:09. And at that point, there were already a whole bunch of tabs open in the background. Okay, so she'd been doing a bunch of stuff on the phone before on her tabs, didn't close out her tabs the last time she closed Safari. So Safari reopened with the same tabs at 2:27:09. And so he says that would show whichever the last open tab was the last time she viewed Safari. And that was Hockomock Sports. That was the Hockomock Sports. Jen McCabe's testimony in the first trial was that she was searching the Hockomock sports at this point in time. That was her web activity at 2:27. I don't know that that's substantiated. It shows she was already in Hockomock sports when the tab was brought forward. And at around 2:27:30, that tab was closed. It has the timestamp of when that tab was opened, which was 1:59:44. So half an hour earlier, I guess, is when she was searching. She opened the tab and eventually, got to Hockomock sports. 2:27:31. So she closed that tab. There's a new tab now that comes forward. It's PayPal. So she closed that. It created the record. But the last time PayPal had been visited was on 128, according to the browser state history. So this is just it was in the background and then she closed it and it records it as the 2:27:31. Then the Eastern Bank tab comes forward. She closes it. It's written at, 2:27:33. Why would it write to the database as 2:27:33 if that's not when the tab was opened? The tab was already in focus. It was last visited on 127. So now, like, this is not consistent with what he just explained. Is this consistent with what he just explained? He said that the browser state.db records when the tab was created, but now he's saying these came forward. It's quite confusing. Maybe I missed part of that, but it seems quite confusing. It was last visited on January the 27th, but she closed it, so it's written to the database as 2:27:33. When she closed it, that's not what this database is supposed to be recording. 2:27:35, the tab comes up. It's the YouTube video of It's Raining Men. It was last accessed on January 27th at 16:58 in the afternoon. Remember in trial 1, Jen McCabe testifies that they're sitting around the table at the party at the Albert's house at 34 Fairview this evening when, we're in the middle of the butt dials to John's phone and she's watching the car outside and all of that stuff. She is searching. She's playing for them the video, It's Raining Men, not according to Mr. Whiffen's interpretation of her phone, because she hasn't looked at it since 6:48 or 4:58 on January the 27th. And then it switched to Hockomock Sports. So now he's saying bringing the tab forward from the background is what causes the timestamp to be updated. Okay, so it's not when the tab was originally created. It's just when you look at it again, that's what timestamps it. It's a mess. The reason I'm bringing up these references that Jen McCabe made in her prior testimony to, I was searching Hockomock Sports, and I showed everybody the It's Raining Men YouTube video around the table, because it kind of starting to sound, it doesn't add up with this explanation. And so it's kind of starting to sound like, Jen McCabe maybe got the extraction and tried to build a story around what she understood the data or the report. Maybe she saw Ian Whiffen's report, one of these prep sessions. Maybe she saw his report. It kind of looks like she attempted to craft a story around it, because her story doesn't add up with what he's saying. 2:27:35 is when the tab was brought forward, but the last time that website was accessed was 4:58 on January the 27th. So she's not showing it to everybody around the table at the Alberts while they're waiting for John to arrive. So as long as Safari doesn't close, the timestamp will be updated. But if you close it or power it off, then there will be a new timestamp when it's opened again. This is important because Didn't Jen testify she turned her phone off before she went to bed? I could be wrong. I could be wrong about that. It could have been Nicole Albert or Julie Albert or one of the other witnesses who testified that she turned her phone off before she went to bed. Check me on that. If we get to the lunch break, I get a chance, I might check in my notes from the last trial real quickly. But if that's the case, if she turned her phone off and that's her story, that again doesn't add up, because according to Mr. Whiffen, that would change these timestamps, and it wouldn't be pulling up all of this old stuff. I kind of thought she did, because it was. But then she got the call from Karen in the morning, so it would have woken her up. Yeah, I don't remember. Maybe it was one of the other witnesses, and I'm getting them confused. It might have been Nicole, to try to disclaim receiving one of these early morning phone calls that shows on her record, shows on her phone record. She got a phone call at like 6 something in the morning, like when they're outside. Should have woken up. Maybe it was Nicole I'm thinking of. So I could be off about that. So then at 2:27:40, she creates a new tab. And according to her, this is the one that's ultimately used to search, according to Whiffen, this is the one that's ultimately used to search the Haas Long. But there's no navigational events. The page in view was Ozone Basketball, which was last accessed on, according to the history, 12:14 a.m. on January the 26th. How do you create a new tab that automatically navigates to something that you haven't visited for a couple days? How does that work? Like, okay, if you open a new tab, it goes to your home, whatever you have set for your home page. It could be Safari's homepage. I don't use Safari, so I don't know if Safari lets you like set a new default homepage. I kind of assume it does. It's kind of a thing that users tend to want in their web browsers. So, okay, I could see if Ozone Basketball is like her default page, it would go there, except he tells us it didn't, because it was last accessed after midnight, shortly after midnight on January 26th. So what's on this tab that gets opened? Already this tab that, according to him, is the one used to search the Haas Long is kind of sus. It's kind of sus. So then she goes to the Hockomock Sports at 12:27:42. And then Mr. Whiffen's got this, series of history of searches, things that he pulled from the history database. Bunch of seconds, different seconds. She moves to schedule. She moves to girls hockey. She moves to Franklin. And all of this is originating from that 2:27:40 tab creation. And then Safari is minimized. So because it's still open, that doesn't update the timestamp. Then at 6:23:37, that tab is open from the background, showing the Hockomock Sports, because that's the page that's visible. Didn't he tell us in iOS 14, none of this stuff, or iOS 15, none of this interim stuff gets recorded? This is all supposed to be in temporary files. And so I guess he's looking at this from history. I don't know. I wasn't able to catch all that, and this stream didn't do a great job necessarily of showing us the PowerPoint. The PowerPoint's an exhibit. Probably like what happened last trial is folks will start to get a hold of the exhibits. They are public records. Yes, even in Delphi, Indiana, they are also public records there. But last trial, a lot of these exhibits were kind of collected and compiled and reported in various locations, even as the trial was going on. So maybe we'll get to see this PowerPoint again and kind of parse through some of these issues. But But he's saying there's no navigational event. It's just showing what's on screen previously. How do you know that? It's not clear to me. So 62349 is when the cache file is created. So that's he explains that's the Safari suggestion only. It doesn't indicate that a search was actually performed, I guess. It just means that a suggestion is made. And then at 62351, the search is, the how long T die in Kikti. He says this is different than if he goes to Google and uses their search bar. This is a query. This is a query using a search bar. It was a little detail that he dropped in there that I don't quite understand the significance of it. What you can see from the URL info is that it appears that in Safari, she went to Google and tried to run this as a Google search. She tried to run it as a Google search. And his explanation for why there's no history of that search is because it never loaded. There would be a gap in the database if there was a user deletion and there are no gaps. So his explanation, the page never completely loaded. Then 30 seconds later is the Has long to die in cold, 62418, also not listed in her history. And his explanation is, well, it never completely loaded. Then it's minimized again. Then at 10:33:33, she reopens Safari. The Has long to die in cold is the last thing that she had done. So that's what's shown in history. Not clear. And then the tab is closed. So the record is written to the database with the timestamp of 2:27:40, which is the time of the original tab coming into focus. Why isn't it when it came back into focus? He said in his previous testimony when he was talking about the YouTube video, the timestamp was it indicates the time that the tab was brought into focus because bringing it forward from the background causes the timestamp to be updated. So I guess he's saying it was never in the background, so it was never updated. That tab was just always open from the time that she created it until she did the Has long to die in cold search. That's the best sense I can make out of his testimony. I consider myself a pretty smart person. Like I can usually follow arguments pretty clearly. I think I'm pretty good at understanding stuff if people are good at explaining it. So that's my best interpretation of his theory. I'm not sure that the jury caught all that, and I'm not sure that it helps that you ended all of this with your explanation that you don't know why these show deleted. Last thing the jury really remembers about you talking about these tabs is saying you don't know. You weren't able to recreate it. That seems like a little bit of a problem as far as validating your interpretation of how these different artifacts are created. Important thing, definitely an important thing here. 623. Let's get it real accurate. 623:49 is the timestamp for when she is starting to search how long to die in cold, right? The how long T die in Kikti is she's starting it then because that's what brings the Safari suggestion about how long to digest food into the cache. So 6:23 49 is when she is doing this search. That's the timestamp. And well, something just happened with my stream. Hang on. Give me a second here. The point is that they're going to need to, you know, the stream ended on NBC 10 for some reason. So I might have to find another stream over here. Give me a second. I'll get it back up. They have all of the they have the dash cam video, right? They have the dash cam video. And so 6:23:37 is going to be an important point in time to be checking that dash cam video, because we are going to want to see who is where at 6:23:37 on the dash cam video. If Jen McCabe and Karen Reed are anywhere but in the back of the patrol car, we don't know if it's Seraph's patrol car or Mulaney's patrol car. I kind of think it was Seraph's, but I don't remember off the top of my hand. She needs to be, they both need to be in one of those patrol cars with Carrie Roberts standing directly outside, because that's the explanation for when and why those Google searches happened at that time. Karen Reed told me to. Karen Reed screamed at me, Google hypothermia. So hence the how long to die in cold. That's her explanation. So just hypothetically, the jury goes along with Mr. Whiffen. Okay, I agree. She didn't do it at 2:27. That's just the weird. That's just a weird way that that Apple keeps track of this data. It's just a weird way that it gets reported in Celebrite and stuff. It's very confusing, but that's not actually, not actually what is going on. She didn't do the search at 2:27. Okay. She did it at 6:23. If that doesn't add up with her story of how it happened, then it's still not a good thing to be searching. A little bit less incriminating because now they're already at 64 Fairview. They already know John O'Keefe is out here. They found him. It isn't the how would they have known type of implication that you have if the search is run at 2:27, but it would be the explanation for why it happened now that's off. If they are anywhere but exactly where Jen McCabe says they were at 6:23 in the morning, then the explanation is off. And now we've just got more sus behavior on your part about why are you making up? Why don't you just tell us why you searched this stuff at 6:23? Why are you having to come up with a story? So let's see how that pans out. Then looked at John O'Keefe's phone and the health data and the location data. Oh, what did you think of that little? What did you think of that little drop? For example, if you're in a basement, you might not get GPS data. You don't say. You don't say. Being in a basement could interfere with being able to get GPS data. What was on his mind? What was on his mind to drop that? To drop that out. So first he starts with the health data, the steps. Doesn't really get into that, does he? Just gets into I can create step data if I'm holding my phone in the car and we're following like the bumps in the road on the car and the navigation and stuff. He says he did it. Was that a peer-reviewed, was that a validated type of experiment, or was this an anecdote? Was this an anecdote? Because I remember the last trial, a lot of people came up with a lot of anecdotes about driving around with their phones and trying to see, if I drive up a hill, will it record? Will it record flights? I would imagine, if this is a good experiment, it's very controlled, right? You would replicate it. You would do it a few different times under the same types of conditions. Your arm you're holding the phone in the same place. Your arm is just as loose this time. I wouldn't do something like, I'd try it like this, and then I'd go and I'd shake and like try to mimic a walk to see if I could get it recorded. No, you wouldn't do that if you were producing a valid experiment. But I wonder, what if any records did he even keep of this testing? And is this really a test, or is this an anecdote? So he says it is usually pretty good at distinguishing movement that is not walking from walking. But nevertheless, he can try to get it to recreate steps and flights climbed by just holding it in his phone in the car. The battery temperature data, okay, looking forward to that, seeing what that shows. The Face ID, when a phone call comes in, over the time period it takes for a phone to register the call, and then, whatever is going to happen with the call, not answer the call, whatever, the phone is looking for a face 500 times. Oh, disturbing. Yeah, I know it's probably not the only time the phone is doing stuff like that, but it's just this is the whole surveillance aspect of the phones that we all carry. Like, I'm gonna turn my phone over right now. Actually, no, because but there's cameras on both sides, guys. Cameras are made now. There's cameras on both sides. You can't even just turn it over to be like, I wonder if my phone is watching me right now. You can't even do that. There's cameras everywhere on it. It's yeah, trying to find a face. Oh, before I forget about the battery temperature, I'm going to be interested to see how far his analysis goes, because I wouldn't think that he has the type of expertise to evaluate something like what's the effect going to be of, okay, take the Commonwealth's theory. John is thrown by the car. He lands on his phone, and he's out there lying on top of his phone for hours. The differential, the one side of the phone is on the ground. One side of the phone is under his body. His body is warm. His body is probably significantly warmer than the ground. That's going to change over time, depending on when he dies. His body's going to stay 98.6 or whatever until he dies. And then it's going to start getting cold. So how is that going to work between those? I'm not sure. Okay, it looks like we have a new link and court is back. So I'm going to go ahead and get that up, and we'll be just a couple minutes behind. Not too bad. And this is this one right here. So,
All right, Mr. Brennan, whenever you're ready.
we're
Mr.
back.
Whiffen, before
Where they
we
go
go
with
into the next subject area, I'd like to ask you about the location data. Based on your review of the location data, do you have an opinion whether the location data throughout the evening is consistent with John O'Keefe's cell phone being near the flagpole the entire night?
I believe it is, yes.
I asked you whether you had an opinion whether it was consistent with. I didn't ask you if you had an opinion to a reasonable degree of scientific certainty. Are there other things that you looked at that you will consider, in addition to the location data, to have a more certain opinion?
There is.
And is the next thing that you considered Apple healthcare data?
It's the Apple Health data, yes.
We asked about it, or I asked you about it earlier on, but I just want to talk about it a little bit before you show us and present to us the data that you've compiled for us. Is Apple Health data different than when you have like an Apple Watch?
No, it's the same Apple Health data recording on the phone or the watch. The only difference is the sensors being used to do that monitoring. So if you're just using the phone, obviously you're only using the sensors in the phone. It's limited to steps walked and to altitude climbed. If you're wearing a watch, it can also do those things, but it can also add things like blood pressure monitoring and things like that.
Does Apple Health data require an internet connection?
It doesn't, no.
So it's all self-survived on the phone itself?
It is.
So without having an internet connection, it will still store the data?
Correct.
If I have an iPhone, is it storing health data even if I didn't ask for it to do so?
Yes. Unless you actively turn the feature off, it will by default try to track movement.
Is it something that is hidden that I wouldn't see unless I look for it?
No, there's an application for Apple Health, and then the settings are quite obvious in the settings screen.
Apple Health data tracks movement of the phone?
Correct.
When you were considering the Apple Health data in this case, did you begin looking for the Apple Health data before Mr. O'Keefe's phone began approaching Fairview Road?
Yeah, I started again at around midnight and looked at the health data up until 6:30 a.m. on the 29th.
The different points when you tracked Apple Health data, is that helpful even if you're only trying to isolate a certain point in time?
It can be, yes.
Does it help determine whether or not it was working properly? If it was,
it can determine whether it's working properly. It can determine an average kind of walking speed, for example, of a person, the average gait that the person may walk with, if that was important.
if a person has an iPhone and they're moving and it registers Apple Health data, and then they stop moving, and the healthcare data doesn't register because there's no movement, would the Apple Health data resume movement even if somebody else picks up the phone?
It would. The phone itself doesn't care who's carrying it. It just looks for movement.
So it doesn't identify the owner in order to register movement?
Correct.
Objection, Your Honor.
Does it identify the owner in order to register
Better
movement?
question.
It doesn't, no.
Could you turn to the next part of the data analysis that you did,
Yes.
please?
So the two sources that I got the Apple Health data from were a database called healthdb_secure.sqlite. This, as I said earlier, is the typical database that's used to store long-term information about the health activity that's been recorded. So this database can have years worth of steps taken, flights climbed, and any other kind of health data that's been recorded. The downside to that is that the information's aggregated, so you see chunks of time and multiple activities can happen within those chunks of time. The cache encrypted C.SQLite database is much more temporary, but is much more granular, so we can see exact times that flights were climbed, for example, or at least you can see the exact time that the flight climb was recorded to the device. And then that information is aggregated into the larger chunk of time. So again, we might see within the cache encrypted C individual flight climb events that occurred, for example, 30 seconds apart. But by the time that information is written to the HealthDB Secure, you're now looking at a 10-minute time period with 3 flight climb events, as opposed to 3 individual flight climb events. Typically, that source is not used because the data is not stored there for very long. The information I found on John's phone was essentially these 5 records. So between 11 minutes and 9 seconds and 21 minutes and 5 seconds, there were 170 steps recorded by the device.
Mr. Whiffen, I'm going to stop at each one and ask you some questions. At the time period between 12/11/09, 12/21/05, you don't have any independent information where John O'Keefe or his cell phone were, do you?
The location data that I showed to begin with on Washington Street was around 12 minutes after midnight. So the presumption is that's where the location was at that time. And then 21 minutes and 5 seconds, the device had already started using WAZE. It was already driving along Denham Street or had turned onto Maplecroft.
What time did you say that WAZE was initiated?
It was approximately 19 minutes and 30 seconds-ish.
Thank you.
Again, we see at 21 minutes and 10 seconds until 24 minutes and 22 seconds, there are 80 steps recorded. And again, if you compare this to the location data, we know that the device was in a vehicle at this time.
Take us back to the screen.
Between 22 minutes and 14 seconds and 24 minutes and 37 seconds, we have 3 flight climb events that are aggregated into that time period. And again, the location data shows that the device was traveling in a vehicle at that time.
Mr. Whiffen, you had showed us a slide of 2437 on January 29, 2022 in your PowerPoint presentation, noting at that time, 12/24/37, the phone in the car was still traveling at 1.4 miles per hour.
Correct. This is about a second before it came to a stop.
Can you conclude to a reasonable degree of scientific certainty that that period of 12/22/14 to 12/24/37, Mr. O'Keefe, or at least Mr. O'Keefe's cell phone, was still in that car?
Yes, the location data shows it was in the car at the time. And my next few slides will demonstrate why that was still recording a flight climb event while it was in a vehicle.
Thank you.
At 31 minutes and 56 seconds until 32 minutes and 16 seconds, there were 36 steps recorded. And then there was no further health activity recorded on the device for several hours until 4 minutes after 6 a.m. When 432 steps were recorded between the time of 6:04 and 6:11.
Let me ask you about that 12/31/56 to 12/32/16 time period.
And when
We can see
the
larger
police get
ranges in the
there?
time period range. That is a smaller range comparatively.
Yes.
Okay. At 12/31/56, is that the beginning of the 36 steps?
Essentially, yeah, it takes the timestamps from the cache encrypted C, looks at when the first step occurred, looks at when the last step occurred, and aggregates the times based on that.
So 12/32/16 would be the last steps taken for that cell phone.
Correct.
And in between that time period, there's 36 steps. You shared it earlier that it doesn't indicate the direction of the steps.
Correct.
Other than the movement that equates to steps, can it tell anything about what direction, the positioning, how the phone was moving?
It can't, no. It's just purely registered what it thinks are 36 steps.
Could it have been a straight line?
It could have been a straight
Could
line.
it have been somebody pacing?
It could have been,
Could it have been somebody moving and jumping?
yes. Jumping, if they were jumping forward, essentially.
After 12/32/16, when this phone took its last steps, it never moved again?
Objection, Your Honor.
Form of the question sustained.
After 12/32/16, when this phone took its last steps, did it move again until 6:04:01 a.m.?
There were no more steps or flight climb or any other health activity recorded during that time.
until 6:04 steps
Do you
started.
know what triggered movement
Is what I
at
understand.
6:04:01 a.m. of Mr. O'Keefe's cell phone?
I presume that the device was moving at that time, but I don't know the details of who.
Objection, Your Honor. Move to strike.
I'll strike it.
I don't
continue.
see that being a problem. Why are we striking
Regarding
that?
the flight climb events, looking at the cache encrypted C database, I was able to find more granular, accurate timestamps for these records. And I showed those timestamps on this map at the position that the device was, according to the location data at the time.
So you're going back to earlier in the evening now, 12:22:14.
Correct.
To 12:24:37 when the phone stopped near the flagpole.
Correct.
Okay, thank you.
So we have the first record at 22:17, a flight climb event was recorded. I've highlighted that was a red line, and that equates to the red line that shows underneath the timestamp where the location was, where the device was at that time. The second record is 22 minutes and 32 seconds, showed with a green line, which shows over here. And then finally, 24 minutes and 37 seconds after midnight, shows with an orange line down here outside 34 Fairview. I'd like to point out that health activity events are recorded upon the event completion. The device doesn't know that you're about to walk up some stairs. It doesn't know that you're halfway up some stairs. It has to wait until you've reached the top in order to detect that an altitude change has occurred. So that change only gets written to the database once the flight climb has ended. I tested approximately 8 different phones, different models, different versions of iOS, and found that on average, there was a time difference between 15 and 50 seconds between when I physically stopped walking up a flight of stairs and when the record was made. So it's just based on the time that the device takes to pull the altitude, detect that an altitude difference has occurred, and then write the data to the database. So then I took that average data between 15 and 50 seconds and plotted it onto this graph, which also plots the altitude of the device over time. So the red line here shows the time according to the cache encrypted C database where the first flight climb event was recorded at 22 minutes and 17 seconds. Working back 15 seconds from that to say that with the gap that I know exists between the flight climb ending and when the record's recorded, the flight climb event is presumed to have occurred within this red gradient area. The altitude information on the device shows that between those times, the altitude increased from around 41 meters to around 45 meters. You may recall earlier I said that it's a 3-meter incline that Apple considers a flight climb event. Therefore, the incline that occurred within this red gradient is sufficient to trip a flight climb event. When we look at the second record at 22 minutes and 32 seconds, this is shown on this chart as a green line. And again, working back 15 seconds and beyond to allow for the tolerance, we see the green gradient area. This shows an altitude change of around 45 meters to 48 meters. Again, that would be sufficient for a flight climb event to be recorded because we have 3-meter incline change. We then don't see an incline change for a while. All we see is the device going downhill until we get the record right at the end there at 24 minutes and 37 seconds. And again, working back around 15 seconds to the orange gradient, we see an increase from around 25 to 28, 29 meters. Again, that would be sufficient to cause a flight climb event to be recorded.
I'd like to ask you.
Sorry, I'll go back.
Continue, and then I'll ask you, please.
Okay. I then compared that information to a topology website from the area according to a topology website data and plotted that out here. We see the red circle now is related to the first flight climb, the green circle to the second flight climb, and the orange circle to the third flight climb. The gradients that we see here are the same gradients that were shown on the previous graph. So the presumption is that within this red gradient is where the flight climb event occurred. Within the green gradient here is where the second flight climb event occurred. And within the orange gradient here is where the third flight climb event occurred. The white circles show the altitude of that particular location according to the topology website. So again, we see that for the red gradient, there's an increase from 43 to 47 meters. Between the green gradient and the green number 2, again, we're going from around 47 to 50 meters. And then with the orange gradient at the bottom, we've gone from around 26 to 28 meters. So fairly consistent with the data that was recorded on the device in terms of altitude information. And I would suggest is the reason that these flight climb events occurred.
Mr. Whiffen, there's 3 different times. The first is 12/22/17. At that time, was the WAZE data app initiated?
It was.
And did that indicate whether or not Mr. O'Keefe or his phone were traveling in a car at that time?
Appeared to still be traveling in a car.
At 12/22/32, was the WAZE data initiated and active?
It was, yes.
And at that time, does the data indicate that Mr. O'Keefe's phone was in a vehicle and moving?
It does.
And you showed us a slide finally from 12/24/37 that the vehicle was still moving 1.4 miles per hour.
Correct.
And was the WAZE data initiated and active at that time, 12/24/37?
If I remember correctly, WAZE had closed about 5 or 10 seconds earlier.
Now, based on your study of the WAZE information, the location information, the topography, and the healthcare data, do you have an opinion to a reasonable degree of scientific certainty whether the indication on the healthcare data reflecting flights of stairs, do you have an opinion whether or not that was registered as a result of a person holding a phone, walking upstairs, or for some other reason?
Based on the location data, the health data, and the research that I did and the testing, I believe it is more likely that the device was in a vehicle traveling on a road going up an incline versus the location data being incorrect and the person being walking up physical stairs.
Thank you. You can continue, please.
Okay. So I'll address the idea of 3 clocks, which I believe was brought up previously.
Let me interrupt.
Sorry.
Yes, because you're going to narrative now.
Why don't we just explain to the jury how clocks work in an iPhone?
That is kind of covered in the next slide anyway.
Okay.
It may be worth just jumping ahead to that slide.
Explain the idea of 3 clocks.
Yes. Essentially, there is one clock on an iPhone. It's the clock that you see. It's shown in the top corner, and all activity is related to that particular time. So when you receive a text message, the time that's shown in the database is related to the time that you can see on the phone. When you do health activity, it's related to the time that you see in the top corner of the phone. Everything is related to that time. The difference is within the current PowerLog databases. It's a subset of files stored on iOS devices. They use what's called a monotonic clock, but it's not a clock that can actually be trusted to see when events occurred. It's the way that the device records time. It's essentially a counter that's just counting seconds since the device was reset, basically. And I'm sure most people can recall a time where you would set a clock on a digital device, come back to it 3 or 4 months later, and the clock's now not quite as accurate as it was when you left it. Time starts to drift. It might drift forward and be faster. It might drift slower and be further behind. That essentially happens with the monotonic clock as well. So you have to take the values that the monotonic clock provides and add or subtract different values, which are essentially offsets, in order to get the accurate time. And that's what I'll be displaying in this slide here. The confusion with the idea of 3 clocks, I believe, comes from the way that Magnet Axiom product displays PowerLog data. They show a monotonic date and time, a baseband date and time, and a display date and time within the PowerLog records. As an examiner, it's really good to see this data and understand how the tool is determining these values. as an examiner, it would be really bad to look at these values and think that they are accurate timestamps at face value, because they aren't. And I'll start to talk through how this information works. So the other thing that Axiom shows, as well as the monotonic baseband and display times, is they show the location where this information came from. In this case, we have two tables. One is called PL Springboard Agent Event Forward S Block. And that is what this table is here. And you can see we've got an ID number, a timestamp, and a value of locked. But we also show a second table that's involved called PL Storage Operator Event Forward Time Offset. And that's this table at the bottom here. So again, we see there's an ID, a timestamp, baseband, kernel, and system values. These values all need to be read together in order to make sense of the data. So for example, if I take the timestamp that's shown here, the 1643 33687 number, if you treat that as number of seconds since the 1st of January 1970, it's what we call a Unix epoch. That will get you the timestamp of 29th of January 2022 at midnight, 21 minutes and 27 seconds, once you account for the UTC -5 offset. And you'll see that that is the same timestamp that Axiom shows here as the monotonic time, 12:21:27. What we need to then do is take that monotonic time and add it to the baseband value that we see in the time offset table. So now we have a value of 1643, 3687.14954, and we add minus 183 point whatever this number is here to get this value. If we treat this value as number of seconds since the 1st of January 1970, then we get a time of 18 minutes and 23 seconds past midnight on January 29th, which is also the time that we show here as the baseband time. Finally, we can take the monotonic time and add the minus 181 seconds shown in the system to get this value, which equates to 18 minutes and 25 seconds past midnight on the 29th of January, which is the same as the display time up here. So all this is essentially doing is saying that the counter that is built into the iPhone is registered the time of that we see in the top, the monotonic time. This is not necessarily the time that the event happened. You have to offset it with this value here in order to get the actual time that this happened. My own personal phone, when I was doing this testing, the time difference between the monotonic time and when something actually happened was over 2 weeks. There was a massive difference because my phone has been drifting so far since I originally bought and set up that phone. And again, when I was testing this, I can turn the flashlight on, turn the flashlight off. Both of those activities are recorded in the power log database. If I just look at the monotonic time, it's off by over 2 weeks. If I do this process to calculate the correct offset, it shows exactly when I turned that flashlight on and when I turned that flashlight off. The calculation is imperative. Without the calculation, these timestamps are irrelevant. And all Axiom is doing here is they're showing you the values that they use in order to calculate the final value. It doesn't mean that you can take the monotonic timestamp and read anything into it. It's completely irrelevant on its own.
Is it necessary to understand this process in order to ensure the integrity of the time that you're offering to the jury so you understand whether it's accurate or not?
It would be if we were discussing power log data. Power log data only really encompasses things like battery level, the time and date that it's plugged in, button presses, camera usage, things like that. It doesn't count for location data. It doesn't count for Apple Health data. They both work on the system time. And they both work on the same system time. So they're always going to be aligned.
Do you have an opinion to a reasonable degree of scientific certainty as to the accuracy of the location data times and the accuracy of the health data times that you shared with us?
They'd be consistent with each other.
Your opinion is they're consistent with each other?
So to summarize that, there's only really one clock that's in use on an iPhone for recording. The only difference is the monotonic time, which is how power logs record information, but you need to offset the times to figure out when that activity actually happened. And that you only have to offset those times for power log data, not for health, not for location, not for messages or photographs or any other activity like that, purely power log data.
Okay. Is there another subject that you looked at, that you analyzed in order to reach a conclusion about the time and location of John O'Keefe's cell phone over the night of January 29, 2022?
Yes, the next one is battery temperature.
Can you explain a little bit of background on this before you start?
Yes.
Slides?
So again, we have a temperature sensor built in within the phone, monitoring for if the battery temperature increases too high and becomes a danger, or if the temperature gets too low and becomes an issue. So it constantly monitors the temperature of the battery and records that information in the Knowledge C database.
Did you look into the battery temperatures from before midnight and after midnight and do an analysis regarding the temperatures of that cell phone battery?
I did, yes. Throughout the evening of the 28th of January and then the morning of the 29th.
Mr. Whiffen, that's going to be hard to read. Is there any way you can enlarge it?
But apparently not like that. There we go.
Thank you.
So on the evening of the 28th, see an average temperature of around mid-80 degree Fahrenheit. I've got no understanding of where the device was at this time, whether it was in a pocket on a surface, whether it was in use or not. But I just wanted to get an average idea of temperatures of the device. By 13 minutes after midnight, we're still at 82 Fahrenheit. At 22 minutes after midnight, we know from the location data that the device was currently in a car, and we see the temperature has dropped to 77 Fahrenheit. By 37 minutes after midnight, we now know the device is already at Fairview. It's been at Fairview for approximately 12 minutes, and the temperature has continued to drop. It's now 72 Fahrenheit.
Mr. Whiffen, if I can interrupt you. At 12:37, when the temperature drops to 72 degrees, is that before or after the healthcare data stops for that evening?
That's after.
Thank you.
45 minutes past, the temperature's dropped to 66 Fahrenheit. 53 minutes past, it's dropped to 61 Fahrenheit. 7 minutes after 1, it's dropped to 55 Fahrenheit. 1:36, it's dropped to 50. And then we have a large gap in the data, with the next record being made at 6 minutes after 6 a.m. when the temperature is 43 Fahrenheit.
Mr. Whiffen, if a phone has any protection or coverage, well, let me ask it this way. Do you know what, if anything, happened around 6:02, 6:03 to trigger that 6-degree drop in temperature?
I don't know accurately, no.
Okay. And then you're now at 6:14 and it's 37 degrees?
Yeah, you're correct. This is the coldest temperature recorded.
Do you know what, if anything, happened to that phone at 6:15:01?
I don't know.
Okay, please continue.
And then
6:15:01.
as of that point in time, from 6:35, we start to see an increase in temperature to 43 Fahrenheit. At 6:40, it's up to 50 Fahrenheit. At 6:48, up to 55 Fahrenheit. And at 6:56, up to 61 Fahrenheit. And then also plotted this out onto a graph just for visualization. Again, we can see on the evening of the 28th, the temperature is relatively consistent. It starts to drop as we know the phone is traveling in a car. And by the time it arrives at Fairview, we only see it drop. until 1:36 a.m. We see a relatively modest drop over the next few hours, but no records recorded. We see the final drop at 6:14, and then we see an increase, but there are no increases occur prior to 6:14 that would suggest that the phone went from a cold environment to a warm environment or had extensive usage.
The Commonwealth
Between
thinks this is
1:36
helpful.
a.m. and 6:06 a.m., is there any indication at any time that battery temperature went up?
No, there's no records related to battery temperature at all for that time.
Thank you.
How-
Is there
how is
another
this
area that you looked
helpful?
at for your conclusions in this case?
Yes, I was looking at device usage.
What is device usage?
Information about when the user unlocks the phone, what applications they're using, what they're using the device for, and when they lock the phone again.
Would device usage require an actual person to interact with the phone, or can it happen without user interaction?
Everything that I was looking at was related to physical interaction and manipulation of the device by a user.
Please continue.
So the three sources of data that I used for this were Knowledge C, a database I mentioned earlier that logs lots of different activity, including device unlocks, device locks, applications that are on screen. The Current Power Log, which I mentioned, which can track button presses. So specifically when the lock button is pressed and the times that I display have been offset appropriately. And Unified Logs, which is essentially a list of almost everything that's happening on that phone for a short amount of time. But it would be used, for example, if you had a problem with your device, took it back to Apple because it was crashing all the time, let's say, they could look at the unified logs and figure out, well, what's causing these crashes to occur. So really granular. We see that at 12 minutes and 52 seconds after midnight, the device is unlocked using biometric Face ID. The SMS application is on screen for about 5 seconds before it's closed, and then the user presses the lock button at the side of the device to lock the phone. At 13 minutes and 54 seconds, biometric Face ID is used again, and the SMS application is opened. And at 14 minutes and 29 seconds, the lock button is pressed again, causing the device to lock. 15 minutes and 46 seconds, the device is unlocked using Face ID. The SMS application is already on screen because that's the application that was on screen when the device was locked. And the device is locked again at 16:03. At 17 minutes and 59 seconds, the device is unlocked again using Face ID. The SMS application is still on screen from before. And at 18 minutes and 12 seconds, the lock button is pressed, causing the device to lock. At 18 minutes and 25 seconds, the device is unlocked using Face ID. The SMS application is already on screen from the previous usage. And at 18:31, the SMS application is closed. At 18:34, the phone application is opened by the user actively pressing on the phone icon on the home screen. At 18:36, they're now in a call, and this causes a different screen on the phone. And at 19:23, that phone call ends. At 19:29, the WAZE application is opened by the user pressing on the icon on the home screen. And that's open for approximately 5 minutes, closing at 24 minutes and 26 seconds. 2 seconds later, at 24 minutes and 28 seconds, the device is locked by the user pressing the lock button on the side of the phone. At 24 minutes and 59 seconds, the device is unlocked using Face ID. The SMS application is opened using the icon on the home screen. And at 25 minutes and 9 seconds, the lock button is pressed by the user to lock the device. At 27 minutes and 45 seconds, the device is unlocked using Face ID. The SMS application is already on screen. And at 27 minutes and 50 seconds, the device is locked using the lock button. 29 minutes and 52 seconds, device is unlocked using Face ID. SMS application is already on screen from the previous usage. And at 29 minutes and 53 seconds, the lock button is pressed to lock the device. 32 minutes and 4 seconds, the device is unlocked using Face ID. SMS application is already on screen from the previous use. And at 32 minutes and 9 seconds, the lock button is pressed by the user. And that is the final interaction with the device. It's the final unlock of the device using Face ID, and it's the final logged button press on the device as well to lock the device.
So the final interaction with John O'Keefe's cell phone that night?
Correct, up until 6:15 a.m.
In 12:32:09 was the last time before the phone moved again the next morning?
Correct.
Is there one more area that you engaged in analyzing to help reach your conclusions in this case?
There is. During my time looking at the unified logs that were mentioned, I found a record that appeared like it could be interesting that was called Doppler. This was the pocket state that I think I mentioned earlier, and it detects when the user takes the phone out of a pocket, or at least removes the item that's blocking the camera. There were hundreds of thousands of records within the unified logs that I was able to filter down to just the Doppler records and to filter and aggregate down into a more digestible number, which is what's shown here. So again, whenever the device receives a phone call, or whenever the device is picked up in a particular way, the camera activates and it actively looks for a face. If it finds that the camera is blocked, it records the fact that it's in a pocket state, and it will continue to record pocket state until either the obstruction is removed, so the device has been removed from a pocket, or until whatever is calling for the Doppler check to be completed. So for example, if I make a phone call, it will continue to check and look for a face up until the phone call ends, or the ringing ends.
Cleared at
So in this case, at 12
a.m.
minutes and 37 seconds, see a small amount of time where 4 Doppler checks were conducted. And that ended at 12 minutes 37 seconds with a pocket state cleared event. At 12 minutes and 39 seconds, there was a 7.5 second period where 108 Doppler checks were conducted. Again, that ended with a pocket state cleared event at 12 minutes and 46 seconds. At 25 minutes and 8 seconds, there was a single Doppler check that resulted in a pocket state. And at 29 minutes and 37 seconds, for 5.5 seconds roughly, there were 97 Doppler checks. The 97th check resulted in a pocket state cleared event at 29 minutes and 42 seconds. At 31 minutes and 52 seconds past midnight, there was an 11-second period where 155 Doppler checks were made. The 155th Doppler check resulted in a pocket cleared event at 32 minutes and 3 seconds. At 33 minutes and 14 seconds was the start of a 5-hour and 20-minute period where 26,500 Doppler checks were conducted. Every one of those checks came back to say that it was in a pocket state. There was never a pocket state cleared event during that time.
Yes, it was.
At 2 minutes after 6 a.m. And 41 seconds, there was a 12-minute period and 20 second where 417 Doppler checks were conducted. The 417th Doppler check showed a pocket state cleared event at 6:15:01.
Mr. Whiffen, as a result of your analysis of John O'Keefe's cell phone, considering the location data, including WAZE data, and considering the healthcare data, the pocket state information, the battery temperature, did you have an opportunity to create a timeline putting all of these different important pieces of data together so you could show them to the jury in chronological order.
I did, yes.
Would you share with us now your timeline and explain it for us?
Of course. So again, this combines all of the information from the previous slides, just showing it all within a timelined view. So at 18 minutes and 25 seconds, the device is unlocked using Face ID. We see the SMS application is in use. For around 11 seconds, a phone call is made from John to Jennifer McCabe. A phone call lasts 36 seconds, starting at 18 minutes and 47 seconds. That call ends at 19 minutes and 23 seconds, and the mobile phone application is closed at 19 minutes and 24 seconds. At 19 minutes and 29 seconds, the WAZE application is loaded on screen. And at 20 minutes and 49 seconds, which is what this location on the side relates to, we see an incoming message from Brian Higgins saying, "You coming here?"
Oh, that's new.
At 22 minutes and 14 seconds, this is the start of the 3 flight climb events. As the device is driving along Oakdale Road, I believe that one is. At 24 minutes and 26 seconds is when the WAZE application is closed and the device is locked via the lock button at 24 minutes and 28 seconds. At 24 minutes and 37 seconds, the three flight climb events comes to an end. And at 24 minutes and 38 seconds is the first record that shows a speed of 0 meters per second. At 24 minutes and 59 seconds, the device is unlocked using Face ID, and the message, "You coming here," is read at 25 minutes and 8 seconds after midnight. At 25 minutes and 9 seconds after midnight, the device is locked using the lock button. At 27 minutes and 33 seconds after midnight, a text message is received from Jen McCabe saying, "Here." At 27 minutes and 45 seconds after midnight, the device is unlocked using Face ID, and the "Here" message that was just received is read at 27 minutes and 48 seconds. At 27 minutes and 50 seconds, the lock button is pressed by the user, causing the device to lock. At 29 minutes and 37 seconds, we start to get some Doppler checks, and at 29 minutes and 42 seconds, the pocket state cleared event is written. At 29 minutes and 44 seconds, there's an incoming call from Jen McCabe. This is answered and lasts for 7 seconds, ending at 29 minutes and 51 seconds. At 29 minutes and 52 seconds, the device is unlocked, and a second later, the lock button is pressed, causing the device to lock again. 31 minutes and 47 seconds after midnight, a message is received again from Jennifer McCabe saying, "Pull behind me." And at 31 minutes and 52 seconds, the Doppler check records a pocket state. At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. And at 32 minutes and 3 seconds, there's a pocket state cleared event. At 32 minutes and 4 seconds, the device unlocks with Face ID. And again, I'll point out that makes perfect sense if the Doppler state clears, because it's no longer within a pocket, and then it unlocks a second later. That makes sense with the logic that's been identified. At 32 minutes and 5 seconds, messages applications on screen, and the message "Pull behind me" is read. At 32 minutes and 9 seconds, the messages application is closed, and the device is locked for the last time. At 32 minutes and 16 seconds, the 36-step health event is ending. At 33 minutes and 14 seconds, we have the first of the 26,500 Doppler state records that all record pocket state. This is followed by several phone calls at 33 minutes and 35 seconds, 34 minutes and 9 seconds, 34 minutes and 38 seconds, 35 minutes and 9 seconds, 35 minutes and 35 seconds, and 36 minutes and 9 seconds. All calls from Karen. Call were all unanswered, and all resulted in pocket state being detected by Doppler. At 36 minutes and 9 seconds, and again at 36 minutes and 40 seconds, 2 more phone calls received from Karen, again showing unanswered calls and resulting in a pocket state being recorded by Doppler function. 37 minutes past midnight, battery temperature has dropped to 72 Fahrenheit. And at 37 minutes and 8 seconds, a further phone call, again unanswered, again resulting in a pocket state recorded by Doppler. 37 minutes and 31 seconds, a 3-second voicemail received from Karen. And at 38 minutes and 21 seconds, another incoming call. And at 38 minutes and 26 seconds, another incoming call, both unanswered, both resulting in Doppler's pocket state being detected by Doppler. And I've also showed some of the locations that were recorded at around this time by the device. 40 minutes and 31 seconds, a message received from Jennifer McCabe saying hello. This is the first iMessage or SMS message received by the device, which is unread. This is followed up 2 minutes later, 42 minutes and 9 seconds, by another message from Jennifer McCabe saying, "Where are you?" And at 42 minutes and 35 seconds, there's a 40-second voicemail received from Karen. 43 minutes past midnight, the battery temperature has now dropped to 66 degrees Fahrenheit. At 45 minutes and 53 seconds, another incoming message from Jennifer McCabe saying hello. And again, we can see location data at 53 minutes and 7 seconds, placing the device on the front yard somewhere kind of around the flagpole area.
Let's get our sound back. Are we going to get the sound back? Oh, it's going to be one of those mornings, it looks like. I do have, let's just go ahead and switch over then. I do have the link for NBC. They are still up, so let me pause that. Hang on a second. Get us back to where we were. Okay, here we go. Share this
Karen
instead.
saying your kids are cooking alone.
Mr. Whiffen, based on your analysis of John O'Keefe's cell phone, keeping in mind some of the data points you shared with us, that WAZE was initiated around 12:19, that the car reached the flagpole around 12:24:37, that the only health data during that later time near 12:30 was from 12:31:56 to 12:32:16.
Sorry, I'm trying to move the
That the last
captions.
interaction was at 12:32:09, followed by an overnight pocket state, and an increased reduction in.
Objection, Your Honor.
So I need to hear the question first.
Let him get all the
including a
leading stuff out.
increased reduction in the battery temperature. Do you have an opinion, to a reasonable degree of scientific certainty, that after that phone stopped in the car at the flagpole area of 34 Fairview, whether or not that cell phone remained near the flagpole the entire night until after 6 a.m. the next morning?
Objection, Your Honor.
I'm going to allow it.
The location data The location data that shows accurate tends to show around the flagpole area. There's no further health data other than 36 steps that were taken that suggest that it moved after 32 minutes and 16 seconds after midnight. The battery temperature data never indicates that the device went from a cold environment to a warm environment, which I would expect to see if the device went inside a building. And the Doppler state information suggests that the camera was blocked for at least the majority of the 5-hour period, with no records showing that the camera was unblocked during that time, which would typically happen if you were to pick a camera up and move it around.
Does that lead you to a conclusion to a reasonable degree of scientific certainty?
Yes.
Whether that phone remained in the flagpole area from around 12, 24, 33,
So
until the next morning at 6 a.m. or after?
That's
the
my opinion.
objections sustained. Ask the question in a different form.
Do you have an opinion where John O'Keefe's cell phone was from around 12:24:33 on the evening of January 29,
Didn't you just answer that?
2022 through at least 6 a.m. and after that morning?
Yes, based on the totality of all of the information that we've described, my opinion is that the device never moved far away from the flagpole.
I have no
Never
further
moved
questions.
far
Thank you.
away.
All right. Mr. Alessi?
May we approach Your Honor, please?
Okay. Jurors, feel free to stand up.
It never moved far away. Well, how far is far away? Is inside the house far away? We saw it inside a number of those location measurements. What even is that opinion? There is so much qualifying of the way he states his opinions, very careful phrasing of certain things. I don't know, guys. I'm thinking we have a timeline issue here. Because something happened at 6:02 to start dropping the temperature of the phone. Is that when that's not when Carrie said she picked it up. She said she picked it up after the first responders got there, which was significantly after 6:02.
Okay.
And we've got steps. We've got steps.
Mr. Whiffen, I should have told you, you can feel free to stand up and stretch if you want to as well.
432 steps at 6:04, well before the first responders got there. So Carrie's story is not adding up. Oh, first Alessi Cross. Let's see it. Getting good and organized at that podium. That's what I like to see.
Thank you, Your Honor. May I proceed with the
Yes.
administrative matters? May I approach?
Yes.
Thank you.
Administrative matters.
Your Honor, pursuant to a stipulation with the prosecution, I would like to mark and enter into evidence 3 documents. These are each portions of a March 2025 report prepared by Mr. Whiffen. The first one,
So, yes, they can come into evidence. They can come into evidence. There's a stipulation. So
And
we
so-
can mark it as the next exhibit.
if we can, that's page 29 for the next exhibit.
Want them marked separately?
Separately, please.
Exhibit 40.
Let's just start with sticking pieces of his report in his face.
The next exhibit will be pages 77 and 78 of the same report.
Okay?
Exhibit 41.
The third and last is page 43 and page 44.
Exhibit 42.
Okay, all set.
Thank you, Your Honor. May I, Your Honor?
Yes, please.
Good afternoon,
Indeed.
Mr. Whiffen. I don't believe we've had the pleasure of meeting.
Good afternoon.
Cell phone data, when correct and when correctly analyzed, can help tell a story of what may have happened under various circumstances, correct?
Correct.
And in cases like this, literally seconds on cell phone data can be significant, correct?
Correct.
What I'd like to do is to go back to your PowerPoint presentation and specifically go to the timeline that you had gone through with Mr. Brennan. And rather than repeating everything, there'll be select aspects of the timeline I'm going to reference. And with the court's permission, we will put the timeline back on that's already in evidence.
Okay.
Thank you. So what I'd like to do is to start with page 70, which we have as 78 of the deck. If you could, Mr. Wolfe, go to that. And what I'd like to do, if I could please, Mr. Whiffen, is draw your attention to the very last entry, which says at the bottom, location 122438. And it indicates description, first location record showing speed of 0. Do you see that, sir?
I do.
And this is the arrival of John O'Keefe's phone at 34 Fairview, correct?
Correct.
If we could go to the
I know where he's
next
going.
page, please. We have up at the top, 12:24:59, about 21 seconds later after arrival, we have device unlocked with Face ID, correct?
Correct.
Is it possible for anyone other than John to unlock that device with Face ID?
If a secondary user was set up,
Do you have any indication that a second user was set up on John's mobile phone?
I never looked at that.
I'm sorry.
I never looked to see if a secondary user was set up.
You never looked it up.
In terms of the next entry, 12:25:08, it says, read message, you coming here, with 3 question marks. What I'd like to do, because you did not note who that was from, but I want to go back a
Did.
few
It's from Higgins, just not here.
slides so we can identify who that message was from. We could
Okay.
go back to 76, please, Mr. Wolfe.
Yes.
So in the last line there, message reading left to right 122049, it says message received from someone listed in context as Brian Higgins. Do you see that?
Correct.
So if we could go back to slide 80, excuse me, if we could go back to slide 79, that phone reading the message, you coming here is reading the message from Brian Higgins, correct?
Correct.
But you didn't note that in the timeline that was from Brian Higgins, correct?
No, I was just highlighting the fact that a message was read and that the contents of the message were you coming here.
But you didn't note in this entry when it was read by John that message was from Brian Higgins, correct?
Correct.
Now, the next entry, lock, again, I'm always going to be reading left to right unless otherwise indicated, sir, is a time of 12:25:09. And it says device locked with lock button.
Yes,
You see that, sir?
I do.
That requires human volitional conduct. In other words, someone has to actually manipulate their phone and hit it, right?
Correct.
Now, at this particular point, isn't it correct that in your report that you mentioned in your March 2025 report, that you had more of a description of what was happening at this time with the phone, namely device bearing shifts to a westerly direction as location records also show the device moving west from the roadside towards the house. Isn't that what you had in your report?
Yes, and that's covered in the location section of this report, the PowerPoint.
So there is no statement in this timeline under any type
True.
where you had concluded that at this time the record showed that the device was moving west from the roadside towards the house, correct?
The location latitude, longitude was moving westerly, but at the same time, the accuracy was increasing. So it didn't intrinsically prove that the device was moving.
My question, Mr. Whiffen, is straightforward in this sense, that I'm just looking for an answer of whether on this timeline you included the analysis that you had in your report that the device at this time was moving west from the roadside towards the house. Did you include it in that timeline?
No, I left that out of the timeline.
Next entry, 2733. And that's 12/27/33. You note that there's a message received from Jen McCabe. Here, exclamation point, question mark. You see that, sir?
Correct.
Now, at this point, you have two people in just 2.5 minutes, Brian Higgins and Jen McCabe, trying to find out if John is coming to 34 Fairview. Is that a fair conclusion?
It appears so.
I'll allow it.
Is that a fair conclusion?
It would appear so, yes.
Late
So
objection
just
from
because of
Brennan
the
there.
colloquy that occurred, I want to repeat the question. Now you have, at this point, at 12/27/33, you have two people, Brian Higgins and Jennifer McCabe, in just 2.5 minutes, trying to find out if John or the phone is coming to, or if John is coming to 34 Fairview. Objection.
Sustained. Ask it differently, Mr.
Thank you,
Alessi.
Your Honor. Now,
Same
at this
question.
point, you have two people trying to find out if John is coming to 34 Fairview, correct? Objection.
Sustained.
Mr. Whiffen, in terms of the information at this stage, there are two communications with Mr. O'Keefe on this phone, and that is they're trying to find, excuse me, I'll rephrase it. There are two communications, one from Jennifer McCabe and one from Brian Higgins, correct?
Correct.
Now let's go to the next deck 80, please, Mr. Wolfe. This is 122745, device unlock with Face ID, correct?
Correct.
And then right under that is 122748. It says read message, which it says here. And is it correct that that is the message that was sent by Jennifer McCabe?
Correct. I'd just like to point out it says read message, not read message.
Read message, thank you. And that, the fact that Jen McCabe sent that message and that it was read was not indicated in your timeline at this point, correct?
Sorry, repeat that question.
Yes, you did not, it does not appear in that timeline that you've drafted that message that was read was from Jennifer McCabe, is it?
Correct. Correct.
Next entry, 2750, device locked with lock button. Next entry down that, 2937, Doppler pocket state. And I want to be clear. Does Doppler pocket state mean that someone takes an iPhone? Because up above, there's read messages we went through on 2748. So if somebody reads the message, and then it goes at 2937 into Doppler pocket state, does that mean someone has, for example, put it in their pocket?
No.
What does it mean that's a pocket state?
So the only times that I was able to cause a pocket state to be recorded is when the camera was blocked and when the device received a phone call or was picked up in a particular way so that the device thinks that you're about to try to use it. If the camera is not blocked from the outset, then nothing's recorded at all. And in order to get the pocket state cleared, the camera must be blocked to begin with. So again, you have to receive a phone call with it in your pocket and remove it in order to get a pocket state cleared.
Thank you, because that helped me, because that's exactly where I was going with the next question, which is pocket state cleared. What did you conclude from 2937 to 2942 that it was in pocket state and then pocket state cleared?
There was some activity on the device that caused the pocket state to be checked. The device was in a pocket state up until 2942 when whatever was obstructing the camera was removed.
Next entry is a call at 12:29:44. And that, you state, is an incoming call from Jen McCabe. So there you do indicate the name. And you say answered 7 seconds, correct?
Correct.
Is the phone at this time that there's an incoming call from Jen McCabe that is answered out in front of 34 Fairview?
Yes, it would be according to the location data.
Yep,
Right.
that's a problem for Jen.
So now we have at 12:29:44, the phone's out in front of 34 Fairview. There's an incoming call from Jen McCabe. It's answered. 7 seconds is how long the duration of the call was. Is that correct?
Correct.
And then 12:29:51, incoming call ends, and that's end of that 7 second duration.
Correct.
So you've concluded that this was a call that was indeed answered by the user of the phone, correct?
Correct.
Now let's go to Mr. Wolfe 81, which is starting up at the top of 12:31:47. There is, as you indicate, an iMessage received from someone with a contact named Jen McCabe. You see that, sir?
I do.
Can you just state for the jury what an iMessage is?
An iMessage is essentially a text message sent primarily from iPhone to iPhone via the Apple servers, not like an SMS message which goes through carriers.
And is it correct that the message that was received from Jen McCabe said, from a contact of Jen McCabe, says, "Pull behind me"?
Correct.
And then at 12:31:52, we're back to Doppler pocket state, correct?
Correct.
Now let's go to the next entry, which is Dec 82. It's under health type. And what I want to do is see if we can clarify. The Commonwealth on direct examination, and multiple times referred to this as healthcare data. Do you remember hearing that healthcare data term?
I do.
Is that a correct term? Is it healthcare data or is it health data?
It's health data.
So it's incorrect to refer to this as healthcare data, correct?
Healthcare data is encompassed within Apple Health, but primarily if we're talking about steps being taken, it would just be health data.
Right. So the correct parlance is health data,
Yes.
correct? Particularly when we're getting to steps. Is that correct?
Correct.
It's important to be precise about the parlance.
Yes.
So in this entry, 12:31:56, you state that there's the start of health event, quote, 36 steps / 25 meters, correct?
Correct.
Is it accurate to say that because we're in the United States and we don't work on the metric system, that 25 meters is about 84 feet? Are you able to make that calculation?
It's approximately that, yeah.
Right. Would you accept approximately
That makes
84
sense.
feet? So as we discuss meters, we can go to feet and
Yes.
about 84.
I would accept it approximately 3 times 25.
Right.
But
So in your report of March 2025, isn't it correct that for this time, you stated that the device began moving for a period of 20 seconds, correct?
yes.
So again, your conclusion from your analysis is with these 36 steps, the device at this point began moving, correct?
Correct.
Next entry, 12:32:03. Pocket state cleared, correct?
Correct.
So does that mean that there's some human activity going on, interaction with the phone, or not?
It could have been a received phone call. It could have been movement of the phone to be lifted.
But something has happened.
But something's
correct?
happened, yeah.
Next, 12:32:04, device unlocked with Face ID, correct?
Correct.
And then at 12:32:05, it states application focus messages.
Yes.
Can you clarify what that means in terms of what is happening with the phone for the jury?
Yep. So at 32 minutes and 5 seconds, the messages application was in focus on screen. So it was the application that was being used by the user at that time.
Now, the next entry is message 12:32:06, and it states red message, quote, pull behind me, close quote, correct?
Correct.
Now, you don't indicate who that message is from in your timeline, but that's the message that was sent by Jennifer McCabe at 12:31:47, correct?
Correct.
Next entry is application lock at 12:32:09. And you've got here end application focus. And then you state device lock with lock button for the last time, correct?
Correct.
So that's again pressing the side button on the iPhone that locks it.
Correct.
And that requires human conduct, human interaction with the phone, correct?
Correct.
And then the next entry under health data at 12:32:16, that is 7 seconds after the lock. It's the end of the health event of 36 steps, 25 meters, and as we agreed, approximately 84 feet, correct?
Correct.
Remarkably
So-
agreeable.
In terms of the steps,
Mm-hmm. Yes, let's talk about the steps. Where was he
I
stepping?
want to turn to some further information with regard to your previous, the report that you mentioned on direct, which is the March 2025 report. Your Honor indicated a time for the break, and I'm going to go into a little bit of different area. Would you like me to keep
All
continuing?
right, Mr. Alessi. Folks, we'll stop.
Taking lunch.
Turn on lights, please. Mr. Whiffen, we need you back here. All right. Jurors, we're going to recess for the day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. And please be very careful with your social media use. All right? We'll see you tomorrow morning.
President Jury, right this way. Keep your notebooks on the
I'll see counsel at sidebar.
Sidebar. I'll just mute it in case they come back and do anything. We can come back. Yeah, so Mr. Alessi here, he is starting to pick on issues with the timeline and that I think are going to be important. Some of them are going to be followed up on. First, the little interesting concession about did John have another user set up on his phone? He doesn't even know. He didn't even look. He didn't even look to see who can face unlock John's phone. Didn't even look to see that. But you know, we're gonna make inferences about activity without having verified that simple fact. I'm not saying there is anybody else or that it even matters, but just in terms of you know, your verification of your opinions, you know, your research, the thoroughness of what you did here, that wasn't a great start. Wasn't a great start. I didn't even look up see if there was another user ID in the phone. Odd explanation here for why even though he put in his report that at 12:25, sometime after 12:25:09, the device shifts westerly, the bearing, as the device moves west from the roadside. And that because that came from the location data. We saw him plot that out. It got closer and closer to the house. And he's saying, well, the accuracy was increasing. So that didn't intrinsically prove the phone was moving. This is a very odd explanation. It seems to be like what he's trying to say is this whole argument that, oh, it starts off imprecise, but then with time it will get more precise. It doesn't explain why he put it in his report that it was moving and now has like revised that in his testimony. Well, it doesn't necessarily mean that it was moving. But also, if the accuracy is increasing, doesn't that make it more likely the phone was moving? If it was getting less accurate, then those individual measurements are less precise. But if it's more accurate, you're getting more precise measurements. Doesn't that mean we can rely a little bit more on what those measurements are? Very, very strange explanation here. But 12:25-ish phone moving is a problem. That is a problem for the timeline. Then starts getting the messages. that message from Higgins, all that. Okay, the 12:29:44 phone call from Jen McCabe that was answered for 7 seconds. They're highlighting this, and they're highlighting the phone is in front of 34 Fairview at this time because Jennifer McCabe's explanation for this phone call was that it happened while they were en route and they called and she gave directions. Remember, this is when the timeline that Jen McCabe is presenting has it's about 15 to 20 minutes later than they're going with now, right? That it was about 12:45 when she sent that last text, and that's when Karen's car drove away. Problem then came up during the first trial. Karen's phone connected to the Wi-Fi at John's house at 12:36 a.m. She was not outside Fairview connecting to his Wi-Fi. She was already long gone. So the timeline shifted, but the explanations don't account for that. So you are not giving him directions to 34 Fairview at 12:29 if he's already sitting outside the front of 34 Fairview. So that's why he's pointing out that this is what Ian Whiffen's theory is, because it's not going to correspond with the rest of what the evidence has established and what the witnesses have previously testified about. Then the 36 steps start at 12:31 and they finish at 12:32. And while he is in the course of taking these steps, pocket state cleared, meaning there's some type of movement. The phone comes out, it's unlocked. Messages are being used. The message is read, pull behind me, and then it is locked with the phone. And then 5 seconds later, the steps end at 84 feet. This is very important because if we're going to try to explain health data being recorded because of just unrelated things that are happening. I'm riding in the car, but I'm holding my phone, so it's recording steps. They're trying to hold the door open to explain these 36 steps as being John being hit by the car. That's what they're trying to do, but that's not going to work with the user activity that's going on between the time that they start having this movement and when it finishes. So that's where I think Mr. Alessi is going with all of this. Oh, man. Did I cover everything that I really wanted to go over from his direct? One thing I did notice, I'm just going to go back through some of these notes. Okay, spent a lot of time on the location data and doing this map of travel and associating that with the timestamps. Okay, when he went and talked about the monotonic clock, he said that only matters if you're looking at the power log data. For the other services in the phone, they use the same clock, the operating clock, and so their reports will correspond. But if you use the monotonic clock that's in the power log, you have to do this correction to accommodate for that. What I seem to recall from the first trial, if I remember correctly, and I assume we'll get to this either on cross or just when we get to the defendant's case in chief, there's an issue with WAZE and WAZE's time being on a monotonic clock, if I remember correctly. So it doesn't record activity at the same time that the Apple stuff records activity. And so if these location measurements are coming from WAZE, if that's the whole issue, WAZE is wanting to use the phone, and so it's requesting location services, and then those are being provided. The issue here is going to be, is the location data that he's reporting, is that on the Apple phone clock that you're saying is accurate, or is it on the WAZE phone, the WAZE clock that we learned from the last trial is not? Because that, again, is going to shift the timeline as well. So that's just a piece of something that that we remember coming out from last time. They haven't addressed it here. Okay, so it's not a surprise. I'm kind of intrigued by the fact that they didn't mention that, you know, to preemptively address if there is an issue with WAZE's clock. And if not, why not? Because it came out at the last trial. You know, it's going to probably come out at this one too. I don't know. We'll have to see how all that plays out, but just not making a little mental note out here. I remember WAZE being an issue from the first trial. They didn't really address it in this trial at all. And so is that something that's coming up? Is it being dropped? I don't know. Tagged, marked for future reference. Big note there. What about the clock difference? I definitely noticed that when he's trying to show the elevations on the topo thing that he looked up. Okay, no information about this source at all. Like, where is their information derived from? How do you know it's accurate? How accurate is it? Nothing like that at all. He just looked at a topo website to get altitude measurements. The one that stood up is the last one, the very last one, that showed a difference between what he described as 26 meters and 28 meters. That's only 2 meters. And he said previously in his testimony, if Apple is going to register a flight of stairs, it requires 16 steps over 3 meters. There aren't 3 meters here. So it shouldn't register a flight by your own explanation. Maybe, you know, it's not exactly 3 meters. Maybe, you know, maybe your topo isn't all that accurate. I don't have an explanation for that discrepancy, but it is one. 26 to 28 is only 2 meters. According to your testimony, that should not cause a flight of stairs to register. The temperature drops were quite interesting, I thought. This steady temperature of 50 degrees between 136 and 606. 606, then it drops to 43. I don't know when did that start dropping? Like when? Looks like it started happening at 6:02 to 6:03. The temperature starts dropping and it drops rapidly 7 degrees. And then by 6:14, it's all the way down to 37. So you got this rapid drop off. And then after 6:14 is when it starts warming up again. So after 6:14, that's consistent with stick it in the pocket and start walking around with it or whatever. But 6:02, 6:03, what happens to trigger the drop in temperature? Is that when they get to John? Did they turn him over or not? If he's supposed to still be lying under the on top of the phone, why would the temperature change? Jen McCabe in the 911 call, you might remember from the last trial if you watched it. She says on the 911 call that they turned him over when they found him. But Carrie Roberts has already testified, and she has testified they found him on his back. And she said nothing about turning him over. So what happened? What happened when they first got there to cause this big temperature drop? Don't know. Doesn't really fit the story that we've heard so far. And then from there, we got into Mr. Alessi's Cross, and we have talked about the points that he's eliciting on that so far. So I guess we're going to get back to this probably tomorrow because, ARCCA is going to be is supposed to be in the afternoon. Guess we'll find out when we get back in. Apparently, Turtle Boy says a juror is being questioned at the sidebar. Well, no wonder they're not showing us the courtroom then. Already? Huh. Already having some issues to inquire of a juror? That's not a good sign. That's not a good sign. I wonder what that's about. We won't know because these sidebars are impounded, right? So I don't know that we'll get to find out. Other folks are apparently reporting this as well. So day 5, and we're questioning jurors at sidebar is not awesome. Guys, we got a lot of questions and comments in the queue. I'm going to start working through them because I am going to have to take, fingers crossed, a little bit of a longer break today. It's been very windy here. And the one thing, it's heat is not so bad for the bone's eyes. They'll just go dormant. They go dormant above like 95, 96 degrees or something like that, real similar to what they do in the winter. But wind will suck the life out of your bone's eye trees. Just, a lot of evaporation and stuff like that. So I got to monitor watering a little bit more carefully when it's windy out. Oh yeah, these are not on the sprinkler. Okay. The trees are not on the sprinkler. The trees get individualized attention because, as I've said, they are the most demanding pets I've ever owned. And they want water when they want it. And if they don't want it, they don't want it. So you got to kind of be checking in to see, are you at a point where you want water right now? So anyway, I will need to do that. Let's get through some of your comments and questions. Michelle Johans 1, love your coverage, Andrea. Today I'm writing an exam and I'm so glad that I can listen to you in the background. Well, you have amazing divided attention if you're able to do both of those things. I wouldn't be able to focus, and so I will take it as a testament to your skills and or a compliment to just the pleasant tones of my voice, the cadence, the calmness. I'm maybe not so calm all the time, but I don't know, these things you folks bring up from time to time. I'm pleasant background noise. I really do appreciate that. So thank you for being here with us. Michelle, is Jen's 911 call coming in? Dispatch asked about his condition and she said they just flipped him over so he wasn't found on his back. That's the question, and isn't it? Who is telling the truth and who isn't? We just mentioned this, talking about that whole issue of what was going on with the phone at this point in time. Carrie said nothing about flipping him over. She's pretty clear. They found him on his back. He had snow on him. They cleared it off, and it's his face. So nothing about finding him on his front and having to flip him over on his back. If something like that had happened, maybe that would expose the phone. Maybe that's the explanation. But why didn't Carrie tell us that that's what happened? Why didn't she tell us that? Did that happen? Not according to her. So, yeah, that's an issue. And yes, as far as we know, her 911 call is coming in. It came in last time. It's typically admitted as a exception to the hearsay rule. 911 calls come in all the time as present sense impressions or excited utterances. These various ways that even though it is hearsay, it's her, Jen McCabe, talking out of court, and Jen McCabe is not a party opponent. The justification we see for bringing Karen's statements in, that exception doesn't apply to her, but other ones typically do. Kevin, Honky Breenan's spell checker takes a bolder person than me to leave that rock there. Sorry, that's a good pun. Good pun. I like it. Kevin, Honky Breenan's spell checker. Are there grounds now to stay the trial pending an investigation given the seriousness of the allegations? Will the defense want to? If this again is in regard to the rock, depends on how serious they think it is and, how far they want to go with it. Do they want a mistrial, at this point? I don't know. I guess it would depend on the reason, right? If this is something that the Commonwealth has coordinated, we can prove Commonwealth sends somebody to stick a rock out there on the front lawn of 34 Fairview, so that the jury sees it and gets a misleading impression. Well, then I think we got a lot better chance of the case not coming back for a retrial at that point, because this is not just a thing that happened. This is the Commonwealth engaging in the type of activity that is intended to provoke the defense into having to ask for a mistrial. You're typically not going to get the double jeopardy protection in that situation, where you get to blow up the trial, and if it's not going your way, and then get a second bite. No, that's not how it works. If you blow up the trial, you're typically going to pay the consequences of that. So if they have reason to suspect that, then yeah, they might ask to stay it. They might ask to do an investigation. Maybe that's what they're talking to the juror at the sidebar about. I really don't know. We'll find out. Lousy David, no court on weekends made my hospital stay a real drag, but at least I get to join y'all this morning. Yeah, man, weekends are different. If I'm fine. I got so much on my table right now. I didn't have time to really watch much of anything. Barely able to kind of keep up with stuff on X as it's coming out. But if you're in the hospital, man, you just want nothing else to do but something to pass the time. How do we kill time so that it passes? Yeah, it would be nice. Would be nice to have the trial going at that time, wouldn't it? So good for you for enduring that. And thanks for being back with us today. Hope your hospital stay wasn't anything too serious. And I'm glad that you're back with us. Greg, any chance ARCCA can bring a Bev-sized Cannone with them today? I would love it if they did, right? It's not technically responsive to that request. That I shouldn't say request, it's an order. That order that they got to show up and produce these items, because they didn't produce the Cannone in relation to Commonwealth versus Karen Reed. They produced the Cannone in relation to the FBI investigation. So if they are drawing that distinction, they don't have to for that to be in a compliance, but it sure would be cool, wouldn't it? I would love to see this Cannone, and Bev-sized or not. 10 Cat, do we see ARCCA observing? Did we ever get a ruling on expert exclusion? No, we didn't, because Hank Brennan had to think about it. He had to think about it. I'm going to think about it over the weekend. He's not sure what he thinks about whether the experts should be able to listen in on each other's testimony. Part of what that means is that until we have a ruling, Mr. Green is the defense's cell forensic expert. It looks like they have other ones now too, potentially. But he's the primary one. He was at the last trial. If we don't have an order from the judge saying they aren't subject to the sequestration order, then he's not able to sit in and listen to Ian Whiffen's testimony right now. Normally you have the experts there, not just because they are going to respond to that when it's their turn to testify, but they're also there to guide you, the attorney, about, is there something that came up here that triggers a certain question that you should ask? Is there something I'm going to want to follow up on that you should lay some foundation for? That type of stuff is perfectly normal with expert testimony, because these guys aren't fact witnesses that might get their stories straight if they listen to what the other folks are saying. So presumably none of that is happening. Doesn't mean Mr. Green wouldn't be able to go back if the judge does order the experts exempt from the sequestration. Doesn't mean he wouldn't be able to go back and watch his testimony. There's a whole live stream of it and respond to it that way. But it does take away that kind of in the moment ability to be able to advise the attorney on how to cross this guy. So as far as we know, no official ruling at this point. Jason McClellan, should Karen Reed give evidence? She has done media and sat through a full trial. Lots of different perspectives on this. The common wisdom is going to be no, she should not. And perhaps that's even more applicable in this case because they do have those interviews. And so, yeah, the Commonwealth is going to go through and cherry pick it to try to pick out the worst pieces that they can to try to use that against her. But at the same time, even the worst pieces are to some extent giving her version of events. So they're kind of doing the defense's job for them a little bit in terms of being able to get in front of the jury. Here's what Karen Reed said happened, at least about these things that we've seen so far. So it maybe takes a little bit of the pressure off her to testify. Counterpoint to that, if these are bad, does that put pressure on her to get on the stand and explain them? Yeah, potentially it does. I, of course, said it a million times. I am of the minority position on this one. I want my client to testify whenever possible. If it will not blow up the case, I want it to happen. And the reason why is because regardless of the instructions, the jury will hold it against her if she doesn't. They want to hear from her. They want to hear from her. And people are always worried about, the cross is going to be real aggressive and they're going to, she's going to be unlikable or bad information is going to come out or things like that. Jurors can be remarkably forgiving about stuff like that. This is just my experience, obviously not universal, my own anecdotes from being in trial. Jurors can overlook unbelievable unlikability. They can overlook histories that are not the kinds of things that having a choice you would want a jury to know about. They can overlook all this stuff to just kind of get a read on a person and what they have to say. But they want to hear it from the horse's mouth. If they don't, even though they're told you can't hold it against them, they do. And there are plenty of studies that show this. They want to hear it. And so I, whenever possible, want to give that to the jury. But some folks will take the position that it's, cross would be too damaging. They would pick her apart. She wouldn't look good. So they would say, no, she shouldn't. I felt like it in the first trial. I feel like it in pretty much every trial. If at all possible, yes, the defendant should testify, but I'm the minority view on that. So for me, this whole media and the sitting through the trial really doesn't change the dynamic at all. But I'm minority. I totally acknowledge that. Felio739, John O'Keefe put the rock there, says the Alberts did it. Well, probably wasn't John, but I'm very curious to know who put the rock there. Would love to sort that out. Where'd that rock come from? Who put that there? What was their reason for putting it there? Glenn McClure, isn't there still an outstanding motion on experts in the court to observe other experts? Yes, there is. Aunt Bev probably dismissed the defense at the impounded sidebar. Yeah, maybe. But yes, we are still waiting for that ruling. So Mr. Brennan needed to think about it over the weekend. Of course, because it's not his experts that need to sit in at this point. So he can take all the time he needs to try to get that sorted. Alessi never sleeps, Marissa J. So weird to address Haas Long to die in the cold before having Jen McCabe testify and present scientific evidence that Karen Reed hit John O'Keefe with a car for the Commonwealth. This is the fact, science, and data that we're getting. This is the facts, science, and data. I guess it's because it's Whiffen, and so it all ties together for them to try to make the case that based on the location data and the health data and so forth, John never went in the house and his phone was outside in the front yard of 34 Fairview the entire time. They necessarily have to get into Haas Long to die in cold because he did all that. That's not what we saw with Guarino. Guarino is getting to testify in little chunks and get recalled. Why don't we do that with Whiffen? I don't know. You know, seems like you could, unless the reason Guarino is testifying in these little broken up chunks has to do with the accident he was in, his ability to sit. This is entirely me speculating, though. I have no idea. It's just something that I heard about, saw that it happened, and so it's possible. But we have no record of why things are being conducted in that out of order way for him. But you wouldn't split it up for Mr. Whiffen. I agree. It's very bizarre. It's very bizarre. We are rebutting Hoslong to die in cold before Hoslong to die in cold is even in evidence. It's a little strange. The rural juror. I believe in the last trial, Jen testified to watching the It's Raining Men video while at the Alberts after midnight. He just said it was last accessed before 1700 on the 28th. Rural juror, great minds, great minds. We both got that. That is exactly what she testified to. That she was showing them the It's Raining Men video at the party at the Alberts house. That's not consistent with this data that Ian Whiffen has reported. And so doesn't that maybe kind of look like somebody went through the extraction and tried to come up with a story to explain the different things, but didn't actually understand what the things were? So didn't get the story right? Kind of looks like that. I'm not saying that did happen, but I'm saying if it did, it would be consistent with this. So, yeah, great minds on that one. The rural juror, also in trial 1, Jen said she was searching for Hockomock or looking at it. Here he says it wasn't intentionally done. It just happened to be the tab on top when she opens Safari. Then she goes on this tab closing spree. Yeah, that does appear to be what he said. And I was kind of trying to sort this out because, you know, it's strange. He seems to be, it just seemed like he was pulling from different sources at different times to say different things. He says at 12:27:40, the tab is created that's ultimately used to do the Hoslong search. The page in view was Ozone basketball, which was last accessed on January 26th at 12:14 a.m. So nothing to do with Hockomock. But then at 2:27:42, there was a web navigation to Hockomock. So I guess he's pulling this from history and then to schedules and then to girls hockey and then to Franklin. And these are all like sub parts of the Hockomock Sports website. And there was no tab switch event happened. It was she opened this tab and then there are lots of events that presumably, I guess he's pulling from a different database. So that's where that seems to line up. History, like web browsing history, seems to show all of these searches happening or web navigations happening, but they're all happening in this tab. And his explanation is, well, the tab, you know, browser state.db wouldn't show that. And so then when she reopened it at 6:23:37, his explanation, she pulls Safari back open from the background. It's on that last page that was shown, which should have been the Hockomock Sports Franklin, Franklin Girls 2021 to 2022. That's what it should be. And that's showing that that's what the screen was on the screen previously. And then we start getting into the, how long T die in Kikti and the Safari suggestion and all that. So that's where I think he's getting, or maybe Jen is getting, or just whatever. That's the Hockomock Sports. So it looks from his account, what we've seen so far, looks like it adds up. That part seems to be consistent with his theory of how all of this stuff works. They have history that would show these searches taking place, but nothing nothing related to the tab, because it's all happening in the same tab. So we'll see if that holds up. We'll see if that holds up. But so far, that does seem to be consistent. That Southern blonde lawyer, remind me, does Mass not require formal tendering as an expert, or did they stick to Whiffen? If apologies, if covered, still in and out. I don't believe that they do. I don't recall them at any point in the first trial doing that formality, Your Honor. So in some courts, you have to go through the process of establishing your experts' qualifications, their background, their publications, their education, all the relevant stuff that goes to show I'm special when it comes to this particular topic. So I get to offer opinions about it and not just personal observations, which is all what lay witnesses are limited to. And so in some courts, you do have to go through a formality of doing that. You go through the resume, you go through the publications, the education. Have you testified in court before? And then, Your Honor, based on the qualifications, I'd ask for Mr. Whiffen to be qualified as an expert. And the court will, say yes, or the court will say no. Court almost always says yes. Yes, the person is qualified. And it's just kind of a notation on the record. They don't seem to do that here. And I don't know if that's because there are stipulations outside of the record. I don't know if it's because so many of these folks have already gone through, Dobert Lanigan stuff where their qualifications have been questioned. And so it's like that record's already been made. Not entirely clear, but it doesn't look like they have to do that formality in court. It just seems like it's probably unnecessary. Young Black economist. All pages he claims loaded are URL other than Google. Haas long search didn't load page separated from Google. It loaded Google page, which you can delete. Oh, that's very interesting. That's very interesting because, yeah, this was apparently, she brings up google.com in Safari. It's not like a Google search bar on her phone like an Android user have. I have, just a search bar. I don't have to go into a web browser to run a Google search. I have a search bar. I don't know if you guys have that on iPhone or not. But she went into Safari and went to Google as a website and then ran the search in there. So it makes sense to me that might be handled differently. I don't know. And yeah, every other page loaded, but not the Google ones. The Google ones didn't load. That seems a bit sus. If it pulled up the Hockamock, does that mean that the Hockamock loaded and then just the subsequent Google searches did not? That would, if that's the case, be a problem for an explanation that we heard in the last trial. Oh, the connection at 34 Fairview, it's kind of all over the place. Sometimes it's not very good. Sometimes you get data, sometimes you don't. They have to have a little black hole right there at 34 Fairview when it comes to certain types of data and connectivity. For some reason, it's also like it's common, no matter whether you're talking about the cell tower connectivity or the satellite connectivity, they both have problems uniquely centered around 34 Fairview. Peculiar state of affairs. If it loaded Hockamock Sports but didn't load the Google searches, to me, that's a problem because it's telling me this isn't just, the service was bad. It's, the service suddenly got bad. You're going to have to prove that to me. I'm not going to just buy that. So this is a very interesting observation if that is the case. Guys, just a couple more, and then I'm going to run off to do my break because we are expecting the court to come back probably about 2 o'clock. Of course, she'll probably be late, and then we can get some more, but just want to make sure I have enough time to check on everything. Oliver Olson, glad the state is proving Karen guilty beyond a reasonable doubt by calling witnesses to defend Jennifer McCabe. Evidence, ludicrous situation. We're back in the rebuttal case, aren't we? we're back in the rebuttal case, that the pre-buttal, the Commonwealth's pre-buttal, right? Defense hasn't even put on their theory yet, but the Commonwealth is going to pre-butt it by proving that Hosslong to die in cold search didn't happen at 227, even though it's like actually worse this time. At least in the first trial, the jury already knew that that's what the defense's theory was. They already knew that. So they're kind of able to make sense out of what they're hearing. The jury hasn't heard any of this. I mean, I guess they heard it in Mr. Jackson's opening, 227, the Hosslong to die in cold. He did mention in an opening. So maybe that's why we're taking it so out of order, but it's just bizarre. It's just bizarre. Proving that it didn't happen before, there's any allegation that it did. The rural juror, I hope Alessi opens with basement, you say? That would have been good. That would have been good, wouldn't it? I thought you said something about a basement. No, you just take that one and run with it, right? You don't give him a chance to qualify or modify that in any way. Don't let him disturb it. Let it sit as it landed. In a basement, you don't always get location data. Huh? You don't say. Michael Muddragon, question for the chat. How confident are you in Apple device location data? My anecdotal experience when I order delivery, the only time the driver ends up miles away is when they're using an iPhone. It does not give confidence. I'm interested in chat experiences as well. I have never had an iPhone. I don't expect to ever have an iPhone. I'm not like, all of these companies are kind of on the same footing as far as, security and spying on you and things like that. So it's not like I think Android is significantly better for those reasons. The main reason I'll never get an iPhone is because they make it very difficult for you to not have an iPhone anymore. And they make it difficult for you to keep your same iPhone if it's working perfectly well. No, they'll keep modifying things that ultimately like force you to upgrade. So that's what I don't particularly like about Apple. I've had Android for decades now. Never have a problem with being able to switch a phone, move stuff over, and all that. Haven't heard the same thing about Apple. If you're trying to switch over to Android from Apple, they apparently don't want to make that particularly easy for you. All right, guys, I am going to go ahead and pause right now and take my break, and I'll be back probably about 20 minutes or so, hopefully like right before they're supposed to get court starting. And then if they haven't gotten started, we'll go in and check in on some more of your questions and comments. So thank you for hanging tight, and I will be back in a moment. All right, guys. Back in just under the wire, but no court yet, so no rush. Wasn't super expecting it. Very glad I did go out and check the trees. Yeah, they are getting pretty dry. I watered them before I came on stream this morning, so that should tell you a little bit about how windy it is. Yeah, I can't read my weather station from here, but it's one of the reasons why I have it. Yeah, so I can track what the wind's like. So a little bit of news came in, saw a couple things during the break. First off, I did see, adjust my chair here. Karen Reed's cert petition to the U.S. Supreme Court was denied. That does not come as any kind of major surprise to me. It was, that was the odds on pick for what was going to happen here. Even in the best case scenario, the U.S. Supreme Court accepts about 1% of all cert petitions that are filed in the court. They typically have certain criteria for the types of cases that they're looking for. Hers really didn't squarely fit within that. So it was always going to be a long shot. And then once they denied the stay as well, pretty good indication that they do not, have a overwhelmingly favorable view of the merits of the case when it comes to her position. So that happened. And that part of the case is now over. Double jeopardy issue is resolved. Not finding any problem with that last trial and everything that kind of went down in the background there. Other thing I saw is that apparently the juror that was being questioned at Sidebar is not being excused. So whatever that was about, don't know. Looks like it's been addressed. And oh, yeah, I saw Turtle Boys announcing that Jen McCabe is tomorrow. So boy, we got a lot of excitement in short order, don't we? We got Crash Daddies, Crash Daddies this afternoon, and then Jen McCabe tomorrow. A lot of stuff happening in a short period of time in this case. If that's the situation. Turtle Boy was getting information at the last trial about the order in which witnesses were being called. He was very accurate with his information, so don't have any reason to suspect that he's wrong this time. So if that's the case, Jen McCabe, as soon as we wrap up with Ian Whiffen. So they're going to debunk Hosselong to dying cold, and then immediately put Jen on to kind of reiterate that and to officially deny it. But what's she going to do with these issues with the timeline? That's going to be the $1 million question. That's going to be the $1 million question. I had something pop up in my mind while we were looking at the location data. I just wanted to double check. So it's after 12:59 that the accuracy is bad. It's all over 1 to 2 a.m. It's still bad. The best ones are 25 meters or better. 2 to 3 a.m. They're just kind of all over the place. What's causing the phone to seek the location data at this time? We don't have apps running. I mean, I don't know. I don't know that necessarily means anything or doesn't. But it's just something that kind of stands out to me. Why did the phone suddenly go to low accuracy at a time when the phone is not supposed to be in use? And then it's just kind of off and on over the course of the day or over the course of the morning, very early morning reporting location. I don't know. I would expect something triggers it, but what triggered it, I don't know. So just something that I thought of while we were waiting and wanted to follow up on. Let's get back to some of your questions and comments. Beach Rando. I'm the step queen and stairs while driven doesn't happen. Ask anyone in a step challenge if there is a way to cheat. We would have found it. I've heard this many times. I've heard a lot of anecdotal stories about people trying to recreate this version of the driving up a hill causing flights to register, and it doesn't happen. I have yet to hear of somebody besides Ian Whiffen reportedly being able to successfully recreate this. I'd like to see it. I'm intrigued by it. This came up in Delphi as well because they had an issue with steps and flights climbed, elevation measurements and movements and stuff that didn't necessarily fit within the state's theory of how that crime was committed. And yeah, stuff comes up pretty often, and most of the time the experts tell us the health data is pretty reliable. It's not necessarily all that precise. There's a lot of averages when it comes to measuring steps and things like that. It's assuming constants, right? It's assuming your tread, the width of your step is pretty constant. Your pace is constant and so forth when you're covering distance over time. So it's not necessarily going to record like if you're suddenly taking very short steps. It's not necessarily going to accurately update. Here's what the exact distance covered was, because it's relying on assumptions. So it's not necessarily that precise when it comes to what it reports. But the general consensus is that it's pretty reliable, and certainly law enforcement often treats it like it's highly reliable. Apparently, until they don't want it to be highly reliable, then it's not. Kim Neighbor, Andrea, can you recap how his testimony conflicts with the butt dial explanations I didn't follow? Well, it doesn't conflict with the butt dial explanations, but it's given us a preview. It's given us a preview of something to look forward to with Jen McCabe, because what he's told us is that when a call is received, the phone, or when a call is received to the phone will attempt to find a person. It will attempt to find a face when there's activity going on in the phone. And so they have Jen McCabe's cell phone. They have her extraction, and her explanation to all of these phone calls to John between 12:30 something to 12:40 something, like after her timeline got busted, is that those were butt dials. And it sounds like from Mr. Whiffen, they're going to be able to look at the phone data and verify if that's the case or not, because they're going to be able to see, was the phone in her pocket? What was the phone state at the time? What was the phone state at the time? We'll see. We'll see how that pans out. We don't have anybody else's phone extraction other than Carrie Roberts's, as far as I know. So we can't check the Higgins and Brian Albert, right? They got rid of their phones the day before the preservation order was signed. So we can't check their phones. We don't have an extraction. Don't believe we had one for Nicole Albert, who was one of the other butt dialers. It's just going to go to Jen McCabe and her explanation that all of those phone calls with John O'Keefe, those were butt dials. I believe there might also be a record of a phone call she made to Nicole in the morning, like when they first got to the scene. We'll have to see when the phone records come up. Oh, it looks like we're back. Let me get it back on. Got it paused real quick here.
Compel reciprocal discovery.
Let me back up.
Reciprocal discovery regarding the ARCCA witnesses. Previously, about a month or so ago, maybe longer.
Oops. Guys, my bad.
I found that there was a violation of the defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCCA witnesses or to exclude their testimonies. Upon that, I believe I issued an order last week for certain discovery to be provided and to be provided by ARCCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them. So Mr. Brennan, who are we going with first? Dr. Wolfe?
Please. And now it's in Mr. Brennan's court.
Dr. Seth, you're going to face the clerk and raise your right hand, please.
You solemnly swear that the testimony you shall give to the court in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
We are off the lunch break.
All right, go right ahead, Mr.
Thank you. Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So
order?
we need Dr. Wolfe to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolfe, last name spelled W-O-L-F-E.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Oh, Lord.
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Ms. Little, last year I was under T-Mobile, was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to, are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Miss Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson?
Yes, sir.
A number of times?
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to Miss Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please.
Thank you.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Miss Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You ever Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolfe, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you on March 20th, 2022, not
He's
the
already
22nd,
answered
not
that.
the 24th. March 20th, 2024. Did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
You sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call, letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission, they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCCA was as a whole. I think we even got stuck a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes, specifically what they were too. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Well, sir, you said that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April
Yeah,
still?
I'm still talking at April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir,
He just told you it's what it
that
sounds
is
like.
my best guess. I don't recall from a year ago.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you actually
That's not
did
what he
and
said.
actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call
Asked
back
and
on April
answered.
24th, 2024? Do you remember those 2 phone calls?
Objection, Your Honor.
Asked and
So let's
answered.
get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Okay.
next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Okay. Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCCA, but never, ever talked about this case.
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCCA. That doesn't come back to Dan Wolfe.
Okay. So in order to get paid for that, you would have had to submit that time through ARCCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes. I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
Your Honor, can you approach, please?
Who asked me that?
Me, Your Honor.
Yes.
Come on over.
Well, how come we're not getting any chastising of Mr. Brennan about how the commentary, the little snide little asides are not necessary? You know, the defense doesn't get to editorialize about the testimony, but here is Mr. Brennan. Oh yes, you certainly are on the side of the science, aren't you? He's getting to add his little snarky little takes here. My view is that Mr. Wolfe is holding up on this very well. Mr. Brennan is badgering him. His questions are harassing. He keeps asking the same thing over and over again, then circles back and asks it another time. Mr. Alessi is objecting appropriately. He could be objecting more from my perspective. There's a lot of asked and answered stuff. He said like a long time ago, he doesn't remember the 2 phone calls, the after phone calls that were made on April 24th. We went around it and around it and around it over and over again. What it could be is possible explanation for it. And then we come back to, you don't remember. Yes, we already know he doesn't remember because that's what he told you in the first place. So nobody's having difficulty understanding what the witness is saying besides Mr. Brennan. And he's only having difficulty because he doesn't want to hear it. He wants to try to push a different answer that is far more incriminating than, these guys called and probably talked to the receptionist. I don't have a receptionist now, but back when I did, if somebody calls the receptionist, they call the main line and the receptionist wants me on the phone. It's going to take probably about that time for her to find me, everything get transferred and so forth. If I'm not there, she's going to say not available, call back, leave a message, and I leave a message, whatever.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Okay. Now, when
Did you at the
billed, did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about ARCCA, talking about your families.
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay. All right.
Objection, Your Honor.
Yeah.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Renstchler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring to?
No, I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you're friends. I said, did you become friendly?
I talked to him like I talked to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
So, do you remember the next time you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here? I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank you.
Yeah, he did multiple times.
So next question, no
Okay.
comments, Mr. Brennan.
How many texts did you delete in communications with the defense?
I don't know the number, sir.
You don't know the numbers?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right, was it 10, 100, 1,000? How many were there?
Of ones that I sent,
No, not just what you sent, either way, back and forth.
probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial. Sir.
Where were you when you were deleting these texts? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
Befuddled.
I have no idea, sir.
You can't remember deleting over 100 texts?
Sir,
No, because it's
I just
only
said I
unusual for
delete
you.
text routinely. You're asking me to specifically give you a location and a time when I deleted those. I don't recall that.
You said it was after the trial.
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
Well, it's an encrypted app, isn't it?
What was that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was
said it was
Mr.
Elmer.
Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard. Is it your standard to use an encrypted app when you're talking to attorneys?
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations do you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know. How many times did you use Signal with the defense to talk about this case?
Going to allow it.
From what I recall, was probably a handful of times.
When you say if what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
And he's
Right,
telling you he
I'm
doesn't
telling you
remember.
that I didn't keep track of it, so I don't know the specific number.
How many times do you think you talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means.
Yeah.
Probably around
means.
probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on Signal? The 4 to 5 times?
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
Were you
yes.
putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
That's the best answer I can give you, sir. I'm giving you my best estimate.
I'm asking you how confident you are.
Objection, Your Honor.
Can you answer that? How confident are you, Dr. Wolfe?
I can't answer that anymore.
Okay.
When
Next
you were
question.
required by court order to provide all of the records to Your Honor, you knew that one of the important things you need to respond to were communications between you and the defense for Her Honor to consider, right?
Yes,
And signal is a communication, isn't it?
certainly.
You looked at all your records and you knew it listed the text messages and the phone calls. You knew that, right?
Yes,
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I
That's-
have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your signal calls were communications, didn't you?
But he has
I
no
provide
record.
everything that I had in my possession, sir.
That's not what I'm asking you. You knew the signal calls were communications, didn't you?
Yes,
Okay. And you never informed in your response that there were phone calls through signal
He
as
wasn't
part of your
asked. It
communications,
wasn't
did you?
interrogatory.
again, because I didn't have any record like I do with the Verizon entries as well as the emails. I could not, there's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes,
Did you understand when the court was looking for all communications, it meant all communications?
and I've provided everything that I have in my possession, sir.
During those 4 to 5 signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there
one.
wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
When you came out to the last voir dire in the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No,
Did you have any agreement that you were going to be compensated for your time?
no.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the cost of you coming out here?
Yeah, no contract.
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill.
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. So did you meet a person by the name of Kat?
I'll allow it.
I think when I arrived here, yes.
Well, without the qualification, the simple question is, you've met Kat, haven't you?
I think I met her, it was either at the voir dire day or the trial day, yes.
Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? Well, how was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street. And I think she walked me over. And then ultimately when I was done, I think she walked me back to the lot.
Do you have conversations with anybody for the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
Okay. And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
Objection, Your Honor. Go and allow it.
Pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face to face, right?
Yes.
Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. He would give me some information about the scheduling and kind of when we would be needed. Then I would check in with Dr. Renstchler and then I would get back to Mr. Jackson. So there was kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. I can certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there, but there's a lot more communications before we get even close to that. Okay. Do you remember on June 10th having conversations with Attorney Jackson?
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
Okay. You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
Okay. So everything from your mind was just logistics at that point?
Yes, sir.
Okay. And then you came in for June 17th?
believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
So you check in with the client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report
Yeah.
of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
Showing you an email. Do you recognize that?
Yes.
From you to who?
To Mr. Jackson.
Okay. And what's it labeled as?
Wolfe Direct.
And that's before you testified on trial 24.
It's at 6 p.m. the night before I testified, yes.
So it's before you testified.
Yes.
Okay. Let me show you this document. Do you recognize that one?
Yes.
What's that?
That is the attachment to the email.
Okay. You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers for him to ask you when you testified?
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
Can I get that, please? There's an email with a document I'd like to attach this as an exhibit.
Okay. Exhibit 1. Exhibit 1.
So you assisted the defense before your testimony.
Hold on.
Of course, he prepped himself for it. He's not going to just show up and be like, I don't remember what we're here to talk about. The guy's a pro.
Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question.
Hold the comments, please.
My question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
Sustained.
Do you want to answer my question or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
Objection, Your Honor.
All right, no comments, please.
Do
Just
you think
Fourth
that
time with the no
providing
comments, and he
a
just
direct
ignores her.
examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized this, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Objection, Your Honor.
Sustained.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
Objection, Your
I'm
Honor.
going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
So there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides. You're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspected the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications
No
with the
comment.
defense. I'm asking you specifically about your conversations with the defense.
That's two
Get a hold-
questions. Ask
Get a hold
one
of the
question.
courtroom.
You
Judge.
wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone in the argumentation.
Did you write that?
Yes,
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right.
No control over her
And you
courtroom.
offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. Yeah. That's what I was trying to make sure that that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
And then do you defer to the defense, not the jury, trying to give the full story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you, did you defer?
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it and then you can give any explanation you want.
Hold on. Question, Mr. Brennan.
You
and then
said-
you answer, Dr. Wolfe.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions, 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to.
Did you inform the court about your misrepresentation?
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not, correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial
Attorney
one?
said he doesn't.
Yes, trial one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls, incoming, outgoing, as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked into court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was
And-
no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCCA did send an invoice afterwards, yes.
Did you talk to ARCCA about that? About the billing in this case?
No.
You submitted your bill? Yes?
ARCCA submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement. And ultimately, he's also an accident reconstructionist. So it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think, felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as logistics, sir.
Logistics. You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Renstchler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me that the report is a general report that has yours, Dr. Renstchler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are on it,
It
yes.
doesn't distinguish who did what in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire, when you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be easy to understand if you could just tell us what the conversation was. That's what I'm asking
But he
about.
doesn't remember.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction's testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
And sir, is there any other communications that you've had with the defense that you didn't tell us about outside the texts and the phone calls and the signal calls, or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
Mr. Alessi, do you have anything?
I can do, Your Honor. Thank
Are we going to get to Dr. Rentschler today or not?
Well,
Is that
no public
his issue?
comments, Brennan's,
I'm just asking you.
I hope so, Your Honor.
Okay.
May I approach the witness?
Yes.
Your Honor, may I approach the witness for the document?
Yes.
Thank you. Dr. Wolfe, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the, excuse me, at this time, Your Honor?
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like it to be part of the hearing, right?
We can mark it.
That's exactly, thank you.
Make sure it's the same one.
I offered it into evidence, Your Honor.
Okay.
May I allow the witness to have that, please?
Yes.
Thank you. Take that picture. Bear with me, Your Honor. Dr. Wolfe, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCCA had in our possession, we produced.
Were you ever asked to answer questions or interrogatories in that order?
What I'd like to do is to go back in time with regard to your interactions with the United States Department of Justice in February of 2024. Was ARCCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCCA?
Well, let me just clarify something real quick. So the The original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have from any time in 2024 any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
Let's now go to your first interactions with the defense. As I understand it, well, why don't you tell me what was the first date of your understanding of interactions with the defense?
I believe it was sometime in mid to end of March of 2024. Again, that would have been over a month from when we issued our report to the Department of Justice.
Your Honor, may I approach the witness?
Yes.
Thank you. Your Honor, what I have is the entire production that ARCCA made. I think it would ease in terms of the.
Sure, he can have it.
Thank you. Use that pursuant to the subject of the Honor's permission to answer any of my questions if you need to.
Okay.
Now, in March of 2024, had your final report been issued, the final report that you prepared for the U.S. government?
Yes, that was issued on February 12th of 2024.
From February 12th of 2024 until you sit here today, has there been any change whatsoever to that report?
No.
Have the conclusions in that report stayed the same since it was finalized for the U.S. Department of Justice in February of 2024?
Yes, and that was testified to at the voir dire and certainly at the time of trial.
Did the defense at any time have any discussions with you about the substance of that report to the United States Department of Justice?
No, we had no idea who the defense was or the Commonwealth for that matter.
And when you took the stand in the voir dire testimony in the first trial, before you took the stand, did you have any discussions with any member of the defense about the substance of that report?
No, sir.
Did you have any discussions with any member of the defense before the voir dire testimony other than discussions about background and qualifications?
Other than, again, some logistics about how to get up here, where to go, things of that nature. But beyond that, no.
Other than logistics, how to get up here, when you were coming, background qualifications, did you have any discussions with any member of the defense of any kind with regard to the report to the U.S. Department of Justice?
No, sir.
Did the defense ever try to get you to improve or change any aspect of the report you had issued to the Department of Justice?
No.
At the time that ARCCA was working for the United States Department of Justice, do you know whether ARCCA could have been retained by any other party for any aspect related to the February 2024 report?
I'm not sure I understand your question.
In 2024, did the federal government prevent ARCCA from entering into any contract with any other party with regard to your report of February of 2024?
So we were, again, because we were still under contract with the Department of Justice, we could not have any other formal agreements, contracts, retainers, anything of that nature, because we were still under contract with the Department of Justice.
Now let's go to the emails that were discussed with you, starting with March 20, 2024, and then the subsequent email of March 22nd, 2024.
Okay.
Are you there, sir?
Yes, I think so.
Okay. Well, let's test to make sure. March 20, 2024, 10:49 a.m. from Alan Jackson to Daniel Wolfe. Do you have that?
Yes.
And that email states in substance, thank you so much for taking the time to get on with the phone this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith along with your retainer as required. As of March 20th, 2024, was there any understanding that ARCCA would be compensated by the defense for any aspect of current or future work?
No.
Was there any understanding or discussion that ARCCA would receive any reward or payment or compensation for any contemplated work with the defense?
No.
The discussions that you had with Mr. Jackson that are the subject of this March 2024 email, were there any inducements to ARCCA from the defense?
No, sir.
After that email was received by you, did you have any understanding or expectation of any kind that ARCCA would be compensated for any work associated with this case?
No, sir.
What was, briefly, the essence of that conversation that's discussed in the March 20, 2024 email?
Well, if it correlates to when I'm looking back at this phone record log, there was an incoming call to the ARCCA main line on March 20th, 2024 at 7 a.m. And that's Pacific Standard Time. So that would have been at 10 a.m. Eastern Time. So that call lasted for 39 minutes. And as I mentioned earlier with Mr. Brennan, I think that was a conversation about Alan trying to get in touch with me, letting us know that, hey, we've received your all's report as part of this federal investigation. You know, how can we go about utilizing you guys to come testify at trial? Can you guys come testify at trial? So, and then as I mentioned, I went over him with our typical, protocol for when a case comes in and a client wants to utilize us to testify, which is certainly outlined in that email. But obviously, given the very unique nature of this case, I had no idea if that was something that was okay, if it was allowed, what to do. So subsequent to that email, I then reached out to the Department of Justice to get clarification on what the guidelines would be to move forward.
I'm going to come back to these emails, but I want to go right to the July invoice from ARCCA to Worksman Jackson Firm. So can you locate that? Is that in your production? It's the July invoice.
Yes. I have it located, yes.
Did you ever have any discussion of any kind with any member of the defense team about that invoice before July 12th of 2024?
No, sir. And I will note, I am not a part of the invoicing or accounting at ARCCA. When a bill goes out, how much it goes out for, who it goes to, I'm not a part of that at all.
For each and every entry on that invoice, did you have any understanding that the defense team, as you're making each of those entries, any understanding that the defense team was going to be paying for any of that work?
No, again, I think my boss wants to know what I'm doing with my time, right? What am I working on? Am I sitting there twiddling my thumbs, or am I working on a case? So that's the purpose of tracking time, sir.
So can you please describe how it is you enter time and what your thought process is as you're entering each of those time entries? Not each one, but just collectively. How do you do it? Why do you do it? And how does that work in your firm?
So again, there's usually just a spreadsheet. Sometimes I'll write it down. Maybe my project manager will enter it. But ultimately, I keep track. If I've got an 8-9 hour day, right? I'm working on multiple cases that day, right? So I figure out, all right, did I have a telephone call? Did I work on a report for this long, right? So I keep track of my time in a spreadsheet, so that ultimately, again, my boss and the accounting department knows what was Dr. Wolfe doing on this day, this month.
Let's take the first entry on May 1st, 2024. You see that?
Yes.
Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
6/9/2024. Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
For any entry on this invoice, did you have any understanding that the defense was going to be paying for this time?
No, sir.
When you're entering this time, if you had any understanding, was your understanding that this time was under the contract with the U.S. government?
Yes, because that's the project number that I put that time towards.
So at the time you're making each one of these entries on this entire invoice, what project number are you billing to, and which one do you have in mind at that time?
I don't recall it off the top of my head. I know it was the project number for the Department of Justice case, though.
Right. I'm sorry. I wasn't asking about the specific number,
right,
but the ultimate client, when you're making each of these entries, who is it?
It's the Department of Justice.
Is it the defense in this case?
No, sir.
Did you ever have any discussion at all with any member of the defense team that this invoice was going to be sent to the defense?
No.
And for any entry on this invoice, did you ever have any belief that you were retained or engaged by the defense?
No, and as I mentioned earlier, again, the Department of Justice forbid that. So we could not be retained or in a contract with the defense.
I would like to now go back to the emails we were talking about. Specifically, we left off with the March 20, 2024. I want to now go to the March 22nd, 2024 email. I'm just going to shorthand that, refer to it as the pause email. What had happened between March 20th, 2024 and March 22nd, 2024?
Do you have the tab for that, the email that you're looking at? Sorry.
Tab 1, please.
Tab, okay. Right, so the first email that we were talking about on March 20th, 2024 from Mr. Jackson to myself, it looks like the next email was from me to Mr. Jackson 2 days later, March 22nd, 2024 at 6 a.m. I sent an email saying, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it." So what it sounds like, and from what I recall, is that between March 20th, 2024 and March 22nd, 2024, I had reached out to the U.S. Department of Justice and the U.S. Attorney's Office to get clarification on, again, moving forward with potentially testifying in the case.
And what did the United States Department of Justice tell you?
They said to wait basically until they internally figured it out.
So what was your conclusion from that conversation as to whether you could do any work on this case at that point?
At that point, I didn't even know if we were going to be allowed to testify. I know that from my conversation with the Department of Justice, I knew that there was a great deal of confusion on their end on whether or not, as expert witnesses involved in a federal investigation, if we would be even allowed to testify in the state matter. So their legal teams were trying to, I think, figure out what the road forward looked like.
And were you entering time under that U.S. contract matter in March of 2024?
Yes.
And do you know where that time was being billed to?
It would have been the same project number as the Department of Justice one.
That time was not, to your knowledge, being billed to the defense, was it?
No, again, there was through the entirety from, again, when the case from the Department of Justice came in 2023 till the trial concluded, all of the time was put to that one project number.
In March of 22nd of 2024, was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCCA?
Certainly, as is alluded to in the email, I prescribed to him our typical operating procedure for when a case comes in. But again, there was, I remember a part of that call, there was a great deal of confusion about what do we even do from here.
So as of March 22nd, 2024, can you just briefly describe whether there was any further activity at all by ARCCA with regard to the defense?
No, I don't believe so. I don't think that there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April. When you sat on the stand under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversations you had with the defense team as of the moment you sat for the voir dire hearing in April of 2024?
Again, they were all scheduling, logistics. And when I look at these records here, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few that are for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out, obviously I know that this was a large trial, a lengthy trial, a lot of witnesses, things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea. Hey, can you come this day, right? And then I would relay that to Dr. Rentschler and say, yeah, that works for me. So that I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
It might appear to some that there were a number of conversations before in communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing for the voir dire.
At the voir dire hearing, do you recall the Commonwealth asking you any questions at all about whether you were being compensated by the defense?
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
Waived. You didn't ask. You didn't ask something, you
Now
waive
let's
it.
go to the next tab. With regard to the outlines that you were asked on direct examination by Attorney Brennan.
This is why they don't want to call him. Good one.
You've described this situation, well, you described how it is you viewed this situation. Have you ever been in this situation before where you're under contract with the federal government? There's rules of the road, so to speak, as what you can do, what you can't do, and then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind, and I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
No, sir.
Did that cause you to have more or less communications with Mr. Jackson to figure out what it is you were going to do or not do?
Sure, yes.
In terms of your outlines that you sent to Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you before you sent that email with those outlines, was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that that's my job.
Was there any other motivation that you had in sending that outline and that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the outline and the testimony at trial? What was your goal?
Again, as I mentioned, I think it's to help the jury understand the report, the analysis, what I did, what I reviewed.
Did the defense ever ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury what it
Oops.
is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we have this alleged incident, there was bad weather conditions, it was nighttime, therefore, we should give that more weight.
And is that desire of yours in your mind to help the defense more than to help the Commonwealth?
No, it's impartial. And I will note, I give numerous presentations, and I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic. And I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
In terms of after you sent the emails with quals and issues pertaining to direct testimony, did you ever have any communication of any kind whatsoever with the defense team?
No, he didn't. Mr. Jackson didn't even respond. And I think when I sent the direct outline, it was Sunday evening before I hopped on a plane. And I think by the time I got into Boston, it was like 1 a.m. So I didn't even have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation with Mr. Jackson or any other member of the defense team about the substance of your upcoming testimony?
No, sir.
So you went and sat during that trial and gave testimony to the jury without ever having talked to a member of the defense team about the substance of your February 2024 report?
Correct.
Do you recall any member of the Commonwealth asking any questions at all during your trial testimony about whether you had been compensated by the defense?
No.
Do you recall the Commonwealth ever asking any questions at all whether you had communicated with any member of the defense with regard to your testimony during your trial testimony?
I don't think that was asked. No.
Do you recall any questions from the Commonwealth about whether back in March or any other time you had been promised or induced by the defense? Do you remember any of those questions?
No.
Do you remember any questions by the Commonwealth at either the voir dire or the direct testimony about whether you had had conversations with the defense?
No.
Do you remember any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
At the end of the trial, did you have any understanding whatsoever that ARCCA was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No, and the record certainly reflected I never spoke to Mr. Jackson after the trial in 2024. There was no conversations between us.
Well, let's go beyond Mr. Jackson. Let's go to any human being. Did you have any discussions with any human being as to whether the defense was going to compensate you for any work, travel,
Any human being.
expenses, disbursements that you had or
What about your
incurred
dog? Did you tell
up
your
to
dog?
and through your trial testimony?
No.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Now let's proceed to December of 2024.
Oh, God, a chronological presentation.
Were there any
Easy to understand.
conversations from the end of the trial until December of 2024, other than logistics? Well, was there any conversations of any kind? And please summarize briefly what they were. Or texts.
The only communication that I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time traveling up here. I said it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder of 2024.
Now let's go to recent communications. In 2025, did you have any communications with any member of the defense with regard to the potential? Well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
How did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
Now let's go to this year. Did the defense approach ARCCA to see if they might be able to testify in this trial that's currently pending?
Well, I think that the first communication of 2025 that happened between myself and Mr. Jackson was in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
And what was the substance of that call?
Well, I think back to that time frame, I became aware that I think that there was a motion or two regarding ARCCA and potentially excluding our testimony for the upcoming trial. I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails, and unfortunately even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids all over the internet. So it was somewhat of a difficult time on my end. And I think what prompted me to reach out to Mr. Jackson was to figure out what's going on. Why is my family all over the internet? You know, why are they talking about me? Why am I getting all these hate emails? So it was, I think, a conversation to figure out, hey, you know, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you were getting hate mails, hate emails, hate communications, your wife, your children? What did you conclude was the reason why you were receiving that?
I honestly don't know. I presume it was about comments made to me in court or that were represented about ARCCA or myself.
So just so I'm clear on that, it was, you believe, regarding comments about ARCCA and whether and what? Can you be a little more specific what your understanding was?
Well, I know that I received several emails that, you know, insinuated that I perjured myself on the stand. Like I said, and a lot of hateful comments just about me and the work that I do. So I received several emails with respect to that.
Sir, do you believe you have ever made an untruthful statement at all with regard to this matter?
No, sir.
Have you done your best to try to provide accurate and truthful information in this matter?
Yes.
Now to the last part, which is, did the defense contact you with regard to potential further work? I want to separate out now and move on from the work that you did with regard to the U.S. Department of Justice, your February 2024 report. We went all the way through the trial in that matter. We went to the end of 2024. Now I want to come to 2025 in a different subject matter, which is communications with the defense about doing further work for this trial?
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson had indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Miss Reed, that phones of defense attorneys had been requested to be looked at? Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but like I said, I did not have a problem with communicating. To me, it was just another messaging app. I know people use all different types of applications, so I didn't have a problem with it.
Was there anything in your mind nefarious or underhanded about using Signal?
No.
And my understanding is the first time you used a Signal app with regard to a matter professionally. Is that correct?
Correct, yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the defense on Signal?
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCCA was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information at all helpful or meaningful to you in your ability to respond to that and to determine what was done and what ARCCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, et cetera, do you recall when you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, et cetera, did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that Dr. Renstchler and myself are particularly interested in are extremely vague in that report in PowerPoint.
Once you got the level of information that you have now, what is the ordinary time it would take in the regular course of ARCCA's business
Good record.
to evaluate that information and prepare your own report, analysis, and finding? In the ordinary course, how much time would it take ARCCA to do that?
Well, certainly for the nature of this case, as I mentioned, we were officially retained by the defense on March 26, 2025. As I mentioned, I myself just got word from the Department of Justice just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson, I indicated to him on the 26th that we did have authorization to move forward. He immediately asked that I send over, again, our typical procedure with the contract and retainer. And I think that same day, the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through 62, which I think encompassed about 800 gigabytes worth of information and data.
How much in relative term, 800 gigabytes? Is that a little data, medium amount of data, or a lot of data?
Voluminous, a lot of data. So we immediately started to review that. And again, I feel like maybe I speak for most experts. One thing we always want is more time, right? So in a case like this, I mean, ideally we would be talking months to be able to sift through all of that information, be able to do analysis, be able to do testing, be able to write a report, right? So I think certainly we are on the order of months, not weeks.
What did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from Aperture?
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could, along with Dr. Renstchler, to review that material, and certainly in parallel try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case.
Did you put other work aside at ARCCA to work on this matter?
Absolutely, work and personal things.
And personal things. What did you put aside? Just one example.
So the other week, my wife and I, we celebrated our 10-year anniversary. So,
So it affected his personal life, I understand.
Okay, I'll move on, Your Honor. With regard to the work, you performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly could. Is that correct?
correct.
You said you would like to have had more time, correct?
Correct, but I understood Your Honor's order and I wanted to beat that deadline. So I worked as quickly as I could over the last week to ensure that, again, we could respect that deadline and we completed our testing.
And with regard to the testing now that you worked on, that you just described, does that testing relate to any previous work, or is it all in response to the new expert for the Commonwealth, Aperture, and the new information from Aperture that came in iterations through the month of February?
It would be in response to Dr. Welchler's work. Certainly, much of what was alluded to in his report and PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month or so? Could you have done any of that work without receiving the Aperture report and slides and scans?
No, I don't even know what we would be responding to then.
So you needed the Aperture information before you could even start working, correct?
Correct.
Do you have in mind, or does ARCCA have in mind, any further testing that you need to do, or have you completed what ARCCA needs to do with regard to fairly and properly responded to the new work of Aperture?
I think we're satisfied that we've completed that testing, yes.
And what, if any, more work do you contemplate that needs to be done from, as you sit here today, going forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering type terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note, obviously, as the court is aware, we've produced all of that raw test data, photographs, video. So it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully, so there's my next question, which is there's nothing that you have that you've done that hasn't already been produced to pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order, yes.
How long on an expedited basis? Well, let me ask you, in the ordinary course, how long would it take you to do this last part of your work in the ordinary course?
Probably, again, it can vary. Maybe around a month would be fair.
However, it would take a month in the ordinary course. How quickly can you get that work done fairly?
I'm hoping, if it pleases the court, hopefully May 7th will work.
And so you believe everything would be completed by May 7th?
Correct.
Just over a week.
That's all I have at this point, Your Honor.
All right, Mr. Brennan?
Yeah, the only other thing he needs to do is show up and get yelled at about his emails, phone calls.
Doctor, you're suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided raw data last Friday,
Yes.
but you would agree you still have not provided any reports.
Correct.
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately. I'm talking specifically about how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welcher's information to the defense? Do you know?
I don't know, no.
Did you know that it was turned over in a report on January 30th?
Just the report?
Yes.
I didn't know that.
And
No.
the file in its entirety was turned over by February 5th? Did you know that?
Objection, Your Honor.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th to complete your testing report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had authorization from the Department of Justice as well as ARCCA, yes.
Putting aside the authorization, I'm going to ask you about that. But just the time you need to test, if you knew or received the information by February 5th, you could have been done by March 5th or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now. So wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever it's going to take you from March 26th, you could have done from February 5th. True.
Again, I don't know the timeline in terms of what exactly was produced when from Dr. Welcher, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time needed to deal with this information. You said you could have done in around a month.
I think a month or more, yes.
So your contract with the federal government ended, ARCCA's did, in June of 2024, didn't it?
I believe it was sometime last year, yes.
Do you know the Commonwealth notified the defense that they were going to have a new expert back in October of 2024?
No.
Are you aware of any effort by ARCCA or the defense to try to facilitate an agreement that the defense could use ARCCA as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCCA in December or January?
No.
And so as far as you knew, this came out of nowhere in March, that the defense wanted to use ARCCA, or specifically you and Dr. Renstchler, in late March of 2025?
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the ARCCA issue was being litigated. And I think that, like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2025 to even seek permission from the federal government to retain you and Dr. Renstchler so you could review the materials?
Objection, Your Honor.
Do you know? Do you happen to know that?
I don't know, no.
Next question.
You shared with us communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
What do you mean with respect to information?
Evidence, discovery, information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025. Isn't that fair to say?
Correct.
Okay. Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
The one that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No, it was just verbal communication.
And they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
And is that how at trial, even though you had no evidence that was produced as part of your report, or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know there was a sequestration order in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that. no.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case before your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes,
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
no, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor.
Okay.
This is your outline with your comments. You recognize this?
Yes.
I'd like to introduce that as an exhibit, please. Thank you.
Exhibit 3.
If that's 3, then
So as an expert, when you receive information, you need time to look at the raw data, don't you?
Alessi, make sure
Potentially, yes.
yours
You
get
need
marked.
time to look at the report of another expert, don't you?
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read if you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when an expert introduces new information, testing materials, it takes about, if not at least a month to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing, that should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new and an expert wants to look at it, you would agree to sift through that much information and consider and vet it and then do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert that determines whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
May 7th. It could take an expert if they wanted to do testing based on new testing that you provided over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report and you provided
But there's no
report,
surrebuttal.
How many pages was it? 10, 12 pages?
The original DOJ report?
The report that you produced in this case with your opinions, yes.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected as classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
And videos of the demonstration, you built like a potato cannon, right?
I'm sorry, what?
Potato cannon.
Smiling, thinking of his cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of it when you were doing your demonstrations and tests?
Yes.
Never turned over those videos, did you?
Again, we're talking about trial one. As I mentioned, for trial two, let me finish.
Trial one. So
Okay.
no, I want you to focus on.
Okay, no, that
trial
was
one.
not produced, no.
You never turned over any of those videos, did you?
Again, we were not able to.
And was there any failed testing the first time around?
No.
In addition to videos, I'm sure you had other raw data, notes, photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welch's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided
Right,
in
so-
response to Dr. Welcher.
Without video and without the raw data, as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
This is arguing against
I think you might be
himself.
confused. Again, our role for this round.
I don't think I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report. You provided no video, no raw
He
data.
just does what he
no
wants,
notes.
and she
Correct.
doesn't
Correct.
take
But for
control.
this trial, sir, we are being asked to respond to Dr. Welcher.
That's
Okay.
not what I'm
We
asking
have
you.
provided everything that he would need to evaluate the testing that we have done.
That's not what I'm asking. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
And
All right,
you-
with that, I need to see counsel with that.
She has zero control over this courtroom. And right there, Mr. Old Dr. Wolfe was just starting to get the hang of how this goes in her court. Oh, you want me to be quiet? You're going to interrupt me? I'm just going to go ahead and keep talking, and maybe even a little bit louder. I'm just going to say what I want to say anyway. There's an objection. And before she can answer, Brennan just continues. She never cuts him off. She never gets control of the courtroom. She never rules on the objection. She never provides any guidance. He does what she wants, and she's letting him. You know what this looks like? This looks like a spoiled toddler. This looks like a spoiled toddler or a spoiled dog, a dog that can't be controlled. They just do what they want, and the owner sits over there going, stop that. And the dog doesn't stop it. And what do? They say, stop it again. And the dog doesn't stop it. Why? Because the dog doesn't give a shit about what you say. Until you follow it up with some action, the dog's going to do what it wants to do. That's what I see going on in this courtroom. This is a dog that's figured out these words don't mean anything. These words mean nothing. I don't care about them. Because she's not going to control the courtroom. Well, we know that she's got an issue now because here we are at the end of the day, and we have not gotten to Dr. Renstchler. No, of course we haven't. Of course we haven't. Notwithstanding Mr. Alessi being advised to move things along. How long is it going to take, Mr. Alessi? I don't know. Maybe it depends on how much time Mr. Brennan decides to waste on a lot of this stuff.
You're all set, and let's bring Dr. Renstchler in here, please.
They are going to bring him in.
Follow me, sir.
Thank you.
Yep, you got to give him a little. You're not hurting the dog. You're just getting the dog's attention. You better pay attention to me. Because I'm going to back up the command I'm giving you, and you're going to comply because you're the dog and I'm the owner.
Shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, Dr. Rentschler, this is going to be very quick. Go ahead, Mr. Brennan. We
Thank
just
you.
need his name.
Good afternoon, doctor.
Good afternoon.
Could you please state your name for the record and spell it?
Dr. Andrew John Rentschler, ANDREWJOHNRENTSCHLER.
You've testified before in this case?
I have, yes, sir.
In a last voir dire in a past trial?
That's correct.
Okay. Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I believe there was maybe one text message.
Okay. How about phone calls?
There was maybe 1 or 2 phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Okay. Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you remember speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium to have conversations with the defense other than text or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
So when I
Keeping a record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
Well, I don't believe that ARCCA has any specific policy for that. No, sir.
Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean?
Yeah.
Well, certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they were called to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
I do not know, no, sir.
And by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it?
It would certainly help prepare me to understand what was going on during the trial, yes.
Did you know there was a sequestration order, that there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, before you testified, did you get a chance to meet anybody from the defense?
Just when I came at court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over, have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And, sir, I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you want to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an
And then you
opinion.
make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do that.
And it's still not done.
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you order me to do so, I mean, I could certainly try and expedite that.
All right. I appreciate that. Thank you very much. You're all set, sir.
Thank you, Your Honor.
All right. I'm going to see counsel at sidebar for 1 minute.
Back to sidebar. Well, guys, is that going to be the hook that Judge Cannone needs? There's just a couple of issues here that if she wants to sink her teeth in and say, nope, I'm going to find a violation, and so I'm going to take it out on the ARCCA witnesses and not let them testify. I think there's two areas that she can sink her teeth into. One of them is this sequestration order.
All right. That's it. Thank you.
All rise to the court, please.
Guess we're done. I guess we're done because the jury is already out for the day. We'll see. I'll leave it on the fan until they kill the stream. So the sequestration order, it is the person who is calling a witness, it is your obligation to inform them of any pretrial rulings that limit their testimony or that limit their behavior. And so, for example, if you're not supposed to mention things like, oh, I don't know, the harassment that you've received from other witnesses and so forth, if you're not supposed to mention that there was a previous trial, just throwing these out as hypothetical examples, it is the responsibility of the person who is calling that witness to make sure the witness knows this is the limitation on you. And so similarly with the sequestration order, the person who's calling the witness is the one who has the obligation of making sure that they know you're not supposed to see anything, attend anything, and so forth. So I see this as something that she can potentially jump on. There's no sound, but there's closed captioning coming up on the screen. I don't know what's going on. That's something she can jump on. Oh, defense, you never informed them of a sequestration order. That's a violation. That's a violation. They violated the sequestration order. There must be a sanction. The other one that I see is with Dr. Wolfe, the preparation of this outline and the comments. And the reason why I see this, okay, they've ended the stream. So I think we are in fact done for the day. She has a little bit of discretion in the context of deciding a motion, a pretrial motion, although we're in the middle of trials. This is still a pretrial motion. She has some discretion to make preliminary factual determinations to the extent that it's necessary to be able to decide the issue that's presented. And she can rely a lot on her own credibility determinations. It's one of the ways that judges who have been around the block a few times and want to insulate their decision-making from further appellate review, what do? They ground it in their determination of who is credible and who isn't. Sound a little bit like that opinion from Justice Nicol way back in the UK trial, Johnny Depp versus the Sun. It's exactly what he did. It's exactly what he did. He grounded his decision about what happened in the case based on his credibility determinations, where, for example, he found Kevin Murphy wasn't credible because, he made a statement against interest, which normally makes it more credible, but in that case, it didn't. The video recordings, the audio recordings, those weren't credible because they weren't under oath. You remember all that? Yeah. And that's what insulated it from further review. When Johnny Depp tried to appeal that and it went up to the Court of Appeals and they're saying this is completely contrary to the evidence at trial. And the Court of Appeal says, well, but we have to defer to those credibility determinations that the trial court made. Because after all, we weren't sitting there in court. We didn't get to see it as it unfolded. Do you guys think she would dare to find Dr. Daniel Wolfe not credible on his explanation? I do. If she wants to keep him out. If she wants to keep him out, she'll say his testimony to the jury, if she wants to, his testimony to the jury about not having any discussion with the defense about his testimony. That was not true because he had sent that text. And so to the extent that he's testifying, well, he didn't understand it that way because the text was never responded to, or the email was never responded to. He never even got any acknowledgement from AJ about it. She'll say that lacks credibility. He was trying to help the defense. If she wants to rule against ARCCA, mark that. Put that marker down. That's my prediction. That's my prediction about what she would rely on. And then she can rely on that to, call into question the whole thing with the time, the texts and the explanation for it, the volume of them and so forth. they say Dr. Wolfe primarily has said this is all scheduling and logistics, she can say, I found you lacked credibility in that other thing, so I don't really believe any of it. Just a little pathway here, if that's the direction she's inclined to go. I suspect that might be how it shows up in her ruling. We'll see. We'll see. But as I've said, it appears to me from her comments before, she is looking for a reason to try to sanction them. Because otherwise, Hank getting mad and throwing accusations around that he doesn't seem to have much of a basis for, we still got no substantiation of any kind that there is anything improper here, that the defense ever manipulated their testimony in any way. We already knew that because we already knew what they testified to, and we already knew it was consistent with their report. So we already know that they didn't change anything. But yeah, what'd you guys think of that? What'd you guys think of that with Mr. Brennan? What'd you think about his manner of testifying? We know that's kind of what he's trying to do. His manner of questioning. Here's another marker I'll lay down. Mark this right here. He'll never do that in front of the jury. He'll never do it in front of the jury. Even if ARCCA is allowed to testify, watch it change. Watch him be sweet as pie to ARCCA. Watch it. He'll never do that in front of the jury because he knows he looks like an asshole. He knows he is being an asshole. He knows that's the whole point. So he'll never do that in front of the jury. He's only doing it with Bev because she lets him get away with it. Because he does what he wants and she doesn't correct him. She doesn't enforce any rules against him. She doesn't enforce any boundaries against him. He continues to do what she wants and what he wants, and she allows it. And that's going to continue to happen. But no, he will not make snarky asides 4 times. 4 times she tells him, stop with the comments. Was there any consequence at any point? No. So what did he keep doing? He kept making comments. Even after that 4th time, he's still, still making his little editorialized injections. So yeah, big signal right there this afternoon. She's not controlling the court. Hank Brennan's going to run the court. He's going to run how things go. If I'm the defense, I am processing this right now. And we are preparing a plan B. I am potentially, letting my witnesses know. Wait till the judge shuts you up, because if she doesn't stop you and shut you up, nobody's going to and nobody has to. He starts talking, go ahead and continue. Make the judge make you stop. I might be making a strategic note. I object. Hank Brennan continues to talk. I'm going to continue to push the point. Your Honor, there's an objection pending. I'm not going to just let it keep going. Might be making little notes of these things after that little performance today. Well, now I guess we wait. If you can get it done, if I order you, can you get it done before May 7th? You just made them take a whole day to be here for this. And they're asking for a week and a day, a week and 2 days to do what they would normally do in a month and to do what the Commonwealth's expert did between October and March. But he might need to test their testing or do new testing. Why? If his original testing is good. If his original testing is good, wouldn't you just stand on business? Why would you need to retest the defense's test or do new tests? Surely you did a thorough and complete job the first time. So again, if your opinion needs to be that reactive to how the defense responds to it, well, maybe you just didn't start with a very good opinion. Maybe it's that. Wild, guys. Wild. I was impressed with how Dr. Wolfe held up under that kind of treatment. Clearly a little bit baffled about why he's being subjected to this level of disrespect and why it's being allowed, why he's not getting to explain his answers and so forth. But he didn't once lose his cool, not a single time. Very professional witness. I'm impressed with it. Not a baitable guy. So guys, with that, we are done for the day. So I will go ahead and take that off, and let's start getting into your questions and comments. See where we left off. Z, RG and TB buy and test same model in iOS. Why not E and Whiffen? I don't know. Yeah, good question. Why didn't you test this in the same using the same thing? Why did you do this analysis on an old iOS and then extrapolate that to a new iOS that's doing different things, but assume that it's, overall still functioning the same? I don't have an explanation for that. But yeah, generally, if you're doing testing, you compare apples to apples. It does nobody any good for you to point out that an apple is different from an orange. We all know that. My Mini 67, Andrea, I could write an essay on GPS tracking. I would love to read it. I would love to read it. There's so much out there. Location services on your phone means that, any app on your phone that uses location data can get your location data from all the different sources, GPS, the tower triangulation, all that stuff. Something, my Mini 67, if you're interested in filling me in, that I'd like to know a little bit more about, is that it's my understanding, and correct me if I'm wrong, that your phone will continue to collect location data even if you have location services off, because it keeps it for purposes of emergency response. If you get lost in the woods and they need to track you down, they have that information available, even if you have location information turned off in your phone. That's my understanding. I could be wrong. So if you got information about that, I would definitely love to know what you think. Greg Cagle, perfect timing. Finish with Commonwealth half a day, rest of day voir dire. Defense gets night to formulate cross for tomorrow. Lots of witnesses' opinions to highlight. Yeah, they get to finish with Mr. Whiffen tomorrow. I don't think they were done, right? I don't think they were done. He was moving into a new area. It was a good time to take a break, so they took the break, and then we had to spend the afternoon on the voir dire. So, yeah, he's got time over the night if he needs it. He may not need it. This man came in, Mr. Alessi. He came in prepared. That's like his MO. Oh, there's something you may need to rely on. Here it all is in a binder. I've got it all. I've got everything. You already have that order? I don't care. I want to make sure that the witness knows what you're looking at. He didn't get his copy of the order marked and admitted as evidence, but I don't think it matters because all he cared about was that operative sentence about what exactly ARCCA was being directed to do. And they were being directed to produce documents. And that's what they did. He wasn't asked to provide an explanation for anything that they don't have documentation of. That is literally your job, Mr. Brennan, to ask him. There's any other communications that aren't reflected in a record that was produced, and you did. And so now we know they talked on Signal for a short time in March. But yeah, I don't know that he'll need the extra time to figure out where he's going with Mr. Whiffen, but he certainly has it if he wants to review what he's already prepared, reviewed what Mr. Whiffen said today, see if there's any other holes he wants to attack. My Mini 67, Safari tabs are quantum. You don't know what's there until you look. It's Schrodinger's tab. Right? No idea. No idea what the tab is or has on it or is about or what time until you need an answer. and then it can be what you need. Brent Mack, Andrea, can the A team get at Be in Trouble 31 2 videos in as a demonstrative showing broken arm from 25-mile-an-hour crash and no salt dust in lens? No, they can't. He is not an expert that's been disclosed or his basis, nothing like that has been produced. So they can't rely on it. It's not a demonstrative. A demonstrative is something that you use as an aid to your own testimony. And so, like, for example, if I'm going to be telling you about where I went, where certain events happened, then we might use a map as a demonstrative, or I might draw like a layout. I went to this room and then here's how it looks when you go down the hall. Things like that. Those are demonstratives. They're there to aid your testimony. As far as we know, the defense doesn't have anybody testifying to this. Now, I would love it, of course, if ARCCA, part of what they were doing, their testing, was recreating something like this. But if that's the case, it would be ARCCA's own opinions and their own testing that they did, that they would show the jury. If there were any demonstratives that would assist them with that, it would, more than likely be their own work. So no, Be in Trouble 31, his videos are fantastic, but they are not going to be seen by the jury. I really did enjoy them, man. That one showing the way that the light moved with the diffuser, like the way the light actually appears in the tail light when it's busted up like this and then is turned back on. Like, well, how did nobody ever think about that? Why don't we break it and turn it back on and see what it looks like? And then we can compare that to what we see on all of these nighttime videos with this taillight lit up. Is that how it would look if it was in the condition that it was in when the Commonwealth had it? Sure doesn't look like it to me. Oh, it was such a good idea. Lady FDD, Hank avoid calling the McAlberts to force the defense to do it. Obviously trying to avoid the jury hearing them before tech info. Will Alessi kick his ass on Cross? I don't know if they're going to call the McAlberts or not. So according to Turtle Boy, Jen McCabe is up tomorrow. So they won't be ignoring the Alberts. The Alberts are a pretty important part of the story. The Alberts are an important part of the story, if only because they have to deny that John ever went inside. They have to deny that John ever went inside for this theory to work. If they never get on the stand, and I'm the defense attorney, I might be thinking to myself, well, I'm not calling him either because I can put John in the house without them coming in and denying it. I can point to this location data. I can point to the steps. I can point to look, even their own measurement has the location, including the corner of the house, and then it gets all inaccurate, and he's moving all over the front lawn. I might not even call him if the Commonwealth doesn't, because they have to deny he came in the house. Otherwise, the defense theory starts to make a little bit more sense. Oh, and that's why Lucky didn't see him at 2 o'clock, at 3 o'clock. So no, I think they're just, this is kind of what I started at the beginning. It's primacy and recency. You bury the stuff in the middle of your case that you want the jury to remember the least. The stuff you want to stick out, you put at the beginning and you put at the end. So what does he want him to remember? I hit him, I hit him, I hit him. That's what he started off with Timothy Nuttall. Now, the fact that Timothy Nuttall was, decimated as far as his memory, it's also the first cross they're going to remember. So that might not have been the best gamble, but as an earnest witness goes, he delivered. He's the true believer of the I hit him, I hit him. He really does believe. I think that. He really does believe he heard it. He believes it so much that he remembers it a little bit better every single time. Gets a little bit more detail each time. Just unfortunately, those details don't add up with what you can see on the actual video. Mike from Providence. Karen connected to John's Wi-Fi at 12:36 and Apple data shows John's last movement at 12:32. No chance she could make it to his house in 4 minutes. Yeah. Yeah, I mean that's part of the issue here. We heard that at the last trial that it was like a 6 to 8 minute drive to Meadows, and that's like under normal driving conditions, and this is the middle of a storm. So what excuse might we get from the Commonwealth? Well, she was angry, so she sped. She drove really fast. She drove recklessly. Maybe she ran some red lights. But we don't have any type of black box data. If you're like driving extra fast in a storm, don't you think you're probably gonna like skid, have to hit your brakes hard, take a corner too fast when that slick snow has just started to accumulate? You're probably gonna fishtail a little bit. Does that seem plausible? I mean, I don't know what they're gonna try to come up with. But Karen connecting to John's Wi-Fi at 12:36, which is a piece of information we learned at the last trial. Haven't heard it yet for this one. But that was pretty critical information in the last trial as well. It's what messed up the entire timeline. Messed up Jen McCabe's whole explanation for these text messages and what she was doing when she sent them. Because she was claiming initially, I would go out the window and I would look and see. And every time I looked, I would send a text. The car was still there. And then the last one I saw it drive off. No, she had to change that testimony trial because Karen's car was not there at 12:45. That's pretty clear. Nick TTT, Apple's internal docs and user reports consistently indicate that driving in a car, even with significant altitude changes, does not record stairs climbed as the required walking motion is absent. This is a quote, so I don't know what it is quoting from, but yeah, this is what I've heard repeatedly, that a car is not going to mistake, or the phone is not going to mistake a movement in a car as a step, because what it's doing is it's evaluating a specific pattern of motion that is the pattern that your walk looks like, and so that is very specifically what it is looking for. And cars don't generally replicate that. So, do we have an expert from Apple? It'd be nice to maybe have an expert from Apple explain how all that works. I kind of doubt it. They probably wouldn't. It's proprietary, trade secret, stuff like that. They could probably get out of having to disclose any of that, but would be interesting. Nick TTT, stairs climbed don't actually mean stairs. The timestamp doesn't actually record the time. The location is accurate, but not really. The sensors are accurate when I want, but not when I don't want. Yeah. Yeah, right. Isn't it ironic how all of this stuff only really you can only really put any weight on it when it's going the direction I want it to go, you know? Don't count the location data when it's more accurate. When it's more accurate and showing him moving towards the house at the same time that these 36 steps are happening. Don't pay attention to that. Why? I don't know. He didn't explain, but it's more accurate, so it doesn't necessarily mean movement. That was Ian Whiffen's explanation. Tell me how that makes sense. How does that make sense? It's more accurate, so it doesn't show movement. It's showing movement, and it's more accurate, but it's not movement because you don't want it to be. Because you need to reconcile that with John never walked into the house. What this phone data does not seem to show, it does not show that those steps equate to John getting hit by a car. These steps happened before because he's messing around with his phone, looking at his text, locking it with his phone, unlocking it with his face, etc., etc. Oh, I can't wait for more Alessi Cross tomorrow. I'm like already excited about it. I'm already excited. I can't wait. I can't wait to see where we go with it. The rural juror, what time was Jen's 911 call? That is $1 million question, isn't it? 1 second. I'll see if I can find out from the last trial. Okay, Jen McCabe's direct. Is on day 14. So let me see if I can find it. Okay, Jen McCabe direct. We already knew you were friends. Met up at CF McCarthy's after the basketball game. What was going on that night? Then the text to John. Suddenly now at 12:40, she doesn't know if they were still outside or if they had already left. That's not what she said the first time she told her story. Okay, so then the whole next morning, woke up, phone ringing, etc., etc. Let me get through that. Okay. She called 911. We don't have a record yet of when that was. Just the fact that she called. So I don't know that I got it in my notes, guys. I don't know if I didn't get it in my notes from her testimony. I don't remember if the call came in a different way, if it came in through the first responders. I didn't write it down, so I don't know. But we know it was sometime before the first responders got there. Testified it took a little bit longer than normal for them to get there from the time that they were dispatched. I think they said it was normally like a 2-minute drive, but it took longer. So maybe 5 minutes before they were coming on scene. And my recollection of the dash cam video is that when it started, we were seeing like 6:08, 6:07, somewhere in that time frame. So a couple minutes before that, I don't know. I'm trusting we will find out in this trial, but that's just my best way of trying to kind of reconstruct when it was, but I do not remember off the top of my head. I guess chat says 6:03:47. That is very precise. And so if chat remembers that, I'm going to defer to the collective wisdom of chat that the 911 call was at 6:03:47, but I don't know yet. Can't verify that. We'll get to it, I'm sure. Byron Butterfield, never heard of an iPhone camera being able to provide Doppler info. I checked with my optical communications engineer son, and he concurs with me. Yeah, I don't know what any of this stuff is. When I think of Doppler, you know, I'm thinking of radar. I'm thinking of that thing you get on the weather report. I don't know if this is the same thing. I don't know if it's a similar thing. I don't know if there's any relationship between those things at all. I don't know. But the Doppler is apparently just the thing that's telling you if the phone is in pocket mode or not. And by pocket mode, all they mean is that the cameras are covered up, right? So all he said it meant was just that the phone is covered up, therefore it's in pocket mode, and then as soon as it gets uncovered, and there's something that triggers it to check, it will show that status is cleared. Pocket mode is cleared. I don't know what, if anything, that has to do with the kind of Doppler that tells you about your weather. Somebody smarter than me in the chat can tell me if there's any relationship at all, or if I am just, you know, connecting threads that don't have anything to do with each other. That's what I thought of when he said Doppler. So yeah, I don't know. No idea. That Southern blonde lawyer, it's like we've only seen Alessi shoot free throws till now. Today, he's going to do some breakaway drives and dunks and a few in-your-face blocks. Everything can be a sports metaphor in my book. Oh, this reminds me of just a couple days ago, you know, things come up in the feed or whatever. And I remember a good old memory where after Michael Jordan retired, some guys, some like loudmouth and like, oh yeah, I could beat Michael Jordan in one-on-one. And so Michael Jordan shows up at his practice and probably absolutely destroys this guy in a one-on-one pickup game. It's pretty epic. After he's retired, Jordan's not even an active player at that point. Just absolutely schooled this loudmouth. Oh, yeah, you know, we didn't get nearly as much of Mr. Alessi as maybe we would have enjoyed today. But he sure was laying his foundation, wasn't he? Here's these parts of your report that I want you to look at, and got those established, and then the small little deviations from his report to his testimony. The device bearing shifts westerly as the device moves west from the roadside, which came from the location data, which he told us here in court. No, that doesn't mean it was moving. It's just more accurate. The accuracy was increasing, so it didn't intrinsically prove the phone was moving. Explain that to me. It's better data, so it's less, you can't rely on it to show what it is purporting to show you. Explain that to me. He doesn't, I got the impression that he was trying to suggest that these send messages, when the messages were read, he didn't identify in his PowerPoint who the message was from. He reported who the message was from when he showed the time that it was sent, but then when he was showing it was read, he didn't report anybody. And so I thought initially, like, is Mr. Alessi trying to like get a dig in on that? Like he's hiding something? I don't think he is actually. He's just making sure for purposes of clarity that we understand which message is happening with which person. Because if you go back and you just look, you know, you just look at the data, you might not realize that. Yeah, the Doppler shows the pocket state, says it doesn't necessarily mean it's gone into a pocket. It just means the camera is blocked and the device received a phone call or was picked up in a particular way. or it was picked up in a particular way. And that triggers the Doppler to do whatever the Doppler does to see if there's a face around. And the camera has to have been blocked previously to get a pocket state cleared. So it has to have been covered, and then there's a call, and the device is moved in a certain way, triggers the action, it checks, now it's not blocked, and it'll register cleared. So some clarification on how he says that worked. So yeah, 1229.37 to 1229.42, it went from pocket state to cleared. It means he took the phone out of his pocket or wherever it was. It had been blocked. It was no longer being blocked. And then, yeah, that incoming phone call from Jen McCabe at 12:29, he nailed that down because that's important to the timeline. Jen's previous testimony was they were lost. They called me. I gave them directions. We were all still in the car. No, because John was already outside of 34 Fairview according to your own location data. And yeah, then the steps, the timing of the steps start at 12:31:56. They show 36 steps going 25 meters, which is approximately 84 feet, but which he agrees with at first, but then it's about 3 times. Well, it's a little bit more than 3 times, isn't it? Because 3 times is 75 feet and it's 84. Let's do a Google thing. Convert meters to feet. Let's see what the WAZE Google said. It's 3.28 feet. So it's actually 3.25 feet. That's quite a bit more. Quite a bit more. Google tells me it's 82 feet. 25 meters is 82 feet. More than 75. But he didn't backpedal on that, right? Now let's minimize it. It's more like 75. Anybody happen to know how far it is from that berm to the front door? Anybody happen to know that? I don't remember that, but I do know from the 16 miles an hour, over several seconds at the front of the house, means that they were moving like 200 feet before the car came to a stop, according to his testimony. Does this yard look about twice as long as it is wide? It kind of does to me. Maybe that gives us a ballpark. I don't know. Maybe not. But I have a feeling we're going somewhere with that because we made a point of nailing down. He started walking 84 feet at 12:31:56, and he finished at 12:32:16 after he hit the lock button on his phone. So that's the 36 steps. You cannot reconcile that with, just like the phone might record steps when you're driving on a hill. The phone might record steps when you're struck by a vehicle and pirouetting through the air and landing on the front lawn, the rock hard, rock solid front lawn. Not going to be able to explain that because you're not checking your message from Jen McCabe while you're pirouetting through the air. And that's what the phone activity shows. He's engaged with his phone, taking action with his phone. When he gets hit by the car, spins through the air, hits locked and then lands. No, of course not. Of course, that's not what happened. So, the Commonwealth said they were going to bring the facts, science, and data. And sure, they gave us some numbers, but do these numbers help their case? Do these numbers prove that John O'Keefe was hit by a car? No, we talked about this at the beginning with those openings. He threw out some numbers to make it sound sciencey, but he never told us what any of it meant. And so here we're going to overlook the steps. We're going to overlook the location data showing things moving. We're going to overlook the location data that suddenly becomes extremely inaccurate and includes the entire 34 Fairview house, which, by the way, can happen when you go into a basement. We're just going to ignore all that and decide, in our opinion, the phone was out there by the flagpole the entire night. That's what we get. I'm looking forward to seeing Mr. Alessi's performance tomorrow. I feel like we got some steady work here, but we didn't quite get the showmanship. We'll see if we get some. Skylar K, maybe it's Monday brain, but I'm having trouble gathering the key points from Whiffen's testimony. Will you please do a quick breakdown? P.S. You're the best. I think it's been summarized very well already. There is reliable data in the phone when it establishes what the Commonwealth wants it to establish, and when it tends to contradict that, it's not reliable. So basically, all he's testified to is series of location data that he was able to obtain from different points. We already kind of have a preview that there may be an issue with the time frame because of the WAZE app and the discrepancy between the WAZE app time and the Apple internal clock time, and we don't know where that data is being pulled from. Where, if WAZE is reporting it, would the time be off or not? Would it be coming straight from Apple? That's not entirely clear. But so he presents this roadmap of where the phone was at different points in time based on the location data. It very much advances the timeline from what the Commonwealth had originally suggested the timeline was going to be, that this accident happened, 12:45-ish. No, we're up like another 15 minutes now. And we saw that adjustment during trial number 1. Besides that, the battery temperature data, which has got some strange activity happening in the very, very right after 6 a.m. time period. Don't have that explained yet. Also, steps taken in that early 6 o'clock time frame. No explanation for that happening either. So yeah, that's pretty much what we got. And then the last thing that he provided us was this issue with the pocket state, which they get from the Doppler. The phone is scanning for a face under certain conditions. If the camera is blocked, it will record a pocket state. It's assuming the camera is in your pocket. And if you receive a call or you move the phone in a certain way and the camera is unblocked, it will not show that pocket state. If it was previously blocked, it will show it cleared. So the $1 million question now, because we have Jen McCabe's phone extraction, when she was butt dialing John O'Keefe over and over and over again after saying like the 12:50 p.m. kind of time frame. What's the pocket state? What's the pocket state? Because it should show it's in pocket state for every single one of those if those are butt dials, right? Should show pocket state. We'll see, won't we? Just a little hint of something that we might be able to look forward to in the coming days. So that's my best quick and dirty summary of Whiffen's testimony. Oh, and bottom line, he says, the search didn't happen at 2:27 because that's not how this database works. But he just didn't provide the clearest explanation because some of his examples seem to contradict his explanation. And then he gets to the very end and says, I don't know why it's showing as deleted. I couldn't recreate that. So you don't actually understand how this database works and reports data. Little bit of a problem. John O'Neill, unconscious faces unlock phones. I wonder if John generally used the lock button instead of just letting the screen lock. Jen, Karen was home already. Yeah, I don't know where this is going to go. If there's a suggestion that this is somebody else manipulating John's phone, yeah, put it in front of his face to unlock it. I don't know. I don't know if that's going to be part of the defense theory, but it seems like that would be doable. I don't know. I don't know whether it would or not. I don't have an iPhone. I've never tried to unlock somebody else's iPhone by putting it in front of their unconscious face. My husband doesn't have an iPhone either, and I'm not the person to check his phone anyway. No. If you got to check your other's phone, you need to question whether this is somebody you want to be with. Or maybe look in yourself and your own need to have that kind of control over somebody. There's an issue there if there's phone checking going on, in my opinion. Of course, I'm an old Gen Xer. I don't deal with these things the way the younger generations do. But yes, I for one believe in a certain scope of privacy, even within a relationship. Mike from Providence, a juror is being questioned at sidebar with all the attorneys present. This was happening right before the break when Ian Whiffen was let go for the day. But before everybody went to lunch, we weren't able to see it because they don't show the jurors. We just saw the camera being pointed at the fan. But we did see some reports from the courtroom. I saw this when I checked real quick when we're on the break. Folks saying that a juror was questioned. And apparently, my understanding, according to Christina Rex, is that the juror was not let go. So we don't know what any of that's about. And we may or may not ever find out if sidebars are going to continue to be impounded. Wasn't that also an issue that was raised? The defense raised. We're objecting to that this time because it's a public record, as you should. Yes, they are public records. And we are entitled to know the basis for decisions and so forth. You don't get to insulate all that from public view just by deciding to have it behind the scenes at sidebar. The purpose of sidebar is to prevent the jury from knowing what you're talking about while the trial is going on. There's no reason to be having sidebars if the jury is not present. Okay, that's issue number one. There's no need for it. What do you need to keep secret outside of the public? Only possible thing that has come up in all of this is juror names. And you don't need to use juror names. You're probably not using juror names at this point anyway. You're using their numbers. That's how you know them by now. That's the information that you see over and over and is being reinforced. The juror numbers. So you could be doing all of this in open court for all of us to see right now in real time, but it's still not happening. We're still having these weird sidebars before the jury is ever even in the courtroom. So we'll find out, I guess, if and when there's a transcript prepared. But for now, we don't get to see. And for why? No particularly good reason. None that I can see. A juror being questioned is actually a good reason to have a sidebar. Yes, you do it. You do it that way. And to the extent you need to keep any of that information from the public, it's the juror's name. Everything else, we should be entitled to know, because we should be entitled to know what's the information, what's the decision, evaluate for ourselves. Is this a good decision in light of the information that was presented? That's what the First Amendment protects, is our ability to evaluate our government and how well it's doing its job, including the judge up there on the bench. So peculiar that we're still having all of these sidebars for things that should not require sidebars. Mandy, paralegal in Finland, I fall asleep listening to you. It is 8:10 p.m. now, so a couple of hours to go and rewind in the morning. And this is probably like at lunch. So it's been a little bit since then. Mandy, if you're still with us, thank you for hanging out with us. I'm glad that you find my voice to be a soothing and relaxing presence in the background. I will take that as a compliment and not, God damn, Andrea, you sure do bore me to tears. I trust if that were the case, you wouldn't be here unless you really actually do desperately need a sleep aid. Hey, come on, man. Get what benefits you out of this stream. And if nothing, there's others. Thanks for being with us, Mandy. Katia Kane, I hate the way the judge shushes Alessi. Big difference when talking to the Commonwealth. She doesn't even expect the Commonwealth to follow the orders she's laying down. No more comments. Never once enforced it. Never once rebuked him. Never once did anything whatsoever to try to suggest that's something he actually needs to pay attention to. He ignored it with impunity, and she did nothing. Meanwhile, after the Commonwealth puts on that whole show, then Mr. Alessi gets up to do questioning, and she wants to know, are we going to get to the other guy today? Maybe if Mr. Brennan hadn't been so argumentative and so snotty and hadn't continued to ask the same thing over and over and over again, because he would get the answer and he didn't like the explanation. So he'd go back trying to get the answer over. He got the answer. I don't remember. I don't even know how many times. And he would keep coming and trying to characterize it, trying to transform it into something else, trying to suggest it was something. How can he say what it was if he doesn't remember? He's already told you that. So maybe if Mr. Brennan hadn't put on that whole display, you wouldn't have to ask. Why would you ask Mr. Alessi that? Yeah, the disparity in treatment is pretty clear. If the defense is going to shout over the judge while an objection is pending, do you think she's going to just sit there and let him? I got my suspicions that that's not how it's going to go. John O'Neill, the phone went to low accuracy because they put it in the Faraday bag they got at Canton PD, put in 50-degree bulkhead for several hours with his body. It's plausible theory to me. Although, I gotta take issue with one thing. Okay, the Canton police, they don't even have evidence collection bags. They suddenly have a Faraday bag. No, we're not necessarily talking about Canton police, though, are we? We're talking about who was in this house, and that's Brian Albert. Brian Albert is on the fugitive response team, so he's out arresting the baddies out in the field, hunting them down. And do you think the baddies that he's arresting have their phones on them sometimes that need to be secured and then taken into evidence and examined and so forth? Uh-huh. Yeah, it does. You're prepared to find phones and take phones into custody. And what's a very common thing to do when you take a phone into custody? You put it in a Faraday bag. That's possible. It's possible. That whole long period of it sitting at 50 degrees, pretty consistent temperature for like 5 hours until 6 some. 50 degrees is definitely not ambient temperature, and it's not body temperature. It's somewhere kind of in between. But John is he's, he was 80 degrees by the time they got him to the hospital. Maybe before, maybe when they started working on him. Can't remember exactly the timing of his internal and temperature being 80 degrees. But he's already started to get cold, but this phone is staying steady. I have a hard time. I wonder if ARCCA is going to tell me anything about that. I have a hard time believing that a phone sitting outside underneath a dying man, a man who died at some point, who was already getting cold by the time he was found at 6 o'clock. The man is such a small mass relative to the earth. Yeah, I don't know. It definitely stuck out as strange to me. And then whatever triggered that sudden drop at six something, it doesn't fit their story. That's not when Carrie said she, they lifted the EMTs lifted up John, and that's when the phone was revealed, and that's when she stuck it in her pocket. That didn't happen until at least 10 minutes later. And why are there steps? Why are there steps recorded on the phone that they just kind of brushed over in Mr. Whiffen's testimony? They just kind of brushed over that. The only movement after midnight was 36 steps shown. Well, at that point, but you recorded it. You recorded it the next morning. Let me go back and let me go back and find that. "6:04 a.m. Between 6:04 and 6:11, 432 steps recorded. Why did the phone start taking steps at 6:04? That's not how Carrie Roberts described it. It's a mess. Amy McCammon. Death wasn't ruled a homicide. How is Karen Reed on trial for murder? Because they don't have to rely on the medical examiner's determination. They can disagree with it. The ME isn't the jury, and so it's for the jury to decide. Her opinion is one thing for them to take into consideration, and I certainly hope they would do so. But she's not the driver of what happened here and what the situation is. So they disagree with her. And that's the bottom line. That's why she's on trial. McRae H. What's the difference between driving 1.4 miles an hour and walking? How does the phone know the difference? That's a good question. I would guess it would have to do with steps. If the phone is recording steps, you're probably walking. If the phone is not recording steps, maybe you're not. It's just that then we also kind of heard that there's a little bit of discrepancy between when things actually get logged. It may not get logged till like a minute later, when the event happens. So yeah, I don't really know how all of these variabilities, all these variations fit together. It just sounds to me like there's enough wiggle room in a lot of this stuff that it's going to be very difficult to get a cohesive image of everything, like down to the exact second. I'm not really convinced that that's going to be possible. There's a lot of different things happening in different places in the phone that record things in different ways and that rely on different clocks, even some of them. So just a bit messy in terms of how do we make sense out of this whole picture. I'm not sure. That's my best guess. Steps versus no steps would tell you walking versus driving. 10 Cat, Brennan's contempt is so bizarre. I get why he wouldn't like them, but he is seething with rage. Very odd to get this hot about an expert. Well, is it performative or is it real? That's question number one. Is this actual real rage or is this just performative? Like I said, mark this. If ARCCA gets to testify in this trial, he's not going to behave like that with them. I'll bet he doesn't behave with any witness at trial like this in front of the jury. No. And that tells me it's not rage. It's if he doesn't ever do this at trial, even if he gets really pissed off, it's not rage because he can control it. It's just performative. So that's my suspicion, And he's doing it because he wants Judge Bev to share it. He wants her to feel his rage and be persuaded by it, share it. And maybe a small reflection of that will be, encapsulated in her order, in her decision making. So he's playing mad because that's what he wants the judge to do. That's my read on the situation. Michelle, I can't tell if Bev is letting Brennan show his arse on purpose or not, but I'm getting YSL ADA love vibes from him. Jurors don't like jerks. Yeah, so I only saw a few clips of ADA love. Like, my God, that trial would have driven me out of my mind. What an incredibly obnoxious, incredibly obnoxious prosecutor. That's why I don't think you'll see Lally behave, Lally. I don't think you'll see Brennan behave like this in front of the jury. I don't think you will. He knows. He only did that because it's in front of Judge Bev. He knows that the jury isn't going to like that. Just wait. We'll wait and see. But that's the marker I'm putting down. He won't behave like that in front of the jury. Pine Rider, beta male Brennan meets alpha male Wolfe. Brennan the Weasel is exactly why so many people absolutely hate lawyers. Can't wait for the defense to get Morrissey on the stand. He did live up to every bad caricature, didn't he? The twisting things and the so you said and the getting argumentative. Coming back with the same thing, the snide little commentary, the editorializing that he should not be allowed to do, but nobody's going to actually stop him. Nobody's going to actually stop him. Yeah, I thought Wolfe held up to that extremely, extremely well. Didn't lose his cool. I didn't look at it at this beta versus alpha thing, but I'll tell you what I did think of. I had a moment where what crossed my mind is the omerta. Okay, the omerta. I don't even know how you translate that, but it's from like the mob films and stuff. They have this like sense of cool, this don't touch, don't react. Don't let other people kind of influence how you're going to behave in a situation or what your emotions are going to be. Like, none of that. You just stay calm and collected. That's kind of what I got from it. Like, this guy's like a Capitan or something. He's got that down. Very unreactive. So yes, Brennan comes across as threatened and hectoring and just trying to overcompensate for his lack of being able to catch ARCCA in anything really significantly wrong. He's trying to substitute his rage, his performative rage, for substance. Duncan, Idaho, if the Commonwealth can play clips of the Karen Read interviews, can the defense also play clips of those interviews, or is defendants' only recourse to have Karen Read testify? They are generally going to have her testify because the Commonwealth gets to use her statements. They are statements of a party opponent, which is an exception to the hearsay rule. Karen Read's own statements, when she offers them, are not the statements of a party opponent. So they are not within that exception to the hearsay rule. If she is going to offer her own statements, they have to come within some other exception to the hearsay rule. And the only one that is like really likely to come up at this point, as far as we can tell, is the rule of completeness. This idea that if the Commonwealth is cherry picking things selectively, taking them out of context in a way that makes them misleading, then the defense can say, you need to show the rest of it. Like, the most common example would be you're playing something that she says and you just cut it off mid-sentence, but there's more that she goes on to say that kind of like puts it in context or clarifies what she's getting at or something like that. That's kind of the classic situation where it's pretty clear that it's going to apply. They want to put in a piece, you get to say no, she gets to finish her sentence. But when it comes to being broader than that, it's really going to be up to the discretion of the judge. Some people will have a very broad understanding of what's fair context. Other judges will have a narrow one. I'm predicting in this situation, Judge Cannone is going to take a very narrow view of the rule of completeness. She's not going to say, oh yes, these entire interviews are the context that you need to be able to evaluate a particular statement that the Commonwealth puts in. So no, the defense has nowhere near the liberty to use the interview clips that the Commonwealth has. And so by and large, if they want to counter this or they want to provide additional information from her perspective, she is likely going to have to get on the stand to testify to it. Zeke, Texas NP. I work for the government. I send a "what did you do last week" email every week. I keep track of what I do. Faux show. Don't want Elon firing me. I remember when that came out. Part of the whole Doge thing was Elon sent out, I guess, that message to all the federal employees. I forget if it was over the weekend or like on Friday or something like that. But like on Monday, you all need to send an email just describing what you did in the past week, and just the outrage, the response to that. The reason why it caught my attention is just because, I personally, like, being able to account for your time doesn't seem really that extraordinary to me. Okay, I'm a lawyer. I'm used to dealing with billing time. I haven't been in private practice for a while, but yes, in private practice, oh boy, are you tracking your time in excruciating detail. In fact, part of the reason I moved back into public defense was just how much I hated the time waste of having to spend as much time tracking your time as you do actually doing substantive stuff. It can be very very annoying. You generally don't have to track your time as much in public defense, although that did kind of change in Washington over the course of my kind of final time there. But so I understand maybe I have a little bit of a different perspective, but to me, it just doesn't seem all that outrageous that from a very broad general standpoint, you should be expected to be accountable for what you've done on the job that you've been paid for. And you're not special just because you're in government and you're not expected to bill your time. He wasn't asking for an itemized bill. This was just to account for your work. So to me, it was a situation where I kind of wondered, is the point here more just the outrage that it generated? Was that why they did it? To show look at how outraged these people are at having to just say, briefly what they did for the last week. Or was it actually substantive? We legitimately are going to use this information for some purpose. I don't know. But, yeah. Of course, people track their time, and especially an expert with a private firm. Yeah, they're going to keep track of what they use, what they spend their time on. Does not seem extraordinary to me. Nick TTT, this is the result of a weak and biased judge who has refused to put her foot down to a sniveling prosecutor. What a circus, all due to this judge's seething bias. She is responsible for this BS. Well, we just saw it. We just saw her not keeping Hank in line, letting him run the courtroom, letting him decide not only is he not going to respect his adversary, his opponent who is making an objection, the court who is attempting to rule on it, but he's going to double down by yelling in this, completely unnecessary histrionic manner. And what happened? Absolutely nothing. Absolutely nothing happened. So yeah, no grave concerns about any of that. I mean, we've seen this. We've seen this for a long time. These parties do not get treated the same. And now he's made it absolutely crystal clear. He's going to do what he wants. He doesn't respect her. He doesn't respect her authority because she's not going to enforce it, and he's figured that out. He is a dog running down the block while she's saying, Sparky, come back. Come, Sparky, come. And he's completely ignoring her, and she's not doing anything else. That's the situation we're in right now. Duncan, Idaho, I wish YouTube would let me say what I think of Brennan. Being an attorney against him would give me ulcers, high blood pressure, teeth grinding, the lot. Attorneys like this are the worst. They're the worst. So, just so obnoxious. Me personally, I might have intervened a little bit more. I might have objected a little bit more, you know, break him up, make it difficult for him. It's just a call, you know. I'm not saying, you know, Alessi did object quite a few times, particularly when it was clear, but he wasn't getting them. It's not in front of the jury, so it's not a situation where you need to worry about that. So I might have objected a lot more, make my point. My point, Your Honor, is that this is unacceptable and you're continuing to let him get away with it. So I'm going to keep objecting until you get your courtroom in hand. You know, I'm not going to say that, but that's going to be my thought process. And of course, then I would probably, if I'm, you know, Alan Jackson, then I'm probably getting blamed for what's going on in the courtroom, because the issue would be the objection and not the offensive conduct that's happening, right? Yeah, lawyers like this are, they're just not, they're not fun to deal with at all. Duncan, Idaho, Judge Bev meekly, no comments, please. Brennan completely ignores her with impunity. Yeah, over and over and over again, she just completely ignores her, and she does nothing. She doesn't even get sterner in her tone. Doesn't even get that exasperated sigh or that, you know, that tone that she takes on with Mr. Yannetti. Mr. Yannetti has been known to drop a little editorializing here and there, and she'll cut him right off. Mr. Yannetti. None of that. None of that for Mr. Brennan. He's deciding what he's doing because he knows she has no bite. The bark, you can ignore it. There's no bite. Kathy, your realtor in Jersey, I hope Breathing Bev gives Dr. Wolfe credibility first for being law enforcement as she loves, and then his clear testimony. He does have that affiliation with the Department of Justice, right? But I'm not sure that Bev is really appreciating the Department of Justice or the FBI in this context. And to the extent they get any of that kind of default credibility, well, doesn't that make ARCCA kind of a turncoat? Because they're here for the defense. They're not here for the law enforcement. Just don't know how she would interpret that. She could, yeah, she could look at them as an arm of the FBI, or she could look at them as you know, you're crossing the line here. You chose the wrong side. So I don't know. Yes, his testimony was very clear. Struck me as, you know, fine, not evasive. He answers consistently. He answers promptly. There's not a lot of like, ooh, let me sit and think my way around how to answer that question. You know, he offered explanations. When he wanted clarity, he would ask for it, but if he didn't get it, he would do his best. He struck me as a very credible witness, but she gets to decide. And as we saw from that old UK trial and old Justice Nicol, they can decide pretty much whatever they want when it comes to witness credibility. And what the rest of us think, it doesn't matter. It doesn't matter what the normal rules are for evaluating credibility. They don't matter either. You know, who on earth on this planet says, I'm not going to give any credit to an audio recording because it wasn't under oath? Well, maybe because it's recording the events as they occurred at the time before anybody thought they had an incentive to lie about them. Maybe that's why you would give that credit. If she doesn't want to find him credible, she will find a way. And what the rest of us think doesn't matter, because she has pretty much untouchable authority when it comes to when she gets to decide certain facts, predicate facts, like what happened when with ARCCA, communications, etc. Yeah, she gets to decide those predicate facts, and she gets to evaluate credibility as part of it. James Casatelli, if Bev were normal, she'd retire after this case. I don't know. I mean, I really don't. We saw Judge retire right after he was done in the Koberger case. Were those things related? I have no idea. I really don't. But it is just kind of, it's what popped into my head when I saw this. So yeah, you get done, you step out. I don't know. I really don't. The Touhy Show live. She doesn't want to control the courtroom. She only cares about whether she has no choice but to exclude their expert testimony. Yeah, I mean, I can see this. If she cared about controlling the courtroom, she would control the courtroom. She's no shrinking violet, as one might say, about issuing the restrictions and the warnings. The findings of contempt. She hasn't been a shrinking violet about any of that. So yeah, if she wanted to do it, she could. She's not doing it. We can infer from that she doesn't want to. So why not? Well, because maybe it'll give her something. If she wants to exclude ARCCA, maybe this will give her something that she can hang her hat on. Edward Kirkpatrick. Experts weren't sequestered last trial, if I remember correctly. I'm going to make a note and see if I can go back and check. Experts sequestered. Because it's, they're normally not. Like, there's no reason to. It's generally not necessary. So if there's a sequestration order, typically they're exempt from it. But I just don't recall the specifics on this. I'm trying to remember if there was anything about like people present listening into other people's testimony. I don't recall off the top of my head. But that would be a problem for Hank's argument if they were exempt from it. And that would take away that basis for her to say, yep, easy exclusion. There's a violation of the sequestration order. That's contempt. I can sanction them based on that. If they were exempt from the sequestration order, then that argument doesn't work. Alex Kane, is Judge Bev's decision appealable now or after trial? After trial. Nothing pretty much is automatically appealable like at the time that it happens. You can always ask for discretionary review before the trial is over, but there's just a lot of reasons why that wouldn't happen here. Number one, they're not going to decide it in a time frame that's going to benefit you anyway. Like if this trial is going to last another month, even maybe another 6 weeks, extremely unlikely that an appellate court is going to decide an interlocutory appeal within that time frame. So it's not going to benefit you anyway. You got all this other stuff going on that you need to focus on. Trying to focus on getting an interlocutory appeal filed, followed up on, briefed, etc. That is diverting your resources from the task at hand. So I don't think that they would do that. No. Even if frankly it were like easier and more available to do that, you got to prioritize what's most demanding of your time and attention right now, and that's this trial in front of this jury. Because if you play that right, you may never have to worry about appealing it. You get your acquittal, you don't have to worry about appealing anything. But you worry too much about this other stuff, it might distract you enough that you get the conviction and then you got to deal with it. So you got to focus on what matters right now. That's getting her acquitted. And if they are not successful in that, if the jury does convict her, then that's the point where you start worrying about raising issues, appeal issues. Nick TTT. So all that for nothing. Lol. She's going to allow Wolfe to testify. She realized the circus she created for nothing. That's a read. I don't know. If that's where she's going with it or not. She did, yes, eventually kind of cut Hank off at the end of his cross with Wolfe, and then made it clear Renstchler is going to be very short. I just took that as he's not going to add much to what we already got from Wolfe. He wasn't the primary point of contact. There's no need to go over all of the same stuff with him, the way that they went over it with Dr. Wolfe. So I understood that as being kind of the reason to limit Renstchler. With Wolfe, wasn't clear. They had that sidebar, and then basically we were done. Like, she's like, I get the point. They were Brennan was talking about how without the raw data, you can't necessarily vet their experiments and stuff like that. She gets the point about Commonwealth wants more time to respond. But the issue is really who is at fault, who's in the driver's seat when it comes to why are we right here with ARCCA only just now, able to complete their own testing and still need another week and a couple days to do their analysis and present a report. According to ARCCA, it's because they didn't have the data. Can't do anything until you have the data. So if she finds them credible, that's a very good explanation. I mean, it certainly makes sense to me. You don't even know what you need to do. So how do you write that contract? Nobody's writing an open-ended contract that says, depending on what the Commonwealth produces, do whatever you think you need to do and then charge us for it. That is not how expert contracts work. That is not how they work. You have to have a pretty good estimate of what you're planning to do, how long it's going to take, what you're going to charge for it, etc. Just depending on how complicated, how established the firm is, can determine like how detailed your contract is in terms of like, how do you change things? You have to submit a change order process, and this ARCCA is a very large firm. So yeah, it struck me as very credible. Started exploring the possibility of revisiting it when they got that disclosure, the initial disclosure of the report in February. Had to get the permission from the DOJ, got it. Didn't have the data in the meantime anyway. Finally got the data, sent it over at the same time as we have the okay to be able to retain ARCCA. Everything Hank was trying to get at as far as like collaboration between the defense and the Department of Justice, no proof of that. That all fell completely flat. So any grave concerns about that? No, of course not. Of course not. I don't know if she's going to allow them to testify or not. I really don't. I think she wants to keep them out. I think she recognizes it's risky to keep them out because she has already nodded. She's already nodded to that. Karen has the right to present a defense. And to me, that has to apply to responding to this new accident reconstructionist. Because if you exclude ARCCA, you're saying she doesn't get to defend their theory of how this accident happened. You are taking away her ability to defend that. That's really significant. So it's hard to do that as a sanction. It's hard to justify why that would be necessary as a sanction under these circumstances. Much easier for her to be able to, maybe limit things or something. So I just don't think we're going to get a completely unrestricted ARCCA can do whatever they want. We're just too far down this road. She's invested in it. She's bought into it. She's allowed this whole process to unfold in anticipation that there was something that was done wrong that's going to be disclosed. Is she going to want to backpedal? Be like, never mind. No, I'll bet she uses it to justify why they did this. Already found that there's been a discovery violation, and come up with some way to limit them. We'll see. Z, Dr. Wolfe, if I like Welcher report, it's done quicker. Well, I mean, that's kind of true, isn't it? If he says sensible things and uses sensible methods, it's not as hard. It's not as hard. That would make sense. It's only if there's like big problems with it that you need to go through and do more testing and validation and so forth. How the hell did this guy get to this? I don't know. I better test it myself. That kind of thing. Yeah, if he agrees with it, hardly takes any time. I see you. Carrie drove from John's Albert. She testified 82, 10 minutes. Aussie inside said going from road to first floor is one flight. She drove from John's. Well, she drove from John's first with Karen. She was going to take Karen back to John's, I guess, to get her car, but then got the call from the Sheriff or whoever called her to say, bring Karen back because we're going to section her. So then she went back to the scene and took Karen back. Then she went to the O'Keefe's house and picked them up and drove them to the hospital because she had four-wheel drive and they didn't, except Peggy testified that they did. Just little things. Yeah, I don't remember. I don't remember these details. Going from road to first floor is one flight. It could be. I don't know. It doesn't look like much of an elevation change. There is going to be some elevation change, but didn't really look like, what did he say? 16 feet, 3 meters. Didn't really look like 3 meters elevation change. Getting out of the car isn't going to be that much. I don't know. We'll see what the defense gives us because I'm sure they've got a theory. Jeffrey B., according to Google Earth, it's 17.6 meters or 57 feet between the flagpole and the front door. It's also 78 feet to the side door if he took a straight line when he went into the house. Kind of lines up with the step data, doesn't it? That lines up with the step data going in the house. Perhaps in that front door and then the one where you go immediately down into the basement where the location would get really bad. Kind of sounds like, maybe the data is consistent with something like that. Interesting. I have no idea how accurate Google Earth is. I would assume that it's just, as accurate as Google's other location data, which they're, telling us at least at times is pretty accurate. So it seems like that's going to probably be in the ballpark. Good find there. Amy's Positive Pathways is a member. Welcome to the channel, Amy. Appreciate having you here. And then also Andy Junction is a new member. Welcome to the channel. Thanks for being here with us. Kathy, your realtor in Jersey, seemed to me Dr. Wolfe made it clear how unclear the financial obligations were at the time. Yeah, he really did. And also that it had nothing to do with him, which is very consistent with a big firm. Okay, a professional engineering firm, you're going to use your expensive, qualified, educated, skilled personnel. You're going to use them for their highest and best use. And that is not sending out bills. That is not what they're going to be doing. They're going to be doing accident reconstruction because you can pay somebody who has a small amount of training in bookkeeping to be able to send out the bills. You don't need a degree for that. You can learn that on the job. You could be trained to do bookkeeping on the job. So you're going to use somebody else to be doing that kind of data. Makes absolute perfect sense to me. He wouldn't be paying attention to the billing details whatsoever. It's not his purview. He's there to do specialty work. I didn't catch anything inconsistent in what he said. I didn't catch Brennan catching him in any kind of inconsistency. Like, to me, that comports with reality and it seemed credible, and I believe it. It was very confusing. It's a unique situation. The pause email seems to very much substantiate the explanation of kind of how all this went. So I buy it. Mama Bear, Wolfe said they are only there to rebut the new Commonwealth expert. That is why they are doing more testing. So all the previous discovery doesn't mean much. Yeah, that was an interesting thing that he said, isn't it? Because I don't know what the defense has disclosed in their disclosures. If the defense has disclosed in their disclosures that ARCCA is only there to rebut the new Commonwealth expert, then that means they haven't disclosed they're going to use ARCCA the same way that they did at the first trial, to use that original work that they did for the FBI. If they have disclosed it and there just hasn't really been a conversation between probably AJ and Dr. Wolfe about that, that's fine. That's between them. They can clarify exactly what's anticipated. But I did catch that because it made me wonder, I wonder what the defense has disclosed about what ARCCA's role is. Because if it is limited to just responding to the new expert, then they're not bringing in any of the old stuff. And yeah, the whole issues with the previous discovery and was it biased or not, that would be off the table. I can't imagine the defense is going to do that because it was such a gift. It was such a gift to have this complete, no skin in the game, no dog in the fight party come in and say, yeah, he wasn't hit by a car. You don't give that up just because, So I suspect that is probably just a miscommunication between Mr. Jackson and Mr. Wolfe, or possibly just Mr. Wolfe being very cautious, not fully understanding the question, something like that. But I expect ARCCA is still going to be asked to testify about the testing and conclusions and analysis and everything that they did prior to the first trial. TG, do you think it's possible that the entire aim of going after Karen Read is to misdirect attention to keep locals from being held accountable for murder? If so, they are succeeding, right? I mean, I don't know. I'm not sure exactly what this is getting at. I don't know if this is relating to Sandra Birchmore. I don't know if this is relating to that was MSP, the guy that got beat up, Enrique Martinez, I think his name was, the guy that got apparently beat up and died during the training at the MSP. I don't know if this was there's another guy with a use of force that came up as well. I'm not sure exactly what this is referring to. Is this a misdirection? Look over here. Don't look at this other stuff. Maybe it's just, I don't know what, I don't know what the other stuff is. And this is, this would be a big, it's a big gamble because you can get caught with your pants down doing things like, inverting Celebort video and things going deleting and so forth. There's a risk you're going to get caught, and the magnitude of that risk is pretty high. You're gonna look really bad if they catch some of these shenanigans. So magnitude, high magnitude risk, you're going to have a pretty high payoff for that to be justified, to justify taking that risk on. Given, discovery process means it's available. Experts are going to be looking at stuff, means they're going to find clues. It's not like a completely low likelihood that it's going to happen. It's a decent likelihood when you're in court. People are going to investigate, and they're going to find your shenanigans, especially after that first trial when you sort of started playing your hand. There's something weird going on with this video over there at the Canton Police Department. So they would have to be hiding something big, in my view, for this to be a diversion. And I don't know what that is. Are there a bunch of unsolved murders in Canton that we don't know about that they would be covering for? I don't know. I don't know of any. Is it not don't look at Sandra Birchmore? That's out of their hands. The feds got that now. So there wouldn't really be any point here, because whatever's going to come out in that case is going to come out in that case. Maybe initially that's the thought process, but I don't know. The things aren't related. The only reason they're related is because we have the same actors seemingly committing a lot of the same mistakes, a lot of the same errors in judgment that just happen to establish that if you wear a badge, you're not going to get any shit because you're a cop too. That's what the common link seems to be. So I don't know that I think this is an effort to misdirect. I think it's just part of the same blue line club. It's just it's the same thing being manifested in different cases. That's kind of my take on it. V. Grave, did Jen McCabe contact the Alberts before finding John O'Keefe? I don't believe so. I don't believe so. She has, if I remember correctly, a phone call at 6:00 something to Nicole, but I believe it's like right in the time frame of when she makes the 911 call. So it's not from the car, like when they're on the way over or something like that. So I'm pretty sure it's after they found John. Before that, I don't believe she had any contact attempts with them. There was Nicole and Julie, I think, were the ones that had the communication. Julie had explained that it was her original story. It was like a 4 a.m. phone call. This is my recollection. Nicole called Julie at like 4 a.m. claimed it was a butt dial or something. And Julie had originally said, that's how I found out that John had died. That's in one of the reports, one of the early reports. But then that story got changed, and I guess maybe she never answered it or something. Can't remember exactly the details there. We'll find out in this trial. It's going to come out again. And so I don't believe Jen contacted any of them, but if they did, there will be people in the chat who know. And so I'm sure they will set me straight if there was something. My Mini 67, bloody Americans, 3 meters equals 10 feet. Yeah, I know. But hey, give us some credit. We got it all from the Brits, right? Don't even get me started when y'all over there in Britain use stone. Okay, what the hell is a stone? How many stones are things? I'm giving you guys a hard time. It's like 13 point something pounds a stone, I think. Ask me how I know. I know because of boxing, and it came up trying to keep track of Tyson Fury when he blew up and then lost weight and stuff like that. When they were talking about that, it was always in stone, and so I had to figure out, how do you do that conversion? So yeah, I found out he's like over 300 pounds. I don't remember what stone it was, but I know. I'm a fan of the metric system myself. I like it. It does make a lot of sense. But of course, I'm an American. I'm accustomed to our frames of reference, and we don't tend to think well in meters, except for very limited circumstances, like mostly sports. If you're a runner, 5K very well. You might know 10K. You might know those kinds of differences. 1,000 meters, 800 meters, etc. Same thing with swimming. You're a swimmer, you probably know those distances, even if you're an American. That Southern blonde lawyer. I use Signal with clients every day. Preference and practice area for encrypted confidentiality. It's smart. Also, everything goes back to high school. AJ and Daddy Wolfe were the cool, popular guys, and HB a loser. Still trying so hard. It's pathetic. Maybe it could be that simple. I think it's smart, honestly, for a lawyer to communicate using Signal. We see over and over again, one of the challenges that lawyers have with their communications always is dealing with people in jail, because that gets recorded a lot of the time. They're supposed to have ways to be able to sort out the attorney's phone and not record that. But they may or may not work. There have been situations, I've told stories before about how we're supposed to have that kind of system in Washington where your number's fed in. They exempt you from being recorded, but we find out they are still recording anyway. And some lawyer has his conversations with the defendant listened to, and it ends up in the case being dismissed because that's like clear prosecutorial misconduct to violate attorney-client privilege like that. You can't get around that with Signal. You can't signal into the jail. No way are they ever going to allow that. But for other communications, yeah, I might look at YSL and how they went after the defense lawyers there. Look at this case and how they're going after the defense lawyers. Shit flows downhill, and who's at the bottom of the status heap in a criminal defense courtroom? That's that defense lawyer. They are the easiest one to blame. They're the one that gets their finger, gets the finger pointed at them repeatedly. They're the ones that, if we're going around and throwing around accusations of unethical behavior, we're going to be very skeptical of that if you're talking about the prosecutor, but we're going to be suspicious of it if you're talking about the defense. These are the kind of biases that defense attorneys operate within every single day. And so, yeah, if I'm dealing with some lunatic that's going to maybe convince a judge that you should seize my phone and go through it and stuff like that, it would make a lot of sense to have all my confidential communications on Signal. I think that's really smart. I do. So kudos to you for having that practice. I think that's probably pretty forward looking, and wouldn't surprise me if we see more and more of that as time goes on, and as it becomes increasingly clear that our communications are not secure. Our phone communications are not secure. We already knew this. We already knew this back to Snowden. God, I don't even remember when that was. It feels like a million years ago. When did Edward Snowden do his big reveal? Was it like 10 years ago? Was it more? Trying to figure that out real quick. 2013. Yeah, 2013. We've known about this for a long time, that there is mass collection of Americans' phone data, communications, and things like that. But here we are still, talking on the phone like it's all private. Nobody's listening and it's normal. Guys, then if you want to go down a rabbit hole, look into Project Hurricane. Look into Project Hurricane. There's been some recent developments about Project Hurricane. because Senator Ron Wyden from over in Oregon got his teeth into it for a little bit and was kind of doing some investigation, released some information about this this program. And then Cato Institute got a hold of it and was doing some public records requests, and so some FOIAs. And so they ended up getting a Department of Justice Inspector General report that was updated in, I believe, March of this year about Hemisphere. I'm sorry, I'm saying hurricane, but it's Project Hemisphere. Look that up. Look that up. It's quite some interesting stuff. Basically, a mass collection by AT&T of user data. Why did this come up? Well, I got a little theory. It might have something to do with what Cy Ray was talking about over there in Boise. Don't know, but just a suspicion. So anyway, yeah, Project Hemisphere, Google that sometimes. We don't have privacy. It's like we're at the point where we should stop expecting privacy. And if that is in fact the case, then makes sense that attorneys should be moving off of that, because at some point it's no longer reasonable for you to expect your cell phone to be secure. And if it's not reasonable for you to expect it to be secure, then you're not taking reasonable steps to preserve confidentiality. Doing something like going on Signal for your client conversations would do a much better job of meeting that standard. Oh, what a day. I mean, we're 9.5 hours in. It doesn't feel like it's been that long. I feel like a lot has happened, but I'm at the same time now, I'm really looking forward tomorrow. I want to see Mr. Alessi. I want to see Mr. Alessi finish this cross of Mr. Whiffen. I love his style so far. He's eliciting facts. He's not arguing with the witness. He's not trying to get the witness to restate his theory to the jury, because that's what your closing is for. All you need now is the facts, and the facts, they will tell their own story. And if you do a good job of eliciting them, then the jury will already be able to follow the facts. They'll understand what the conclusion is. And when they can reach it themselves, it's far more persuasive and far more powerful than if you're trying to get them to adopt that down, just through argument. Always more powerful for them to come to the conclusion themselves. So just feed them the facts, let them sit on it, let it simmer. I find it extremely powerful. I really like the style. You don't get bogged down in the explaining and the wriggling and so forth. And he's got some good facts to work with, just from what we saw. Just from what we saw from Mr. Whiffen's testimony. Mr. Alessi hasn't even gotten to those 6:04 a.m. steps starting. Hasn't even gotten to that. There's a story in that phone, all right. So guys, with that, I'm going to go ahead and call it a day. Half a day of Ian Whiffen, half a day of the Crash Daddies. We await the ruling. We'll see what she has to say. Don't know when we'll get it. Other updates for today. Cert petition denied. Saw that come out. So we briefly talked about that. Otherwise, guys, we're just moving forward with new evidence tomorrow. Jen McCabe, being told, is on the horizon, but we'll see. We'll see if that pans out. So getting exciting, guys. This is some of the juicy stuff. We'll see if burying it here in week 2 in the middle, is that purposeful? Is that a deliberate strategy that Mr. Brennan is pursuing? Certainly, if the cell phone data presented the compelling science, facts, and data that establishes the Commonwealth's theory of the case, you'd probably lead with that, wouldn't you? That was what you told the jury in your opening statement your case was about. Can't help but notice you didn't. You led with I hit him, I hit him, I hit him, and now buried into the middle part of the trial. Second week, we're starting to get into some data. So if I wanted the jury to not remember this, that's probably how I'd structure it. Can't wait to see what Mr. Alessi does tomorrow. Thank you, guys. The wind has died down a little bit, so I am going to go out and check the trees, but I'm optimistic that they should be in pretty good shape. I also have to check and make sure nothing gets blown over. That's like the other downside that happens with a lot of wind. It dries out the trees, so a lot of water in the pot. You know, the soil is the academic clay. It holds water, holds nutrients and stuff very well. But when it dries out, all that water is gone, and so it's much lighter. And it's very easy for a little gust to get a hold of a tree, take it off the bench. I used to tie them down, but I stopped doing that because it tends to compress the soil too much on the top of the plant, and then I get compaction. I get issues with compaction and watering and stuff like that. So I don't tie them down. I kind of gamble with the wind. If the wind gets really high, I might take them off the bench and put them on the ground. But I have had a couple trees that I call them wind pruned. They were one thing. The wind took them off the bench and they became something else. It's just part of the story of the tree. Every bonsai tree has a story, and wind pruning is part of the story of some of mine. So I'm going to check that out. Spend some time with the dogs, spend some time with the chickens. I might even go box tonight. So yeah, just things to get caught up on, taking care of that old biological container. I'm still I don't laugh hysterically anymore when I think about it, but still highly entertained at what a kind of ridiculous thing that I said. So you guys do take care of yourselves. Enjoy some of your afternoon, some of your evening. Make sure that you're looking after what you need, both your body and your spirit. Very important to take a little time for ourselves. So with that, I will look forward to seeing you guys back for day 6, bright and early tomorrow. Thank you, everyone, for your support, for your great contributions to the chat. Thank you to the mods, everybody that is making this place the awesome place it is to take in this trial. Really couldn't do it without all of you. So thank you, and we'll see you all tomorrow.